All right, we'll go ahead and call the remand hearing back to order. The time is about 8:16. Before we get started, yesterday, I believe Mr. Owens had presented his final witness. Is that correct?
Get one more.
We have
Oh, that's right. We had Mr. Lee that was going to come up this morning, I believe. Is that right?
Yes, we have one more, and I'd like to recall Mr. Boss.
Okay.
From
Do you want to
AWW.
do Mr. Boss first?
Yes.
Okay. Before we do that, Mr. Staley, was there any concerns, issues, or anything you wanted to bring up before we got started this morning?
No, Madam Chair.
Okay, thank you. Mr. Owens, was there anything that we needed to address before you get started this morning?
No, thank you.
Okay, very good then.
Then I'm going to need the Elmo, and it doesn't seem responsive.
I've called security and asked them to come down and check it.
I was going to say the lights aren't on.
That happens around here.
Good thing we have an engineer in the house.
Lights not on, there's nobody home.
Perfect. All righty, go ahead, Mr. Owens.
Okay, municipality would like to recall Brian Boss.
Okay. Mr. Boss?
I'm sorry, Madam Chair. Mr. Owens, you need to speak directly into the mic. We're not picking you up.
Mr. Boss, could you please introduce yourself again for the record?
My name is Brian Boss, last name B-A-U-S, and I'm the Planning and Development Services Manager for the Anchorage Water Wastewater Utility.
And Mr. Boss, do you recognize that you're still under oath?
Yes, I do.
Okay, wonderful.
Go here, I guess. Okay.
Thank you. We've placed Exhibit A7 on the Elmo. The purpose of recalling Mr. Boss is just to revisit the questions that came up late yesterday afternoon about access to Pump Station 10 and what the implications of constructing the road on Pete's Place and the relation of that to the Road Improvement District has to the overall cost allocation for the Road Improvement District. So can you see the exhibit well enough, Mr. Boss?
Yes,
I can. And
I can.
You'll recall that yesterday there was some discussion about the fact that the Pump Station 10 required maintenance, and so there would be trucks and other equipment from AWW going down there and using the road to get there. And there's some discussion about that portion of the road that is within the Road Improvement District compared to the extension down Pete's Place to the pump station. Yesterday's testimony was that AWU paid for the extension of the road down through Pete's Place to the pump station.
I wasn't in the room when you guys had that discussion, but I have been briefed on it.
Yeah, and that the AWU did not participate and it was not a member participant in the Road Improvement District, and so did not contribute to the portion of the road from the beginning of the Road Improvement District down to where it intersected with Pete's Place, and AWU picked up the tab.
Correct, yeah. The Road Improvement District boundary ended at Pete's Place Lot 2, as well as the Water Improvement District boundary.
So could you briefly walk through the standard practices for developing adjacent property to subdivisions and the practices of the utility for extending water service and paying for participating in road improvement districts when it has to travel through a subdivision to get to its own property?
Sure. Couple of basic concepts that people have to be familiar with when you're talking about land use planning and orderly extension of the system. One basic concept is the idea of the benefit of frontage and the benefit of service. As properties extend infrastructure, their responsibility is to construct full frontage along their property line and nothing more. So, for example, this is Pete's Place Lot 2. Say there was no improvement districts weren't constructed. If Pete's Place Lot 2 wanted to get water, what they would have had to have done is construct water from wherever it was all the way to the end of their property boundary. And then likewise, if Pete's Place Lot 3 wanted water, they would have to take it to that point and construct it to the end of their property boundary. So there's two programs that allow developers to do that. There's the improvement district process and the private development process. An improvement district, when it's created, you have a series of petitions that come in from people that want service. The petitions don't make up the alignment of the improvement district boundary. Essentially what happens is those petitions come in and they come to people in the planning department for water and sewer. That's my department. For the roads, that's Department of Public Works, specifically Gary Jones's office, which used to be Jim Lampson. They take the petitions and they analyze land use regulations, they take a look at the overall developability of the area, and they draw a boundary of the benefit of service. So for us, for water, that was Pete's Place Lot 2, because we didn't envision water extending further. For the road, it was the same thing. At the time, there was no pump station plan down there. No one thought that there would be development down there. So they basically drew the boundary at Pete's Place Lot 2 thinking it wasn't likely you would get further development. They thought that would be the best chance to pass a district. So that's where the delineation of the line got built, and that's where the RID and the WID basically constructed the benefit of service. Everybody beyond there, if they want service, they would have to construct it through another means like private development or create another improvement district. And essentially what they would be doing is building a new project and new infrastructure. Pete's Place Lot 3 and the pump station, from a land use perspective, didn't really get a benefit from the improvement district because it didn't front their property. So essentially, just like they didn't have to pay for the construction of Northern Lights or any of the water and the sewer infrastructure within Northern Lights, they do use it. They get a practical benefit, but from land use perspective, everybody pays for what fronts their property, and that's how we apply land use rules consistently to developers.
So if we were to now consider extending participation or costs of the road improvement district down to the pump station, what would be the implications of that?
If I understand your question correctly, the improvement districts ended at Pete's Place Lot 2. When we came up with the idea to build the pump station down there, the pump station had to build the road, water, and sewer per standard land use philosophies, right? So it took the cost responsibility to build the road, water, and the sewer. And they would have done it using the regulations that govern private development. So they didn't necessarily have to enter into private development agreements because it was a municipal project, but they had to follow the same rules. So they paid for the water and the sewer that got to the pump station. As far as the standards of the infrastructure that was constructed, it was slightly modified because it wasn't an occupied structure. So they didn't have to build standard access and things like that. You didn't have to build a standard roadway because it wasn't a housing development or a fire department or a school. It was an unoccupied pump station that has temporary maintenance.
So what implications does that have to the nature of the road surface and the bed itself compared to that in the road improvement district?
It didn't have to follow your standard design criteria for a roadway. So you didn't have to build a standard width street, things like that. You didn't have, I don't believe you have sidewalk down there, things like that.
So, but there was cost associated with building that road?
Correct, and that cost went to the pump station project.
And so if it was unitized with the road improvement district, what might be the implications?
If you were to try to go in after the fact and unite the pump station with the road improvement district, you'd have a myriad of problems. One, you would have to address Lot 3 as well. Lot 3 was not benefited by the RID or any of the other improvement districts. So if you unilaterally wanted to include the pump station, you would also have to address Lot 3 in some way, shape, or form. The road that was built wasn't a standard road, so it wasn't built for an occupied structure, so you'd have an inequity there you would have to address. The road improvement district, the intent behind it was to build a road that could support a residential development, and you don't have that. Then on top of that, the money that AWW spent to build that road would somehow have to get shuttled back to the RID, and then you would have to balance the accounting. So it would create quite a bit of a complex problem.
Okay, does the panel have any questions about that?
They were my questions that spurred this conversation. So just to clarify then, so what you're saying is either by code or processes that have been developed for the municipality, the reason Lot 3 and the location of Pump Station 10, that lot, were not included initially in the RID is because the improvement district is because they don't have property that has frontage in that district.
What it is when we get the petitions in, the employees of the utility and public works draw the boundary line. And they're drawing it based on what they think is going to pass and what they think the future of development is. When they were speculating that boundary at the time, they excluded 3 and the pump station for some reason. I can speak to the water and sewer, and that's because we didn't think it would be developed down there. And we were going along the road section, and we knew what ballots we got in, so we basically just drew the boundary based on that. As far as the roadway, Jim Lamson set that boundary. I assume he did a similar thing, but I don't really know for sure.
And this boundary was obviously, so you get the petition from the citizens, then the boundary is set, then it goes to ballot.
Correct.
That's the process.
That is correct. And then after you get an approved ballot, it goes to the assembly. So if you take a look at the boundary from 2004 to 2007, there's not a lot of variation in it. We had to change it a bit for the Grumman replat and things like that. However, it stayed the same. It carried over in the Pete's Place area per the original boundary line.
And do you know if you were to change the district, would you have to go back to ballot for that? Do you know?
I think that's probably a question that you would have to analyze law to really come up with an answer for. My take would be you couldn't do it after the fact, because how would you've already built the improvements, right? So you've already invested the money. So if you tried to go back to ballot, why would if you went back to ballot, you've already spent the money. I mean, the whole point of the ballot is to get the commitment up front. If I were a property owner, I would vote no if it went back to ballot, because why would I pass it, you know?
Thank you.
Good morning, Mr. Boss. So, just so we're clear, the boundaries can be amended.
The boundaries can be amended, but they should be amended before construction at the creation ordinance. So typically in 2004 and 2007, if we were going to amend the boundary, that would have been the time to do it.
Okay, and certainly by that time, you knew you were building the pump station there.
Correct.
Okay, and so you knew that the pump station property was going to benefit from the road access going down to Pete's Place.
Yeah, in 2007, that was clear.
And, well, even before 2007. I mean, let's be honest with this panel.
Yeah.
That location for the pump station was being explored at least as early as 2004. At least, if not earlier.
I would say you're correct. It was being explored, but it wasn't a done deal by that time.
No, because of the litigation associated with who owned the property.
No. Even in the early stages of design, we were going over other alternatives to where we were not sure whether or not we were going to put the pump station down there. That didn't happen until after the first ballot got approved and we were in design of the project.
Okay, but still, you clearly knew before the second ballot got approved that was where the pump station was going to be.
You are correct. Yeah.
And so, again, before that second ballot got approved, you could have amended the district to include the pump station, correct?
Correct.
And you could have amended the district at the same time to include lot, is it 3 or 1? I can't.
3.
3, lot 3.
And if we did that, we would have had to allocate the costs differently per the standard land use planning rules, which we didn't do. So.
Yeah. And so then lot 3 would, I mean, because let's face it, lot 3 has road access, correct?
I don't believe so. That's probably a question for the planning and zoning department. Basically, if lot 3 were to try to draw a building permit right now, they would fall under the rules of AO 7884 and other land use planning rules. They would have to provide standard road, water, and sewer. I believe they would have to apply to use the access road and get that granted by a municipal official, probably planning and zoning.
Okay. Do you really think that there's any doubt that if they wanted to build on lot 3, that they wouldn't get permission to use that road?
I have a doubt, yeah. I mean, you never really know what happens when people draw building permits. It goes to review. What we think now is really just a snapshot in time, right? It's when they actually draw the building permit, that's when you're going to get the planners, and that's when you're going to get the engineers to look at it, and that's when they're going to apply the law and the rules at the time. And things change quite a bit, which is why you never really give anybody guarantees on hypothetical situations. You wait till they actually do the development.
I understand that, but we saw that the municipality issued permits for lots 10 and 11, even though the roads didn't go all the way past those lots at the time, correct?
Understandable, but that was a different time.
And so the road goes by lot 3, the water goes by lot 3, and that west trunk line or sewer line goes by lot 3, correct?
Correct. For the water line, they actually, when they connect, they'll have to pay an assessment that was estimated when we built the pump station. So they actually have to pay for that water line when they connect through a different process other than the improvement district process, but they still have to pay something for it related to the pump station project.
Not nearly the amount that the other homeowners are paying for water lines, correct?
Don't have the numbers in front of me. I would assume you are correct. Typically, the HB 380, it would be $1 per square foot. I don't know what the improvement district was, but I believe it was a lot more than that.
I want to say the water for each one of the improvement districts is in the $40,000 range.
Okay. It was equal assessment, so yeah, you're probably right. I can look. It was $29,760 for the water main line assessment.
Okay. And so the dollar per foot that they'd have to pay for lot 3 is nowhere near that, correct?
It would, It would probably be about $1 per square foot. I would assume that lot is probably about 10,000 square feet. So,
And again, they'd be able to hook up to the sewer, correct?
yes.
Okay, and would there be a charge for that or no? Just the hookup charge that any homeowner who's going to build on any of these lots would have to do?
They are connecting to the sewer that was built by the previous project to get to the pump station. So yes, they would have to pay an assessment for that, but that assessment might actually be zero. I'm not sure without actually looking at the records. But yes, they would have to pay through the different process other than the improvement district process.
And again, though, just so that the panel is clear, prior to reballoting this improvement district, AWWU was aware that it was going to build the pump station in that location, correct?
Correct.
And it was the utility's obligation to define the boundaries of the improvement district, correct?
Correct.
And it had the power to amend those boundaries and could have done so at that time.
Correct.
No further questions.
I do have one follow-up for you, Mr. Boss. Is there ever a time in which you're building a road or you're doing an improvement district that there's actually not frontage, but the district ends right here in that person at the end that doesn't have is actually assessed and has to pay in?
No, what would happen in that scenario is they would come to the planning department, they'd say, how do I connect? And we would tell them they either have to build a private development, or if they're the last lot served, they can apply for an extended connection, which basically means there's no development beyond them. We won't require the full build out of a big water main. We'll just let them do an extended connection. However, they would have to satisfy the assessment at the time, and that would probably mean paying the improvement district price.
So even though they're not part of the district, they would have to satisfy the assessment? Is that?
They would have to pay their fair share of construction, and that would either be by building infrastructure, or there would have to be, or there's a provision in tariff that will allow them to pay the adjacent assessment, but that's speaking only to water, and it's only if they're, quote, the last lot served.
Okay, and is it your belief then, since AWU constructed the road at their own cost, that they paid their fair share of construction in this scenario?
Yeah, yes. But the difference is that they didn't build a standard road when they built the pump station, right? We built a access road to a non-occupied building. So if we were to tear down the pump station and build a building like a fire station, a school, or something like that, we would have to upgrade that to a standard road.
Okay, let me ask this in a little different way. So considering if we were a lot owner at the very end, there was an improvement district that came in, we want to connect to that improvement district, there could be scenarios in which we would be required, in order to connect, to pay an equitable share of the improvement district, say, like a neighboring, somebody who's adjacent to us.
You would actually have to take it and build the infrastructure from the improvement district. Your contribution would be the construction of the facilities that gave you access. When you're talking about extended connections, it works a little bit differently to where you could pay into it, but then you also have to be the last lot served. For water, the pump station isn't because of lot 3. I believe it's the same for road 2. Which is why the pump station wasn't allowed to build an extended connection for water. They actually had to build a main down there. So, and that's what drew the assessment on lot 3.
Okay. Any redirect?
So the road improvement district wasn't an equal allocation that was based upon lot size, correct?
Correct.
And the lot size for where the pump station is, any idea?
32,681 square feet.
And most of these other lots, 10,000 square feet roughly? I mean, Pete's Place 2?
I don't have those numbers.
Okay. Even just looking at them, 10,000, some of those other ones on the water side might be bigger.
That would be my guess. I don't know what the average lot size is, but I'm guessing in this area, it's probably somewhere around 10,000 to 15,000.
So your lot was about 3 times the size, correct?
Correct.
And so the road improvement assessment per lot is roughly what?
It's access. There's a calculation associated with the road improvement district.
No, I mean, looking how are the lots being charged for the roads?
They
All right.
vary.
Certainly, they vary by lot size. So pick an average one.
I don't really think there's an average one. I mean, what I would do is refer you to Exhibit A in Exhibit B2 in your binders, and then if you look at Exhibit A within that, that's the role for the road improvement district. That's the allocation of cost per property.
Can you repeat that exhibit for us?
Sure, that's Exhibit B12.
Bravo 12.
So I'm looking at that exhibit, and I'm seeing estimated assessments for the road ranging from 30,000 to 40,000. Is that right?
I would say that's incorrect. I would say it goes higher than that. It's if you look at Marston Park, they have a $104,000 assessment. If you look at Laneri Park, it has a $373,000 assessment.
Okay, for some reason, my numbers don't match that. Why? What page are you looking at?
Oh, sorry about that. I'm on the wrong exhibit. So what I'm looking at is AR 2014-193. Those were the documents submitted to the Assembly for final approval after this hearing. That's basically the amended roll. And within that is Exhibit A.
You're looking at, say that again? Okay, I guess I was looking at B12. I shouldn't be looking at B12 then.
Let me try to find the exhibit. Let me try to find the exhibit in your guys' packet. Okay. Sorry, that was 2004 that I gave you. Let me try to find the 2014.
Could you repeat that, please?
He's trying to find the 2014 census.
What I'm trying to find is the exhibit in your packet that is the final assessment rolls submitted to the Assembly to approve after this hearing.
I think it's going to be G1.
It is. G1 is the 2014 proposed assessment roll for the RID.
So if we look at Exhibit G1, which is what's proposed assessment roll for the RID, and I don't want to look at Lineary Park because I don't know the square footage of that, but I think we talked about the fact that most of these lots are probably in the range of 10,000 square feet, and we can see that most of these lots are being assessed somewhere in the neighborhood of $90,000. There's a couple of them that are smaller, obviously. There's a couple of them that are larger. But the great bulk of them are in the $90,000 to $94,000 range. Do you see that?
I would say there's a range. The exhibit stands for itself. If you look through it and you take a look at the properties, you'll see the prices.
Certainly. And those prices vary based upon square footage, correct?
Correct.
And so these lots obviously all aren't the same size, but a number of them are roughly in the neighborhood of 10,000 square feet. You agreed with me on that, right? Most likely.
Yeah, correct.
And so if a 10,000 square foot lot has to pay $90,000, a 30,000 some square foot lot would have to pay $270,000.
Sure, just like Lineary Park.
Okay. And so if in fact AWWU had redrawn the boundary and included the pump station site in there at 30-some thousand square feet, it would have had to pay roughly $270,000.
No, what would have happened is you would have had to change what you built. So you would actually had to have modified the design, and it would increase the overall cost of the improvement district. So the numbers you see in there would have gone up across the board. So they probably would have been a lot higher.
Well,
you're right about the distribution, though.
I understand, sir, that you would have had to upgrade that short section of road from the end of Lot 2 to the pump station lot, right? You would have had to upgrade that to some degree.
Yes, it would have to be a standard road.
Okay. But you built it. You built it sufficient to handle heavy trucks, correct?
It's not about the weight. It's about the Title 21 requirements for what a road is. So a standard road has a standard width. It has sidewalks, things like that. That road can only support one vehicle at one time. A standard road obviously can support two, one going one way, the other going the other direction.
So then, if I'm understanding correctly, this drawing isn't accurate in the sense that the road actually narrows at the end of Pete's 2 as it goes to the pump station.
Yes, it's not you don't have a full width of a roadway like you do down in this area. And I could be speaking out of turn there because I don't have the plans in front of me and I haven't reviewed them for quite some time, but I believe that is correct, that's just a access for our trucks.
Okay, so you don't even know as you sit here today whether it's the same width or not.
I'm certain that it's a smaller width, but yes, you're right. I would have to look at the plans to confirm that for sure.
But the incremental cost, even if it is slightly narrower, the incremental cost to widen that.
You're talking to the wrong guy there.
Okay. Again, though, the incremental cost is not likely to be much compared, and pump station, again, would have to bear its proportionate share, given its lot size, for that incremental increase, correct?
I think you're speculating about cost and you're generalizing. As far as the separation, yes, it would be driven by an area calculation the same way it was calculated with the rest of the district.
Okay, so again, just assuming the cost that we have now, if AWWU had properly included the pump station, amended the district and included the pump station lot sometime before the reballot in 2007, based upon the costs that we have now, we don't know what those new costs would be, but based upon the costs we have now, it would be sharing in the road improvement cost to roughly to the tune of $270,000.
No, I wouldn't try to speculate a dollar value. I mean, you would have to actually go through the engineering and do all that. You're right, there would be an area calculation, and you would have to apply the standard methodologies for the improvement district process.
And it would be roughly 3 times or more the amount paid by a 10,000 square foot lot.
It would be whatever. In general, I think you're correct, but without actually knowing what those area calculations are, you would have to run the numbers and do the math.
No further questions.
Just one follow-up. As far as extending the road improvement district down to include the pump station, that would impact Lot 3 as well, wouldn't it?
Correct.
And you can't compel participation. They'd have to be offered the opportunity, given an opportunity to vote. It would have changed the whole balloting process.
Correct. And if we were to have done it at the time, that's what we would have had to have done, is we would have had to include them in the 2007 ballot, as well as the pump station property, which actually didn't really exist then.
Okay, thank you.
Okay, Mr. Boss, I'm taking a third bite at the apple here.
Okay.
So, hypothetically, we come to the end of a road. There's 2 parcels right next to each other. Both of them abut the end of the road. If I wanted to hitch into this road, I would potentially have to pay my fair share of the improvements of that area. And then if I had infrastructure that needed to be developed to get to my lot, I would be responsible for that as well.
No. So you would only have to contribute what fronts your property. You would have to pay for whatever infrastructure you needed to get there. So in your example of the 2 fingers, if the improvements ended at my right index finger, I would have to build the improvements to this index finger, and that would be my contribution. I wouldn't have to pay for anything associated with where my face or nose is. It's already been paid for by someone else.
Is that only for the road, or would that be for
Road, water, and sewer. Oh, I can speak as an expert on the road, on the water and the sewer. I'm pretty sure the road works the same way. So.
Any question from council members? No. Any question from either council?
No questions.
Okay.
Only the observation that I think that was the best illustration we've had.
With my nose, you like my nose?
I'm very visual.
We'll see how that's going to do it.
It'll read great in the record.
Yeah, I was going to say. Okay, thank you. Mr. Owens, you can continue.
Thank you. Okay, Scott.
If you want it.
Mr. Lee, would you please state your first name and your last name? Spell your last name for us.
My name is Scott Lee. Last name is Lee, L-E-E.
All right, and if you'll go ahead and face the municipal clerk, she'll go ahead and swear you in.
Thank you. Do you solemnly and sincerely swear or affirm that the answers you will give to the questions asked of you in these proceedings will be true?
Yes, I do.
Good morning, Mr. Lee.
Good morning.
Could you tell us where you're employed?
I work for internal audit department of municipality of Anchorage.
And what is your position with the internal audit department of the municipality?
I am senior auditor for our department.
And how long have you been a senior auditor?
I've been since 2007, so a little bit over 7 years now.
And were you employed with the municipality before that?
Yes, I was.
As an auditor still?
No, I was with the Treasury Division
How long have you worked for the municipality?
since 2005.
Okay. And did you perform a review of the costs and expenditures included in the Turnagain LID, WID, and RID?
Yes, I have.
And did you prepare a report of your review of those
Yes, I
financial
did.
records? Could you the witness binder?
On the floor.
You'll find inside that binder there are tabs. Please refer to tab G and the document number 5 within that tab. Is that the report that you prepared?
Yes, it is.
And when did you write that report?
I prepared this report August 11th of 2014.
And what was the purpose or objective of your review?
Objective of this review was to determine whether the cost charged to each assessment role, LID, WID, and RID was appropriate and accurate.
And how did you perform that review?
First, I obtained the cost entered to the municipality's financial system. I also obtained a copy of actual physical invoices in both physical form and on the hard drive. And I reviewed and matched those costs or the invoice related to each assessment. Also reviewed the invoice to determine the nature of the invoice.
Is the panel able to understand well enough? I'm happy to try to paraphrase.
No, I can. It'd be helpful if you spoke into the microphone.
Into the microphone a little bit more, Scott. So you obtained a printout from accounting department of the expenditures for the programs,
Correct.
and then you obtained physical invoices that backed up those reports from the accounting software,
It was provided by you.
and then you compared the two,
Correct.
and you compared the information on the invoices as to what they were and what they were for, and compared that for accuracy to what was put into the computer?
Correct.
Okay. Did you review wages or benefits that were charged to the program?
No, I did not.
Did you review charges relating to the Pump Station 10 project?
No, I did not.
And when did you do your work?
I performed my review in June of 2013. I presented my initial finding to you for WID and LID. Then I did perform the review and provided my initial report to you on August of 2013.
Okay. And what did you find at that time?
We found some charges were misapplied and some charges were omitted to each assessment role.
And did you identify those charges that had been misapplied or omitted?
Yes, I did.
And were you able to discuss those findings with people at AWWU?
Yes, I did.
And did you discuss them as well with people at Public Works?
Yes, I did.
When did these meetings occur?
The first meeting occurred on December 2013. And January of 2014, we met with the staff from AU and the PM&E, and they presented what proposed the resolution to correct those errors. We met again in February of 2014 to have further discussion. Then March 2013, I was presented with journal entries to correct those errors. And I reviewed and I determined that was correct.
Now, does your report detail the omissions and the mistakes that you discovered as well as the recommended corrections?
Yes, I did. Yes.
All of that information is in your report.
Yes.
Did you find any expenses that had been allocated to the improvement districts that really belonged with the pump station?
I found only one of such entry, which was about $6,000 professional service invoice. That was for pump station 10, and that was applied to WID.
Was that a VEI invoice?
I believe so.
And what did you recommend be done with that one? Was it transferred out of the improvement district and back to the pump station?
Yes.
Did the AWU water utility, Anchorage Water and Wastewater Utility, implement your recommendations accurately?
Yes, when I reviewed their journal entry, performed in March of 2014, those remedy was implemented.
And similarly, did Public Works implement your recommendations?
Correct.
And have you reviewed the final project costs as maintained in the records today? The totals and the conclusion as to the overall total cost for the water improvement district?
When I reviewed those journal entry in March, yes, I did.
And the same for the sewer improvement district?
Correct.
And the road improvement district?
Correct.
And do you believe all three of those projects are now accurate and reliable?
Correct.
I don't have any other questions. Thank you.
Good morning, Mr. Lee. My name is Mike Staley, and you and I have never spoken before, have we?
No.
Okay. First of all, we heard testimony previously that AWU worked with the contractors like VEI to tell them how to bill for these projects. What sort of codes to put in there for the different schedules or the different projects and the different aspects of it. So if VEI submitted an invoice and it said that it was submitting this invoice for the LID, then all you did was look at it and say, did that actually get charged to the LID, right?
That is correct.
So if in fact the work that was being done was really for pump station 10, but it was coded LID, you wouldn't know that.
That is correct.
So there was no audit done of that.
No.
With regard to the RID, you indicated that you found costs that were charged to the RID that belonged to Lineary Park in the tune of $19,000 some odd dollars, correct?
That is correct.
And what were those?
I believe those had to do with some. Let me look at my report here. I believe that was just some park layout design and landscaping.
Okay. And what was the funding source for Lineary Park? Do you know?
I do not know.
And can you take a look at G4? It's going to be tab G, and then within tab G, you'll have to find the green sheet that is number 4.
Okay.
I don't know if you've seen this before or not, have you?
I have not seen this before.
Okay. You can see at the top it's got total scheduled G payments, total scheduled G payments related to change orders, so total payments related to scheduled G. It then says out of that 56,000, 13,000 they're claiming was not related to the RID, correct?
Correct.
And that 42,000 was related to the RID, correct?
Correct.
Then a little bit further down, they say that there were some design payments related to Lineary Park. And those design payments were $6,000, correct?
Correct.
They applied just sort of a mathematical formula to say that 4,500 roughly should be charged to the RID, correct?
Correct.
And so and then allocate to the RID slightly more than $47,000 of the Lineary Park work to the RID, correct?
Yes.
And you haven't done any kind of audit to determine whether or not that was appropriate or whether or not that should have been paid for by some other funding source?
No, I have not.
No further questions.
Are there any questions, Mr. Owens?
The principal follow-up is that if you're looking at Exhibit G4, the top section is entitled Lineary Adjustments. Is that right?
Correct.
Is there anything on here that indicates that this is that the total funding for Lineary Park? This is referring to the adjustments made to the allocation to Lineary Park?
Could you repeat your question?
Actually, you don't really know what this document is, do you?
No, I do not.
Okay, never mind. Thank you very much.
Thank you. Any follow-up, Mr. Staley? Any questions from council members? Okay. Thank you, Mr. Lee. Mr. Owens?
That concludes the witnesses for the municipality. Thank you.
All right. With that, we will take a 10-minute break, and then, Mr. Staley, you will be up to call your first witness.
And the first witness is going to be by videotape, and so I'm going to have to try and figure out how I set this laptop up to play the videotape
Okay.
deposition.
The clerk can assist you. So we'll take a 10-minute break, and hopefully that'll be enough time. If not, we can wait till we get it working. All right. We'll go ahead and get started again. Mr. Staley, you, sir, are up with your first witness.
Thank you, Madam Chair.
If you could, just for the record, in case somebody's reviewing these records on transcript later down the road, could you restate for on the record what you discussed with the panel with Mr. Owens present during the break?
Certainly, and that's the fact that the first witness is Cliff Hitchens. When we rescheduled this, we rescheduled it for a time when he was going to be out of state, so we videotaped his deposition. There are a variety of exhibits that he looked at in the deposition. The numbering for the deposition exhibits is not coextensive or identical to the numbering for the pre-hearing or these hearing exhibits. And so the deposition exhibits are contained within hearing exhibits numbers 76 and 105. The deposition itself will refer to the various emails and letters, et cetera, by date, but you won't be able to necessarily follow along by number.
Thank you, sir. Please proceed.
And so I'm just going to hit play, and if you can't hear it or something like that, let me know.
state their appearances for the record.
Michael Staley here on behalf of the appellants.
And Robert Owens on behalf of the municipality of Anchorage.
You may swear in the witness.
Would you raise your right hand, please? Do you solemnly swear that your testimony in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I will. Good afternoon, Mr. Hitchens. We're here today because you at one time owned a property at 2219 West Marston Drive. Is that correct?
That's correct.
And that is was included as a part of an improvement district, and it has certain assessments that were levied against that property. Is that correct?
That's correct. Road district.
Yeah. And it was your understanding that you had reached some sort of a compromise agreement with the municipality regarding the amount of those assessments. Is that, am I correct?
You're right. I had a meeting with a number of people from the municipality, including Jim Lanson and Jerry Hansen. Jim Lanson and Jerry Hansen, that's correct. And some members of the assembly.
Okay. And you had an understanding that that was to be presented before the whole assembly, and apparently it didn't happen, although you didn't have notice of the assembly meeting where that was to occur. Is that
well, by that time I'd actually sold the house at 2219 West Marston Drive, and I didn't get any more notifications. But correct, we did. We were informed that the assembly meeting was going to be happening sometime, I believe, in August, and there was a continuance of that meeting because it ran over time. And then the next meeting that they arranged to have this, there wasn't a quorum. So that got cancelled, and then I lost all contact.
okay? And the reason why we're here today is because you understand that we're to have a hearing on these assessments in early December, but you're going to be out of state.
That's correct.
Okay. Let me get a little bit of background information from you before we get into the detail. When was it that you moved to Alaska for the first time?
Well, I was here in 1974. I came up here on a contract with my company that I was working with out of Chicago, and the particular project I was working on came to full fruition sometime in November after a vote. So I actually, myself and my wife, we moved here permanently in 1978 and had a home here ever since.
Okay, and what is it that you did for a living while you were here in Alaska?
I'm a construction cost estimator.
Okay. And are you still employed? Are you retired?
I'm retired. I've been retired for 10 years. 1980, I formed my own company, and for 25 years we involved ourselves in projects throughout the state, working for the municipality of Anchorage, the state of Alaska, various federal organizations, BP, ARCO, and architects and engineers throughout the state.
Okay. And you retired approximately 10 years ago?
Exactly 10 years ago.
Okay. And do you still maintain a home here in Alaska?
Certainly do.
And is this still your
This is my home.
This is your home. Okay. Thank you very much. And so the home on Marston Drive, 2219, do you recall approximately when you bought that?
Yeah, in summer of 1993.
Okay. And at the time you bought it, was it a vacant lot or was there a house there?
There was a house there with utilities, road access, everything you could hope to buy was there. I never considered there being anything other than a fully developed site.
Okay. And were you taxed on it?
Taxed continuously the full amount for a fully developed location. I never questioned it once.
Okay. Yeah. I think the record will show that in or around 2003, certain property owners in that vicinity who had vacant land that was not developed had petitioned the municipality to create an improvement district. Are you familiar with that?
Yeah, I do know that, yes.
Okay. And were you given an opportunity to vote on whether or not you wanted that to happen or not?
Yes, I was.
And did you want it to happen? Did you not want it to happen?
Absolutely not. We had a number of votes on it, and we continued, my wife and I did it, and I continuously voted no.
Okay.
And even when there was a bond issue, we voted no.
So when there was actually a bond issue that was put before the voters of the municipality to determine whether or not bonds should be issued to pay for various roads, which included this road and others, you voted against that.
Exactly right.
Okay.
Exhibit 33.
The court reporter has handed you what's been marked as Exhibit 33, and what is that?
Well, it's a letter from me and my wife to it's the Anchorage Water and Wastewater Utility. The reason we sent it to them was because the only communications we got on this improvement was through that organization. And at that time, I hadn't realized that the RID development should have gone to Jim Lamson. But anyway, we sent him a letter saying that we didn't want to be part of this, and we do not benefit in any way, shape, or form.
Okay.
By these so-called improvements.
Okay. And so this letter of October 23, 2003 is at least the first written correspondence that I've seen where you've let somebody at the municipality know that you didn't feel that your home at 2219 West Marston Drive should be included in this because there was going to be no benefit to you resulting from these improvements.
That's correct.
Do you recall if you ever got a response from that?
No response.
Handed you what's been marked as Exhibit 34, and is that also a letter that you prepared?
Correct.
Okay, and you'll see on the upper right-hand side there's a date of March 8, and I believe it's 2007, although it's hard to read, but you can see there's a received stamp dating May 31, 2007, that somebody at AWWU stamped on there.
Yes.
Okay. And again, I take it that you were writing to them to let them know that you felt that your property at 2219 Marston Drive had been improperly included in the improvements.
Yes, and I pointed out that my earlier letter had been ignored. Having not heard from them, I assumed that I could happily go around thinking that I was not going to be included in this improvement district because it was an error to be included, for us to be included in the first place.
Okay. And let me ask you, Mr. Hitchens, I mean, you indicated that you voted against this improvement district, but what did you feel about this? I mean, did you feel like this was going to improve your property, or?
Well, certainly not. I had a beautiful location. It was rural behind me. There was nothing but moose. I had full access. It was delightful and quiet. No traffic or motorbikes going past me at midnight at 100 miles an hour and screeching down the road. It was idyllic.
Okay. As a result of the fact that it appeared as though, well, you understood that more than 50% of the people that had been asked to vote on this had basically voted to go forward with the project.
Yes, I understood they wanted the road to nowhere.
Okay. And as a result of the fact that it looked as though this project was going to, in fact, take place, did you make any decisions with regard to your property at 2219 Marston Drive?
Oh, yeah, that's about the time when we decided we needed to move because it was we were used to it being there as it was, and the idea of having the road punched through there was something that, frankly, we just didn't want to have. The quality of life for that particular location was completely eradicated as far as we were concerned.
Okay. And again, in this letter, which has been marked as Exhibit 34, you point out that, in fact, from your perspective at least, this project is going to reduce the value of your property, and that you're not going to receive any benefit from it, and you're requesting that you be removed.
Correct.
Bob, the next one.
For the record, I got no response to this letter either.
Okay. So the court reporter is handing you what's been marked as Exhibit 35. And this is another letter that you then drafted to the municipality. And this one dated May 27, 2007, so some
80 days
80
later.
days later. And indeed, in this letter, what do you point out to the municipality?
That I didn't get any response to my earlier letters, and I assume, therefore, that they must agree with my point, and we should be removed from the improvement district charges.
Okay, so at this point, you had written, this is your third letter now, and nobody had even given you the courtesy of contacting you or talking to you about this point that you're making, that is that you've had a fully developed lot, road access, water, sewer, a home. You had been living there for some 14, 15 years, and you didn't feel that you should be included in the district, and yet they aren't even responding to your inquiry.
I had no response.
Number 36.
Find that one.
Has handed you what's been marked as Exhibit 36, which appears to be an email from an Andy Underwood to Jim Lamson, Gary Jones, Russ Oswald, and Bruce Robson. And it says, attached is a letter I received this morning from Cliff Hitchens, and it appears to reference the letter we just looked at, which was marked as Exhibit 35. If you look at 35, you can see that it's got the received stamp of May 31, 2007, the same date as this email, and indeed the copy of your letter, which has been marked as Exhibit 35, has Andy Underwood's name highlighted on it. And so it appears as though at this point, Mr. Underwood has forwarded this on to Mr. Lamson and asked Mr. Lamson to contact you.
That's exactly what this says here.
Okay. And in fact, you did have at some point subsequent to this then conversations with Mr. Lamson.
I did indeed.
Okay.
Mostly as a result of my two representatives on the assembly. Harriet Drummond, who was the representative, the assembly member for the Marston Drive property, and I then moved no, I haven't, sorry. Yeah, well, actually, by the time I actually spoke to Mr. Underwood, I'd actually moved to East Anchorage, and so Sheila Selkrid helped us. And it was the efforts of those two assembly people that got me a meeting with Mr. Lamson.
Okay. And at this point, you had made the decision to market your home, is that correct?
Correct.
And in 2007, if I recall correctly, that was before this big financial collapse. I mean, things were going well in the real estate market at that point.
Well, the collapse happened at the end of 2008.
Right.
So yes, the answer to your question is correct. Oh, yes.
Is it 38 or 37?
Oh, 30. I'm sorry.
Okay.
just handed you Exhibit 37, which is a letter from a real estate agent addressed to you and your wife. Is that correct?
That's correct.
So just tell me generally, you had been marketing your home for sale. As I recall, I mean, it was basically a seller's market at that time before the collapse. How was the marketing of your home going?
Not very well. We had it for sale soon after, about this, I guess, the beginning of summer. I don't remember the exact dates. And Janelle Fliger is a very, very good real estate person and capable of selling. And every time someone came to look at the house, they were very keen on it until they heard about the dark cloud of this RID and all the road being punched through, and they lost interest. And I asked her about the whole question of this. I said, in the point of view of the fact that everyone else around me was selling their homes and yet I couldn't, and she wrote this letter.
Okay, so she was kind of responding to your inquiry about why is my home not selling, and she points out the fact that she's made an extensive effort advertising, shown the house a number of times.
Yeah, virtual tours and all that, everything.
Okay.
Did everything within, her tremendous expertise in trying to sell this house.
Okay. And that it was her opinion that the reason why your home was having a hard time selling was because of the unknowns associated both with the expense of the road as well as the unknown impact on the property in the setting.
That's what she says.
Ultimately, you sold the home.
Correct.
And I want to say that I think you sold it sometime in spring of 2008. Does that sound right?
That sounds right, yes.
Okay. And in order to get the home sold, did you have to agree to something with regard to the assessments?
Well, certainly. First of all, the price had dropped quite a lot. I couldn't get the price we were expecting, and the appraiser had made it valued it at. But then when we came to the actual sale, and the people knew that we were having a hard time sale, so they played hardball with us and said, look, we're not prepared to pay or be in part of this RID district. If we take this on, Mr. Hitchens, you have got to take responsibility for those eventual costs, if there are any. So to that end, we had to put into an escrow account I think it was $80,000, and it still sits there today, waiting to be the outcome of this decision.
Okay. And so again, just so that I understand, so you had, prior to listing your home for sale, you had a real estate agent give you an evaluation of the home in terms of what it should sell for based upon comparable homes in the area.
Yes.
And you were not able to sell it for that. In fact, you ended up having to reduce the price below what they thought it should sell for.
Correct.
And then when you did eventually get an offer, essentially you had to reduce it further still by the unknown amount of the assessments.
That's correct.
So the assessments actually decreased the value of the property in not only your eyes, but the eyes of the people that bought the property from you.
Well, that's exactly right.
And that's essentially what you had been telling the municipality all along, was that you shouldn't be included in this because this doesn't benefit your property. In fact, it hurts it.
That's my point of view.
This is Exhibit 38.
Okay.
Richards, the court reporter has handed you what's been marked as Exhibit 38, and this is a series of emails, the earliest of which is on the bottom of the first page and continues on to the second page, and it's an email from you to Mr. Lamson, dated May 27, 2009, CC'd to Harriet Drummond and Sheila Selcraig. And again, you're reiterating to Mr. Lamson, you're concerned that, you've got a unique property here that has had it has had road access the entire time, it's had a home there, fully developed, fully taxed for all of these years, and that you were going to receive no benefit. And indeed, on the second page, you say that, that you attached the letter from the real estate agent saying that, in fact, the road was a detriment to the value of the house. Is that correct?
That's exactly what this all says.
And Mr. Lamson responds to you that same day, saying that he is planning to set up a following meeting with the key players, he says. Is that correct?
Yes.
And then at the top of this Exhibit 38 is Mr. Lamson's email to Sheila Selcraig and Harriet Drummond, CC'd to you, indicating that he was going to try and set up a meeting for the next month, meaning the first half of July.
Correct.
Okay. And in fact, you had a meeting with Harriet Drummond, Sheila Selcraig, and Mr. Lamson in July, early July.
Yeah, and others. Jerry Hansen was there, and I think maybe some of the members from AWW were there too, but I can't remember who they were.
Okay. Handed you what's been marked as Exhibit 39, which appears to be a memo from Mr. Lamson saying that he has scheduled a tentative meeting for July 8th, 2009, and you're shown as being one of the required attendees, together with other people that you've mentioned. He indicates that he's setting up this meeting at the request of Assembly members. He's asked that Acting Mayor Clayman be invited to the meeting, since he'll be back on the Assembly at the time of the meeting, and that the purpose of the meeting is the merits of and process for removing your property from the assessment rolls.
That's exactly correct.
And indeed, that has been essentially what you had been claiming all along, is that your property should be excluded from the rolls.
Yeah, and that's what Mr. Lamson says in the last paragraph, that I have constantly presented to believe that there was no benefit.
Handed you what's been marked as Exhibit number 40. It's a 3-page document. The front page is difficult to read, but it appears to be dated July 6, 2008 at the top.
Yes.
If you look at the fax line on the second page, you can see that, in fact, that's the fax date, July 6, 2008. And this appears to be perhaps notes that you prepared for the meeting. Is that correct?
Yes, it looks like just that.
Okay.
It is that.
And again, you reiterate to them that you had a fully developed lot, it had been fully taxed for almost 30 years, that in fact, your own experience and your own belief and your own experience when you were trying to sell the home was that not only did this not improve the value of your home, but it was actually a detriment to your home. And again, you're asking to be released from the proposed assessments. Is that correct?
That's correct.
And you've let them know that while you sold the home, that in fact you had to escrow money to take care of any potential assessments.
Yes.
So in fact, the purchase price had to be decreased, if you will, by the amount of the assessments.
That's exactly.
So rather than adding value to your home, again, it took away from your home.
Once again, it took away the value for me, for myself and my wife. Excuse me.
Exhibit 41.
Okay.
The court reporter has handed you what's been marked as Exhibit 41, and this just appears to be the meeting agenda, if you will, for the meeting that you had on July 6, 2009 regarding your home at 2219 Marston Drive and your request to have the home removed from the improvement district.
That's correct. This is the agenda.
Okay, and number 3 on the agenda is the process for removal or amendment of the assessment amount. Is that correct?
That's correct.
All right. And indeed, you indicated that you had that meeting, and can you tell me as best as you recall what was discussed in the meeting?
Yes. As you see at the bottom, there's a note about photos. Discussion of the site. Mr. Lampson, although he knew the area, had looked earlier on at some old maps from what he said, some old maps, some old aerial photos that actually didn't show my house. I don't know how old those drawings were. So based on that, it appears that he made the determination, because apparently it was just Jim Lampson makes the determination who gets assessed. And he made the determination that our site should be assessed. Well, when we were at the meeting, new photos came out, new aerial photos and drawings. And he could see that our property, and he could see it was there for the first time, I think. I don't know that for sure, but it appears from what he said, it was that he saw that and said, there's a case here. He did also point out that to Mr. Hanson, Jerry Hanson, that perhaps they should reconsider it. And as a result of discussions with everyone going on there, the final agreement at the end of that meeting was that we should be withdrawn from the full charge. But like our neighbors to our south, we should be charged for a frontage. And as a compromise position, we accepted that.
Okay, so your neighbors of the south, they were the McLeods.
Okay, I don't know.
Okay. And
it's a rented area, so.
And you understood that the McLeods had also been originally included in the improvement district and some accommodation had been made for them?
Apparently, yes.
Okay, and the accommodation was essentially they were assessed a reduced amount just for curbing or something like that?
It's essentially curbing, but they call it frontage. That's the phraseology they used.
Okay.
And it was $32 a linear foot. And I think our length was longer than theirs, so it was a greater charge, which under the circumstances we said, well, okay, we can live with that.
Okay.
Yeah, it's better than going through all this. But that didn't happen.
Exhibit 42.
Thank you.
The court reporter is handing you what's been marked as Exhibit 42, and this appears to be a memo that Mr. Lamson wrote following that meeting, where indeed he states that that there was a meeting held on July 6th, and in the first paragraph he talks about the fact that assessments are supposed to be proportionate to the benefits received.
Yes.
And in the second paragraph, he talks about the fact that, indeed, in this case, you felt that there had been no benefit. In fact, there was an adverse impact, and he said the code, frankly, just doesn't even address that.
Yes, he does say that. That was interesting. I didn't know that.
Okay. And then in the third paragraph, he talks about the equity adjustment that had been done for Lot 11. That would have been the house to the south of you since you were Lot 10.
Yes.
And that they were going to be assessed a lesser amount, just $1,815.81 to install curbing. And that he had been asked, he says in the next paragraph, the fourth paragraph down, he says, we've been asked to calculate the assessment on the Hitchens property using the same approach. And then he goes on to say that he has since done that the lot frontage on Lot 10 is 83 feet, and that indeed, you recalled correctly, the price per linear foot for the curbing was $32 per linear foot, so that the assessment for your lot would be $2,656.
That's what it says here, yes.
Okay. And was it your understanding then that basically was that at the end of that meeting, that there has basically been an agreement that you would be assessed the same as Lot 11, and that Mr. Lamson was to calculate what that was to be, the amount that was going to be?
My understanding was that he was going, further than that, he was going to take this to the Assembly at the meeting we mentioned earlier, and it was going to come to a vote at his recommendation that we pay this. That was my understanding.
Handed you what's been marked as Exhibit 43, and again, this appears to be a series of emails, the earliest of which is at the bottom of the first page and continues on to the second page. And that appears to be essentially Mr. Lamson's memo that we had previously seen marked as Exhibit 42, and he essentially is now emailing that memo to Sheila Selcraig, Harriet Drummond, and yourself, with a CC to Jerry Hansen, Matt Clayman, Russ Oswald, and Gary Jones, again responding to this request that he calculate what the curbing cost would be for your home at 2219.
That's correct, and I think in the middle there I've accepted the proposal.
Okay, and so that's the middle email is from you back to all those same recipients saying that you'll agree to that. And then at the top is an email from Sheila Selcraig to all the same recipients again, saying that it's her understanding that Harriet Drummond and Jim Lanson will take the lead in working with you to finalize this agreement. Is that correct?
Correct.
Okay, and so again, it was your understanding that basically you had reached an agreement that you would be assessed curbing. Mr. Lamson calculated what that amount would be. You said you're in agreement with that, and there was an understanding that documents would be prepared and presented to the Assembly.
That's correct.
Okay. Handed you what's been marked as Exhibit 44, and again, it's a couple of emails, the bottom of which, the one on the bottom of the first page continuing on to the second page is the earliest one. And this is an email from your wife, CC'd to you, sent to Mayor Sullivan and Larry Baker, and dated June 25th, 2012. And again, this sort of is just reciting the history of what you've gone through trying to resolve this. Is that
correct? Diddy had met the mayor and Larry and had the discussion, and he asked her to send a memo, letter, email detailing what the story is.
Okay, and again, again, the reason why I'm showing you this is your wife, Ms. Hitchens, is not only does she talk about the fact that you had this meeting on July 6, 2009, where you had reached an understanding that you'd be assessed for curbing, but she talks about the fact that it was supposed to go in front of the Assembly on August 11, 2009, and why that didn't happen, and that she was then told that it would be heard in 2010. Is that correct?
Yes.
Okay, so that was your understanding, that it didn't happen in August of 2009 like you had anticipated, but it was supposed to happen at some point when the entire matter went before the Assembly to calculate the amount of the assessments.
And we would have been there to help present this, but we never did this.
Okay, and in fact, were you even aware that in 2011 the municipality, the Assembly, had a hearing wherein they considered the assessments and made an initial decision?
No, we fell between the cracks. Well, first of all, we were caught in the net of this thing, and now we fell between the cracks because we no longer owned that property, and that all those notices went to the current property owner, who didn't bother to pass it on to us. And I think the only assembly member there was Harriet Drummond, and she neglected to forward that to inform us of the situation. Otherwise, we would have been there. It was just one of those things we just did not know it was happening.
Okay. Do you remember the name of the people that you sold the property to?
Is Mr. Dexter. And his wife, she has a different name.
Exhibit 45.
The court reporter has handed you what's been marked as Exhibit 45, and I'll represent to you, sir, that indeed the municipality sent out a notice to potentially impacted homeowners about the fact that the Assembly was going to hold a meeting in 2011 to consider these assessments, and you'll see that they sent them out by certified mail requiring a signature. And the top copy of the green card, if you will, is addressed to David Dexter and Mary Lisa Pisani. And that's the people that you sold your home to. Is
That's
that correct?
correct, yes.
And indeed, it shows the address of 2219 Marston Drive.
Yeah, there you go.
But in fact, you had already informed the municipality that you had to escrow the money for this. It was your money that was at stake, not...
There's documentation.
Yeah, okay. And so you just didn't get notice of the meeting, didn't have an opportunity to follow up and say, hey, we had this agreement, and so it fell through the cracks.
That's correct.
Exhibit 46.
The court reporter is handing you what's been marked as Exhibit 46, and I'll represent you, sir, that this is the document that the municipality prepared showing the amount that various lots were going to be assessed for the improvement districts. If you'll turn to the last page of this document, concerns the RID, or the Road Improvement District, and you understood that that your property had been included in the Road Improvement District. Is that correct?
That's correct.
And it shows, again, it shows the fact that the municipality has ignored the fact that you've informed them that you've escrowed the money and that it's your money that's at stake, and they have listed Mr. Dexter and Ms. Pisani with regard to the home at 2219 2219 Marston, which is Block B, Lot 10. Do you see that?
Simonson Estates, correct.
Okay, and again, you'll see that the amount of the assessment for the road is $78,512.06 or 8 cents.
I think it's 8.
Yeah, okay.
I'm not worried about that.
And again, that's not consistent with your understanding in terms of the agreement that you had reached. Is that correct?
That's exactly correct.
Right. And with regard to your neighbors, Lot 11, the McLeods, you can see that in fact the accommodation that had been made for them is reflected here, the $1,800 essentially that they...
Yes, it is. Wow.
And you have you were agreed to pay that reduced amount for the curbing, the $2,000 and change that they had calculated. That's correct.
Oh, absolutely. I'd have written the check right there and then if I could.
Okay, and you stand prepared to do that.
Oh,
that
absolutely.
Correct? And it's your understanding that you had basically reached an agreement at that meeting with Mr. Lamson, Mr. Clayman, Sheila Craig, Harriet Drummond, and others.
And others. Mr. Clayman actually wasn't there, but Jerry Hansen was there, who was Mr. Lamson's boss at that time.
Okay.
Wow. Very disappointing.
Exhibit 47.
Okay.
The court reporter has handed you what's been marked as Exhibit 47, and I'll represent to you, sir, that this is a list of the assessed value. The municipal assessor is required by state law to annually assess the fair market value of properties within the municipality of Anchorage.
I understand that.
And these are all properties that were included within the improvement district. And if you'll turn to the second page, you'll see the assessments for
Might I ask who prepared this?
the assessor's office or somebody at the assessor's office.
And was this, I don't recall if this was ever produced or anything. I'm just curious
I think
how it came to be.
You'll see at the top of it says research request. Apparently you go to the my assistant did it, but you go to the municipality.
So your assistant prepared this or printed this out?
No, the municipality did.
Well, I appreciate kind of an explanation of how she acquired it. I just want to know where it came from.
Yeah, you go to the municipality's assessor's office and you make a research request for them, and that's why it says research request. And you say, can you please give me information on the assessed value of identified properties, and they will do that for you.
And do you know when that was done or any details about it?
I don't know, not off the top of my head, but this was all done by the municipality of Anchorage. This is their work product, not mine, and not my office's.
Okay.
Turning to the second page, you'll see that in 2008, prior to these improvements being built, you've got assessed values for the lots.
I'm sorry, one more time. I'm looking at page 2, and I've got 2011 and 2012.
The exhibit is only 2 pages, and you've got extra pages.
Mine
there.
is 4.
Yeah, so just the last 2 pages, Bob, are marked as an exhibit.
Just the last 2 pages were marked as an
It's the only part
exhibit?
that's really relevant, I think, but yeah.
So that these aren't?
Correct. So again, Mr. Hitchens, looking at page 2, you'll see that the properties are listed for 2008, and this is prior to the road being built.
Correct.
And you'll see at the bottom of the list here, you've got Simonson Estates, Block B, Lot 7, Lot 8, Lot 9. Those are all the lots right next door to you, correct?
That's correct.
And they're assessed essentially, roughly $36,000 for the most part.
Correct.
And yet your lot, because you had access is assessed for substantially more than that. Is that correct?
Yes, so 4 times.
Yeah, and indeed, the entire time that you lived there, you had been assessed for a fully developed lot. Is that correct?
Yes, absolutely. I mean, that's the sort of breakdown one gets. You get the lot value and the building value, and that comes out in a little green card, usually at the beginning of the year.
And so these other lots that are a part of this improvement district were being assessed for years at substantially less than you had been paying.
Exactly right.
So you had been paying for the fact that you had access. Is that correct?
That's exactly right.
All right. And so the total assessed value in 2008 was $471,400?
That's correct.
All right. And then if we turn to the first page, and if you'll look at the assessments for 2010, which would have been after
completion of the road.
After completion. At that point, your total assessed value was $478,500. In other words, an increase of roughly $7,100. Is that correct?
That's correct.
Okay. And yet, if you look at the lots that were also vacant lots that were also included, they went up in value substantially more, didn't they?
They sure did.
They went up in value, $44,000 for the lots that were immediately next to you to more than $150,000 from some of those that were across the street.
That's exactly right.
So clearly the assessor had taken into account the fact that this construction was done and it added substantial value to these vacant lots, correct?
That's right.
But it did not add substantial value to your lot.
It did not at all.
So
they agree with me.
Yeah. So essentially, while you felt that it actually decreased the value of your lot, in fact, the sale of your home buttressed that because you had to decrease the selling price of your home in order to get it sold, and you had to escrow the money to pay for the assessments to get it sold. The assessor essentially agreed that your lot did not nearly benefit to the degree that these vacant lots did.
That's what he's saying.
No further questions.
Okay. Can we take a break?
Sure.
Off record, 2:19 p.m.
Well, no, it should continue forward, I think.
On record, 2:26 p.m.
Okay. Mr. Hitchens, my name is Robert Owens. We met once before in my office.
Correct.
Cordially brought by some papers. So I've got a little bit of background information I'd like to, hold on, pause for a second, my cord's caught. Okay. You said that you purchased the property at 2219 West Marston Drive, I think in 93?
I think that's correct, yes.
And in fact, you owned the 2 adjacent parcels.
I bought those
as well,
later, yes.
Later. 2219 Marston Drive is also known as Lot B, or Block B, Lot 10, Simonson Estates subdivision.
That's correct.
And the other 2 lots were lots 8 and 9?
I think so, yes.
Just to the north of...
Yeah, to the north, yes.
And you've testified extensively about your concerns about the assessments for Lot 10, 2219 West Marston. But you also owned lots 8 and 9. Do you have objections to the assessments with respect to lots 8 and 9?
I'm on record as never complaining about those because those lots never had access or full utilities.
Okay. So your objections today are just limited to the assessment amounts for Lot 10?
Yes.
What did you know about the property in the vicinity when you purchased it in 1993, particularly with respect to its proximity to the earthquake slide zone?
Well, obviously we know that it was in that slide zone. The property had been there a number of years. We liked the location. It was something we were looking for. We bought the house from a respected individual, and we got full title. So that was it. Later on, we bought the other 2 lots because we really liked the area, and by securing those 2 lots, I thought that forever we would have a minor wilderness experience in an urban setting.
Right. And so you understood that at one time or another that area had been developed?
Yes.
And that there were roads in place and houses prior to the earthquake?
Oh, yes.
And so did you understand as well that the area was platted and that there were rights-of-way and roads still shown on the plats?
You know, I didn't at the time of purchase. I found that out subsequently.
I want to hand you, I guess we'll mark this a new exhibit.
Oh my.
This is a little hard to read, but if you look down at the bottom, it's pretty clear that this is Simonson Estates subdivision.
Okay.
And if you take a moment to look at it and see if it appears to be familiar.
Okay, yeah, let me see this. They got different names, of course. It says Simonson Boulevard, but I believe that's now West Marston Drive, correct?
Correct.
So that would logically mean that my place is there at the end there on lot 10.
Right above the tape line?
That's what I'm looking at, yes.
Okay. Thank you. I'd like you to, I'm showing you this because some of the additional photographs I'm going to show have this subdivision superimposed over an aerial photograph.
Okay.
And so I wanted you to be familiar so that you can not be surprised when you see that.
All right.
Tell me if you think there's any inaccuracy in the other photographs. First off, I want to show you, this will be exhibit
49. Okay. Oh boy.
This is a May 1959 aerial photograph of the northern extent of Simonson Estates subdivision.
Pardon me, which date did you say?
In the lower right-hand corner, it says May of 1959.
59, okay.
So this is before the earthquake.
I understand, yeah.
And you can see that there are roads in there, and I believe that your house may be, the house that was on the parcel known as Lot 10, Simonson Estates Block B, is shown on this photograph. Do you see where that might be?
I see some buildings there, but I can't identify Block 10. Lot 10, excuse me.
Is your house the same house that was on the property prior to the earthquake?
Oh, no, I believe it was built in the 1980s.
Okay. So one more historical photograph.
Okay.
And just for the record, the exhibit we marked as Exhibit 49 is also identified as MOA Hearing Exhibit A2. And Exhibit 50 is marked as MOA Hearing Exhibit A4. In the lower right-hand corner of the box indicates that this is a photograph from June 1 of 1964.
Yes.
And it is the same area as shown in Exhibit 49 prior to the earthquake. And do you agree that this shows some pretty extensive changes in the landscape after the March 1964 earthquake?
I would think it would, but you're asking me to agree. Yeah, I can see some changes, but the documentation is not that clear to me, and maybe my eyesight's not good enough.
Right. But you are aware, nonetheless, that this was an area of substantial damage in 1964.
Yes, of course.
And commonly known as the earthquake slide area.
That's correct.
Did that give you any concern when you were buying your property in 1993?
Did it give me some concern? Obviously, I thought about it, but obviously not enough that it stopped us from buying.
Okay, I'm now going to show you. This is one that's hard to see the year. If you like the other one, you're going to love this one.
All right. Okay.
You'll see the legend box in the bottom shows that this is a Marston Foraker Redwood lid is the large print. Below that, in fine print, there is a reference to aerial imagery, which is difficult to read, but I'll represent to you that this is 2006. So this would be before any work began on the project.
Yes, okay.
So this is an aerial photograph with which the subdivision alignments have been superimposed. And if you take a look at it, I'd ask if you take exception to any of the way that this is laid out. Particularly if you look in the lower left-hand corner of the page, you might see your home.
Yeah, I can see my home.
Could you put that photograph on the easel and point to where your home is?
Yeah, here we go.
Right down there in the lower left-hand side, third lot up.
Yes.
Now, the one just to the north, which would be towards the bottom of, I'm sorry, the lot 11, let's refer to that.
Yeah.
Which is towards the bottom of the page, the next adjacent property. Do you see where the road comes down to, into your access route to your property? And I'm trying to compare it between lots 10 and 11. And do you see where I'm referring to? This area down here where the road comes in.
I don't quite understand what you're saying.
Where the road comes in and you drive to get to your property.
Okay.
Do you notice that it is wider where it comes into lot 11?
Oh, yes.
And becomes narrower onto yours?
Yes.
So was your access road that you got to your house smaller than what was leading to the adjacent property?
Not noticeably. We just drove straight in. It was, I think it was 2 cars wide. In fact, I know it's 2 cars wide. We passed.
So, but when you look at this photograph...
That's not a good... I think you can find a better photograph than that. I've seen a better photograph than that with Jim Lamson. A more, closer in.
Okay. Handing you what's been marked as Exhibit 52.
Okay, good.
This again is from the Marston Foraker Redwood lid. And the small font aerial imagery date is 2007. Although again, it's a little difficult to read, but clearly this is before any work began. Would you agree?
Yes, it is. Okay. And I think I know what you're going to say, but I believe this is the tree cover doesn't show the extent of our driveway. Because you can't see the you can't see the asphalt in front of our house even.
Mm-hmm. But would you agree that your drive was not as wide as the road adjacent?
Oh, yes.
And looking again at Exhibit 52, there's a large green space just north of where the road ends and the beginning of the trail to Pete's Place is? You see that large green area?
The block C, lot something.
It says West Marston Drive.
Oh, that. Okay,
where
yes.
that language is.
Oh, yeah, okay, yes, I do see that.
Could you put that on the easel and point to it?
That's the sign that says West Marston Drive.
Yes, right in that area there.
Yes.
Is that basically a grassy area?
Oh, yeah, it was.
And was that an area that you enjoyed? Earlier you were describing a pastoral setting and having, nothing but moose around you. Is this kind of what you're describing there, a large green area with trees all around?
Yes, yeah, this was actually sort of an area that was had just been cleared. We actually looked after it. And then these areas here was treed areas.
Okay. Now you can see from this image with Exhibit 52 and the subdivision superimposed that the green area you're describing is actually West Marston Drive?
Yes, apparently.
On the plat?
Yes.
And so it was dedicated right away, in fact?
It was, yeah, apparently.
Okay. And in fact, your access road to your house is within that same right-of-way?
Yeah, well, I guess so. That's that's how we got our access on that right-of-way.
Right. And you knew that old road had been there prior to the earthquake?
No, I
and it was still part of the plat?
Well, I subsequently found out, yes.
At some point you knew that?
Yeah.
Prior to when the work was actually...
Of course, yeah.
So you knew that if the road was ever built out, it would cover your driveway?
It would certainly impact our property, yeah.
Yes. And in large part, that has part of the reason why you didn't want the project to go forward. You had a great setting, and it would have changed the entire layout of the property.
Yeah, obviously from this drawing here, you can appreciate how much we liked the area. We bought that house, and then later on, I acquired the other two. It was idyllic. It was lovely.
I agree. But then the project began in 2009.
Exhibit 53.
Okay. Oh, there you go.
And this again is one of the aerial photographs with the subdivision superimposed. And the image here is 2009. It's difficult to read, but I'll represent to you that's what that little bitty language says down there. By this time, you had sold the property and had moved out?
That's correct.
So in terms of working with project staff for realignment of your access, you weren't involved in any of those negotiations?
Not at all.
Okay. Finally, I'll show you one more. That is after the project is completed.
Exhibit 54.
All right.
And this again is an aerial photograph with the subdivision superimposed, and this is dated 2012. Can you see that?
I can see 2012, yes.
Yeah, it's a little clearer. You can see that the vegetation is starting to grow back in, the road's in place, and you can see your house.
My former home, yes.
Former home, yes. So, do you have any reason to think that the road as constructed differed materially from the way it was originally platted?
I haven't the foggiest idea.
Okay. Now I'd like to show you two photographs. This first one is, and the last one was marked as Exhibit 54, but it's also MOA hearing Exhibit A14. This next one is Exhibit 55. It's MOA hearing Exhibit 13.
There you go.
Do you recognize this photograph?
Oh, certainly. This is the access to my home, my former home. There's the driveway. There's my fence that was there. Post office, the mailbox, and the house is to the right there.
Through the trees are those windows at your home?
That's correct. That was my home, yes.
And was there any feature that's just off the edge of the photograph on the left?
Yeah, that's the access to the coastal trail.
And did it have a name?
The Pete's Place?
Pete's Place.
Yeah, okay.
Now, the next photograph, is marked as Exhibit 56, and this is also marked as MOA Hearing Exhibit 13, page 1 of 2. Do you recognize this structure?
Yeah, that's my home for 15 years.
Where would this picture have been taken?
Well, I guess from
the angle?
from Pete's Place coastal trail access road path.
Okay. Now, where is the primary access door for the home?
Well, as you come in here, there's garage doors there. So you came down this driveway straight into those garage doors.
And just for purposes of the record, you're pointing to the right-hand side of the house?
Yeah, I guess they call that the south side. Yeah.
Okay.
South side, and there's a main door there. That's the entrance door.
And yet it looks like there might be blacktop that goes around to the other side of the house as well?
That's right. It goes around, and there's the sort of ladder access there.
So when you were living there, there was a paved access to both sides of the house?
That's correct.
Now, I'd like you to keep that photograph and
56. 57. Yeah.
do you recognize building in Exhibit 57?
This is my former home as it is now.
And is it taken from the same angle?
No, it's taken from, I would say, about this point here, above my former access.
Okay, maybe you could sort of put one on the easel and hold the other one. We're going to do a comparison of the two.
You mean these two?
These two.
Well, it's very difficult, because that's the south, and this would be the west.
Okay.
Elevations.
But looking at these two images of the home, do you notice that there are certain physical features of the property that are significantly different?
Are you talking about this other access?
Yes.
Okay, yes.
And do you notice any other changes?
What am I supposed to be looking for, sir?
Well, is the paved access to both sides of the house still there?
Apparently not.
And looking at the image, exhibit number 57, does it appear that there are two different shades of asphalt on the...
There certainly are.
Is the configuration of the asphalt on exhibit 57 the way it was when you lived there?
No, of course not.
Is it significantly bigger?
I don't know.
Would the fact that a portion of that is darker than the other might suggest that it's newer?
It's newer, yeah, but well, you said bigger.
Okay. Did you have a drain in your parking area adjacent to the house?
Oh, I don't remember. I don't remember.
Okay, is it possible you didn't?
It's possible I did, but it's possible I didn't.
And do you notice that there's the area where the driveway going around the spruce used to be is now grass?
Yeah, so it seems. I don't know why they did that. I like that.
And there's landscaping features in the foreground?
Oh, yes.
And the property, the road itself now has a curb and gutter,
Yes.
and you can't tell width in this photograph. So those seem to be material differences in the aspects of the property from before the work was done to after. Would you agree?
These are changes.
You indicated you sold your house at 2219 in 2008, I believe.
2008, yes.
You stated that it had been appraised at a value. What had it been appraised at?
You know, I was looking that up last night, and I don't have the paperwork anymore. I don't know.
Ballpark?
I can't.
So how can you say today that it's less? You sold it for less?
From memory. I remember the weeks and months we went through agonizing over trying to get this place sold. People going through. My wife hated it because she had to prepare the place, and then people came through. If you sold a house, you've been through it. Yeah. And then one of the things Janelle said, well, I'm afraid you're going to have to bring the price down. So we brought it down. But I don't know if there's a record of that.
So you couldn't find the appraisal at the time that you had at the time?
It was 2008. I don't keep my paperwork for that sort of thing more than I have to. Okay. I've got limited space.
What did you sell it for?
I think about. This is judicial. It's approximate. I don't really remember, but below 500, 480,000 $480,000. Don't hold me to that. I can't. I'd have to look that up.
Do you have an opinion as you're sitting here today how much money the difference between what your original asking price was and what your final sales price was?
Yeah, I want to say that originally, this is once again guesswork from trying to remember. I would say we were asking for about 550,000. But I could easily be wrong. It didn't seem important to me at the time to remember that.
And when did you first list the house? Do you recall what time of the year?
Yeah, it was in the summer of 2007, or the early summer, as soon as we get back to enjoying Alaska in the summer, springtime, probably May. Probably.
May, June time frame?
Yeah.
Somewhere in there. Now, did you sell the adjacent lots 8 and 9 when you sold lot 10?
I sold it, but I can't remember when I sold it. I got a feeling it had to be later. Yes, I'm sure it was later.
Okay. I do have the record you brought me.
You know better than I when I sold it.
We don't really need to make this a record, but, well, I guess I'll ask first. Maybe we do. These were signed in May of 2009.
Okay.
When you sold lots 8 and 9, did you address the question of the assessments in your sales transaction?
I sold it to Mr. Spinelli, who was very well aware of what was going to be going on in that area, as he owned other properties there, and part of the agreement was that he would take on those responsibilities. No escrow account in this particular case.
Okay.
Those particular cases.
So he purchased the property for a price that included him agreeing to assume responsibility for the assessments.
That's correct.
And on lots 8 and 9, did the assessments include the water and the sewer utilities?
I got a feeling from memory that one of them had something already. I think maybe 9 either had water or sewer. I don't remember.
Okay. And the agreement that, well, we'll just make this a record. recognize what's been marked as Exhibit 58?
Oh, yes.
Is this the purchase and sale agreement when you sold lots 8 and 9?
Yes.
It indicates the purchase price is $116,688 in paragraph 1.
That's correct.
How did you reach that price?
That was what I agreed with Mr. Spinelli.
Did you allocate the values between the lots? Did you figure a value for it and double, or do you have any recollection?
Those types of questions, I don't recall how we came at that number. Chuck, I saw Mr. Spinelli in passing, not socially, we don't socialize, he asked me if we were interested in selling, and I said absolutely. And he came to me with an offer, and I took it.
Okay.
That's
And it was a combined...
Yes, what I had two. Sorry, 8 and 9.
And if you look at paragraph number 16 on page 2, you see where the buyer agrees and acknowledges the lots are subject to a lid and rid.
Yes.
And subject to a sizable assessment, and the buyer accepts full responsibility for paying those?
Yes.
So that confirms what you had testified to?
Yes.
So at least the buyer of those 2 lots believed that those lots were worth whatever they paid you in addition to the assessments?
Well, they weren't developed.
But the buyer agreed to pay those assessments.
Oh, yes.
Plus other money to you.
Yes.
And must have perceived those lots to have sufficient value to justify that.
That's up to Mr. Spinelli, isn't it?
He paid the money.
Interesting enough, he has developed them.
Yes. They're very nice homes going in there, too.
Oh, beautiful.
Now, you testified earlier that you opposed the improvement districts every opportunity that you had. Is that a fair statement?
That's a fair statement.
I'm handing you marked as Exhibit 59, which is also marked as here in Exhibit F3. Do you recognize this document?
No.
It's identified at the top as testimony on the Turnigan Slide development, Citizens for Turnigan's Future, April 2004.
Okay.
And if you look at the back page, page 4, your name is on there.
I see it.
Do you recall the circumstances by which your name came to be on this document?
No, I don't. I've never been, I believe I've never seen this document before.
Well, let's look at the first page of it. It indicates that it's a testimony submitted on behalf of an informal group of homeowners. In 2004, were you coordinating with others to...
Oh, no, I was not coordinating with anybody. Not anybody at all. I did go to a meeting called by Mr. Fink and was there at that meeting. And he was very keen that we should go ahead and build this road and have access to his ancestral home, which he was going to develop because he had fond memories of being there. And I just sat there and listened. But I went to the meeting to oppose. But I don't, is this the meeting?
Well, I believe this is information submitted by homeowners or by property owners who opposed the development.
Opposed?
Opposed.
Okay. I haven't had a chance to read. Yes, of course, Zobel's is there. Yeah. So I know Zobel was opposed to it. Pete Eberhardt. Well, he lived down the road. He now lives, ironically, on Marston Drive. I mean, the other part of mine. He built the first house there. But yeah, okay, all right. Angel. But I don't remember seeing this document before.
Okay, so speaking then just in general terms, this suggests that some of the parties who were opposing development were concerned about soil stability. Does that ring any kind of a bell with you?
I'm sure they did. The answer to your question is no, but I think I was aware of that problem.
Were you concerned about lateral support of your property if this development occurred?
I hadn't considered it.
One of the things that these homeowners indicate that they were advancing, a proposition, was that the project be referred to the Geotechnical Advisory Commission.
I just read that, yes.
Are you familiar with what the Geotechnical Advisory Commission is?
Yes.
How would you describe it in your words?
Well, they look at the prospects of in this particular case, seismic activity and the adverse effect on properties, buildings.
And so what would you understand the purpose of referring something to the Geotechnical Commission?
In the hopes that they would put a stop to the development in view of the people who are involved.
I see. And geotechnical in and of itself, do you know, and being in the construction industry, you probably are aware, what does that address? What kind of aspects of development?
Oh, liquefaction.
Of the soils?
Of the soils in the event of a seismic event. A seismic event.
Soil stability?
Correct.
If you turn to page 2 in item number 4, it talks about using the pre-earthquake right-of-way routes for redevelopment and expresses concern about doing so in that it cuts into the side of the bluff above the slide, and the proposed sewer utility would cut into the side of a bluff that has a house on it. Do you know which house they might be referring to?
It certainly wouldn't be. I see beside it says Hitchens House ?
I didn't mean that. That's my note.
Yeah, I know. Well, I didn't know it was your note, but I see it's written in a different hand. I would not think so because, we're talking about sewer pipe, right? So a sewer pipe goes downhill. In order to get that pipe connected to the utility in Marston Drive, existing Marston Drive, you'd have to go uphill. So I'm presuming that they're talking about a connection the other end at Laneri.
Okay. Okay, that's fine. It indicates in paragraph 5 that if you look that in the third line, soil stability has always been the issue.
They do say that.
And would you concur that that was a matter of concern for you?
I'd lived there 10 years by then, so obviously not.
I see. Okay.
I was opposed to this development, and I guess that they knew I was opposed to it. I did not attend a meeting with these particular people. I did meet Mr. Zobels informally at one time during this whole process, exactly when, and I assume in order to make sure that everyone was on board, he put my name in it, but unfortunately I was not copied.
Okay. Is there any possibility that your wife was active in trying to resist?
No, she mostly left it to me.
Okay. All right. back at off record 3:04 p.m. On record 3:09 p.m. Okay, we're back from a brief break. I just have a couple more documents I wanted to touch base on. The first is Exhibit 44, if you could grab that. Exhibit 44 is it's a couple of emails. I'm looking particularly at the email from your wife to the mayor dated June 25. It's at the lower portion of the page. You see that?
I've got the,
Okay.
okay, yeah.
There's the second paragraph. We then had a period of about 2 years. You see that?
Mm-hmm.
We were actively involved in trying to get the matter resolved, meeting with Dan Coffey, Harriet Drummond, Sheila Selcraig, and other members of the Assembly, including the mayor when he was on the Assembly. So, why were you involving various members of the Assembly to, at this point in time?
I guess it's called lobbying.
Okay. So did you understand that the matter would need to go to the Assembly as a body and for a positive vote?
That's what I was told.
And ultimately, any adjustment would require a vote of the full body?
Yes, because they'd already voted, in my opinion, erroneously, because they've been given wrong information in the first place. Once they've voted, they have to unvote.
Right. So until that occurs, there's no binding deal with the municipality.
I understand that, but we did have somebody who suggested the first amount come back with a adjustment. So I felt pretty good about that.
Okay. And then in terms of the nature of the change, you earlier referred to Mr. Lamson's statement in Exhibit 42, for example, as well as 43. But in Exhibit 42, this This is Mr. Lamson. I'm not sure if this is an email or a memo, but it appears to have been written by him. And he is recounting the meeting that occurred on July 6th, or thereabouts. And in particular, the next to the last paragraph, he states the improvements abutting the Hitchens Lot 10 property are substantially greater than the upgrades to adjacent Lot 11, but he's been asked to calculate a modification of the amount. So he's indicating at least here that there's significant difference between Lot 11 and Lot 10, wouldn't you agree?
He does appear to be in this note.
I guess I don't have any other questions.
I've got a couple of follow-ups, Mr. Hitchens, real quickly. Mr. Owens said, you understood that the issue of an adjustment for you had to go before the whole assembly, and you agreed with that. But you had an understanding that basically the representatives of the municipality had reached an agreement with you to put before the assembly this adjustment. Is that correct?
That's exactly correct.
Okay. And I want to ask you a couple of questions with regard to a couple of other points that Mr. Owens addressed. Looking at Exhibit 58, which is the purchase and sale agreement of lots 8 and 9 to Mr. Spinelli. Do you have that still in front of you?
Of course, somewhere here.
And so you sold those two lots to him for a total of $116,688. Is that correct?
That's correct.
And then if you'll take a look at the assessment exhibit, which I don't...
Yeah, okay, it's down here somewhere.
It should be the last one before the photos.
Yeah, before the picture. There you go.
Yeah. What's the exhibit number again on that?
47, I believe.
So again, if you'll turn to the second page and look at the 2008 assessment for lots 8 and 9, you'll see that Lot 8 was assessed at $36,600 and Lot 9 at $67,000. And again, you indicated that you thought that one of the two lots, the one closest to Lot 9, had either water or sewer or something.
Yeah, I know it had one or the other.
Okay, and so indeed that seems to reflect in even the pre-improvement assessment by the assessor. Lot 9 was assessed for slightly more, slightly more than Lot 8. Right?
Yes, correct.
And so the total value of both of those, if my math is correct, is $103,600.
Okay. Yeah, that's about right.
Okay. And so the assessor thought the fair market value of those two lots prior to these improvements was roughly $103,600. And you sold them for $116,600. So you got slightly more than what the assessor thought they were worth.
Yes, indeed I did.
Okay. And then with regard, but not substantially more, but slightly more. Yeah. Is that correct?
Correct.
And then if you look in 2010, the assessor, following the completion of this, the assessor said Lot 8 has increased from $36,600 to $80,200. Do you see that?
Correct.
And Lot 9 has increased from $67,000 to $84,800.
Correct.
So if my math is again correct, the total of that is $165,000.
Yes.
So roughly $62,000 of increase for those two lots.
That's correct.
As relative to those two improvements. Now, with regard to your home, you said that you were originally asking, you thought around $550, and you think you sold it for roughly $480. Is that correct?
Something like that.
Okay.
Yeah, that's memory, but I don't really remember too well.
Okay. And so, again, if you look at the assessments, in 2008, your home was assessed for $471,400.
Correct.
So, again, if you sold it for $480, you got slightly more than what the assessor said it was worth.
Okay.
Is that correct?
That's correct.
But in fact, out of that sale for $480,000, you had to escrow $80,000.
$80,000, yeah.
And so, if the assembly does not honor the agreement that you thought you had, you really only got $400,000 for the home.
Unfortunately, yes.
Substantially less than what the assessor thought it was worth.
That sounds like it, doesn't it?
And so, and indeed, doesn't that seem to corroborate that the road itself actually put less value on your home?
I always believed it was detrimental.
That's all the further questions I have.
May I add something, please?
Sure.
It was to do with these photos, and specifically this one here, that is 57.
Mm-hmm.
We are talking about road improvements. Now, the fact that Mr. Dexter had the asphalt removed and this extra work put in here, if that's the case, ask Mr. Dexter for the money, not me. I didn't want it. I never asked for this.
Yeah. So, and again, just to make sure that it's clear, so on Exhibit 57, Mr. Owens asked you some questions about the fact that the drive looks slightly different insofar as some new asphalt was put in. Maybe not additional asphalt, but new asphalt.
Mm-hmm.
And he removed the asphalt that went around the house.
Right.
But again, that was done by the owner of the property.
Yeah. If he made a special request, good for him, but I don't think I should pay for it.
Yeah. Okay. I do have one other question. I guess that brings up one other point. If you look at Exhibit 52 and 54. 52, this is a photo from 2007 prior to the construction, and I want to draw your attention to lot 11, which was your neighbors, the McLeods.
Right.
And like you, they had access to their home, but it wasn't the road that has since been developed. Is that
That's correct, yeah.
And then if you look at Exhibit 54, you can see that, in fact, the road that was eventually built
goes beyond this.
Goes all the way across their lot. That new curbing you can see on either side of the road, it's kind of a bright white, that curbing, right?
Yes.
So that entire road was built in front of their house. That new road was completely redone in front of their house, correct?
Yes.
And so, they had this same improvement done to their house that was done to your house, correct?
Looks like it.
And yet they were only assessed $1,800.
There you go.
No further questions.
Okay, no further questions.
The deposition of Cliff Hitchens is...
That witness, if we can take a short break, I can clean up and use the restroom. I'm sure everybody else can use a break.
Yeah, I have a couple of comments for you, Mr. Staley. As I'm looking at your your final witness list, it looks to me from people not yet called, you'll be calling Dee Dee Hitchens, Chuck Spinelli, Matthew Fink, Vern Rolfs, and Bryant Robbins. Is that your intention?
I'm not calling Bryant Robbins. He was what I thought was the assessor, and since Mr. Owens called Mr. Wedlick yesterday, I will not be calling him. I believe the other witnesses I will call, but I may not even call all of them. So,
Okay.
and I think that they'll be pretty brief. So,
Okay.
I still don't think we're going to have a problem finishing today. So,
Okay. And then, is there any, my understanding, I see Mr. Hansen in the audience. Is Mr. Lamson, what is his status? Where is he? Is he retired? He's
retired.
He's retired? Then I will request that Mr. Hansen stay today because the panel will have questions for him.
Okay.
Thank you. With that, we will adjourn for about 15 minutes. The panel needs a break, so thanks. Okay, we will be back on the record. Call this meeting back to order. Before we go too much further, I just want to discuss the board's desire to listen to Mr. Hansen. Is there any objection from the municipality to Mr. Hansen being called?
No, I don't have any objection, but I would note that Mr. Hansen has a commitment this afternoon, and so we'd like to get him out of here by 3. So we'll coordinate the arrangement of folks, but that's kind of his
time frame
situation.
Okay, and Mr. Staley, do you have any objection to Mr. Hansen being called as a witness or being questioned by the panel?
well, other than the fact that I haven't had a chance to speak to him, but myself. So, but beyond that, no.
So the answer is no.
If you would give me a chance to interview him, I'd appreciate it. But
I'd be happy to. So the other question to that, follow-up question, we have no desired structured way that we want to do this. I mean, we're happy for either of you, both of you, to query Mr. Hansen before the panel asks questions. That's fine. Or if you'd rather, we could call him up, ask our questions, and then you could follow up. Either way. Whatever you prefer is the method we'll use. Mr. Staley?
Well, what I'd like to do is I'd like to, before we break for lunch, call Dr. Diddy Hitchens so that she's been patient enough to be here. And I'd like to get her on and off the stand before we break for lunch. I think we'll really be brief. I would only need 5 minutes to chat with Mr. Hansen briefly during the lunch break, and that's all I would need. And obviously, Mr. Owens has all the time in the world to chat with him and has had all the time in the world to chat with him. So, I mean, I don't anticipate any kind of a problem here, just as long as you ask Mr. Hansen to cooperatively talk with me for several minutes. That's all I need.
Absolutely, and that is requested. Okay, so we will proceed with that. Mr. Staley, if you'll go ahead and call your next witness.
Thank you, Madam Chair. We'll call Dr. Diddy Hitchens.
Through the chair, Mr. Staley, could you please get a little closer to the mic or tip your mic up, please?
Sure.
Thank you, ma'am. Can you please state your first and last name? Spell your last name for the record.
I'm Dr. Diddy Hitchens. Last name is Hitchins.
Welcome. And if you'd please face the clerk, she'll go ahead and swear you in.
Do you solemnly and sincerely swear or affirm that the answers you will give to the questions asked of you in these proceedings will be true?
I do.
Good morning, Dr. Hitchens, and it is still morning for another few minutes. You've sat through most of this hearing, is that correct?
I have.
Okay, and so I'm going to be fairly brief with you, but I would like to give the panel a little bit of a background. And so I understand you're currently retired, is that correct?
I'm Professor Emerita from UAA. If you're
Okay.
Emerita, you're not really retired. You still do projects.
All right.
I don't teach
Okay.
regular semesters.
Okay. At one time, until recently, you were a full-time professor, is that correct?
I'm Professor of Political Science at UAA for 30 years.
For 30 years, okay. And so you've lived in the state of Alaska since the 70s, is that correct?
Arrived in Alaska on December the 13th, 1974. It will be 40 years next Saturday, and I've lived here ever since.
Okay. And in addition to being a professor at UAA, did you have any other professional...
I'm also the British Honorary Consul for Alaska, which I have been since the mid-1970s. Sorry, the mid-1980s.
And then you said you're currently Professor...
Emerita, which means I still am part of the faculty and the UAA community, and I work on my fields are comparative politics. I'm a specialist on the Arctic and North Pacific international relations, and I'm currently involved on an Arctic project with UAF and the University of the Arctic in association with the US being the will soon be the chair of the Arctic Council. So I'm working on an ongoing project that will last through 2017.
Okay, and so even though you retired from your full-time position as a professor, you still are engaged actively with the university system working on projects.
Absolutely.
And if you'll look at Exhibit I-3, I need to figure out how to get this back on.
just noticed that in the book, these are listed as Hutchins property, not Hitchins property. Okay, yep, got it.
And what is that?
A photograph of my former home.
And that's the way that it was when you lived there, is that correct?
Yes, it's exactly how it was when we bought it from.
And who did you buy it from?
We bought it from Bill and Donna Walker.
Our current governor.
Yeah, they had built it in 1984, I think, and we bought it in 1993. And the grass out front, the day we went and looked at it, Bill Walker had a little soccer pitch set up on this grass and was playing with his daughters.
Okay, and so this grass area out front, which was in the municipal right-of-way, it was used by Governor Walker when he owned the home.
Absolutely, yes. It's right-of-way in the foreground for the what later became the road. And then the section that goes right through is also right-of-way because that's where the one of the lines was under there. So there were two different rights-of-way.
Okay.
And we knew about we knew about both of them.
Okay. And at some point, you learned that certain people in the area were petitioning to have roads put in to create access for some undeveloped lots. Is that
Yes.
correct? And indeed, you and your husband had purchased a couple of undeveloped and undevelopable lots next to you, just to purchase for the green space, correct?
Right, exactly.
And when you were asked to vote on whether or not you wanted this project to go forward, how did you vote?
We were completely and adamantly opposed.
Okay.
We did not want there to be any development.
Okay. And at some point, you were notified that your home was going to be included in this road improvement district. Is that correct?
Yes.
And
I think initially we were just told it was going to be included in the development district. And I don't think I ever knew that it was divided into these three different aspects. I think Cliff probably did. My husband did because he's in construction and he understands that sort of thing. I'm a political scientist. I don't understand about that sort of thing.
okay, fair enough. And we saw your husband's deposition, and we understand that he took an active role in writing to try and get a meeting with somebody or get a response. Didn't get any response, but he took the active role on your behalf in terms of trying to contact the municipality to say that your home should not be properly included in this improvement district. Is that
Yes,
right?
We conferred together. We were of one mind. We were perfectly in agreement about how we felt about this. But he was the one who initially pursued it by writing letters and things like that. Yes.
Okay. And at some point, this went on for a number of years. For a number of years, we were just getting no response whatsoever.
Right.
And finally, in 2009, you had a meeting with a number of people. Is that correct?
That's true.
Okay. Tell me about that meeting.
Well, actually, the meeting or how it came about?
Well, you can tell me about how the meeting came about, and then what happened at the meeting.
As you said, we had for several years been trying to get some response, trying to get somebody to agree that we should never have been included in the development district because we were a fully developed and a fully taxed developed property. And it was very frustrating, and we just couldn't seem to get any response. And then, and I'm not quite sure when this was, but I was called onto a jury pool, And Dan Coffey, who was on the municipality, was also on the jury pool. Now, I didn't at that point know Dan Coffey, but you know what it's like being on a jury pool. You sit there for hours and hours. And at some point, I think I was sitting next to Dan Coffey and had a conversation with him and told him about this situation that was so frustrating for us. And he said to me, well, if you want to actually get some response, what you should do is write a letter setting this out to the mayor and to Larry Baker, who is the mayor's special assistant. And so I came back after that evening on the jury pool. As it happens, both Mr. Coffey and I were selected for the jury, but then the lawyers didn't want either of us, so we didn't actually serve. And I came back and I said to Cliff that this had happened. And Cliff said, well, since it was you who had the discussion with Mr. Coffey, why don't you write the letter to Dan Sullivan and Larry Baker? And I think in the course of that actual week, I was at some social function to do with being British consul. Actually, I think I had a British ambassador up visiting or a consul general. I had to take them in to meet the mayor, and Larry Baker was there as well. And I briefly mentioned to them that I had this issue and I was going to write them a letter. And Larry Baker said, do, by all means, send it in. And so at that point, I wrote the email letter, which has been already presented in documentation, I think.
Okay.
And subsequent to that, it took a little while. I think that was probably April or May. There was some communication back and forth. I know that Harriet Drummond was involved, and there was the municipality actually set up a meeting, and we went to a meeting out at that big building that's near Martin Luther King Parkway, the other side of Tudor Road. And there were representatives of the assembly and of the municipality. Dan Coffey had told me that if we had a meeting, we should have a lawyer there. So I think there was a man called Mr. Raston.
Dick Roston.
That's right, yeah. He was there at our invitation. And we had the meeting. Initially, we looked at some photos, aerial photos. And I think Mr. Lampson, the photos that he initially showed us were photos that didn't even have our house on them. They showed the land, but they didn't show the house, so it must have been prior to 1984. And then there were other photos that clearly showed the house, and so we went through a discussion. I think Mr. Hanson, who I think's in the room, was also at the meeting, and during the course of the meeting, it was mentioned that our neighbors had an agreement and that they had simply agreed to pay for the frontage, and it was suggested, we were asked, would we be willing to pay for frontage?
Let me stop you there. Prior to learning that your neighbors, the McLeods, had reached an agreement where they would pay for what you're calling frontage or curbing, it's been referred to, a reduced amount, did you know that the McLeods were even in the district?
No, had no idea. Never occurred to us that they would be.
And did you have any idea that that the municipality had reached any kind of a special accommodation with them?
We didn't even know that they were in any way impacted or involved in this.
Okay, but then out of the meeting came this idea that you should pay the same thing that they did, or you should pay an amount based upon a similar formula, that is for curbing or what you're calling frontage. Is that right?
Exactly, yeah.
Okay. And if you'll take a look at Exhibit 105, And the first page, it's a series of emails, but at the top, it's an email from...
I don't think I have emails. I have, oh, okay. Okay, thank you. Yes.
So it's a series of emails. There's one from Mr. Lamson at the bottom. Then there's one from Cliff to Mr. Lamson and others.
Mr. Staley, could you talk into your mic, please?
Apologize, sorry. There's one from your husband in the middle, and then at the top there's one from Sheila Selcraig. Do you see that?
I do.
And so in the middle one, your husband is saying, thanks, Jim, as a compromise position on our part, we can accept the new assessment amount of $26.56. Do you see that?
I do.
And at the top, Sheila Selcraig is writing to your husband, Jim Lamson, Harriet Drummond, and then others, and saying, it is my understanding that Harriet Drummond and Jim Lamson will take the lead in working with the Hitchens to define and finalize an agreement to address this problem. Is that correct?
Yeah.
And so it was what was your understanding of what was going to happen next?
That Jim Lamson was going to put this in writing, that Cliff was then, or both of us were then going to agree to it. But I think we knew that the paperwork then had to go to the assembly.
Okay. And were you told that it was going to go to the assembly at a particular time?
I think at the meeting, I remember at the meeting there was some discussion about how long this would take and so on. I don't think at the time at the end of the meeting, or maybe when this was written, that we knew, but subsequently we were told that it was going to the assembly. I think it was certainly in August. I think it was August the 9th or something like that.
Okay. And do you recall going to an assembly meeting and seeing whether or not it was going to come up and whether or not it actually got on the agenda?
I think I did. Yes, I don't think Cliff did, because I think it was a night when there was a football match, but meaning soccer. But yes, it was supposed to come up on one night Tuesday night in August, and then that assembly meeting ran on until midnight, and they still hadn't finished their agenda, so it was supposed to then carry over to the next week.
Okay. And if you'll look on pages 3 and 4 of that same exhibit, it's an email that you drafted that more or less summarizes this history. Is that right?
3 and 4 of this one? This one's just 2.
105. Are you in 105?
Then there's another one, another one. Yes.
So there's little page numbers at the bottom. It's stamped Exhibit 105, and so
I see. Yeah.
You get to page 3, it's the start of your email, and page 4 is the continuation.
My summary to the mayor and to Larry Baker, telling them the whole history of this.
And at this point, you still thought that this was to come before the assembly, this agreement that you believed that you had reached regarding this reduced or accommodated assessment.
Right, exactly.
If you'll take a look at Exhibit I-8.
Thank you. Yes.
And that's a photo of your former home after this road was put in.
Yes.
And you were in here when I played the deposition of your husband, and you probably heard Mr. Owens asked him some questions about that new asphalt, that dark asphalt, and about the fact that when you owned the home, you had asphalt that went around that tree on the left of the home, and that had been removed. Do you recall those questions?
Yes, I do.
And Mr. Owens seemed to be implying that that this work was done to the home as a part of this improvement district, and therefore that's what would justify some sort of an assessment. And your husband said, well, gosh, if they wanted that asphalt removed, they should have paid for it. You heard that, right? I
did.
In fact, I'll represent to you, Dr. Hitchens, that the new owners did pay for that. This isn't a part of the assessment. That isn't a justification for this assessment. And if you'll take a look at Exhibit 99, needs that notebook, Chrissy.
'99, yes.
And if you look at pages 32 and 33,
I have.
okay, so page 32 you'll see is a temporary construction easement
Yes.
for Simonson Estate Subdivision Block B, Lot 10.
Yes.
And then 33 is a permanent drainage easement for that same lot and block that was granted to the municipality by the new purchasers of that property. And then if you'll turn one page or 2 pages further into page 31.
2 pages back.
Yep, 2 pages back.
31, yes.
You'll see there's a letter from VEI to the municipality regarding this same lot and block, and it says, per the property owner's request, we have incorporated additional work on the subject property beyond the construction limits for the Marston RID project. This work includes removal of 710 square feet of existing pavement, et cetera, et cetera, et cetera. Please deduct this cost from the amount to be paid for the drainage easement. In other words, the municipality wanted an easement for construction purposes, wanted an easement for drainage, agreed to pay something for that. In return, the Dexter Pizzanis said, we'd like this pavement removed. Will you do that for us at the same time? We'll pay for it. And there was a bit of an exchange. The cost of removing that pavement was deducted from the cost of the easement. So that's not a part of these assessments at all, is it? I mean, that's not a justification for charging you money, is it?
As far as I can see, this is something long after we're even involved in anything.
Yeah, you're left. But let me raise another point. If you look at page 31, you'll see that the letter here is dated September 26, 2008, correct?
Yes.
So at the time that the municipality reached an agreement with you in 2009 to assess you just for the curbing, that meeting in July of 2009, all of this had already occurred, hadn't it?
Apparently, yes. This is the first time I've ever seen this. I don't think Cliff's ever seen it.
Yeah, I don't believe that Cliff's ever seen it either. And in fact, it wasn't ever produced to me. I had to subpoena it from VEI. I have no further questions for this witness.
No questions.
Are there questions from the panel? No questions. Thank you, Dr. Hitchens. Thank you. Mr. Staley, would you like to call another witness, or would you like to have a lunch break now?
I think probably it makes most sense to have a lunch break because we probably don't have as brief of a witness. And so,
Okay.
I mean, I think that it makes most sense to have a brief lunch break and then come in and get it done.
Is 30 minutes sufficient for both parties?
Sure.
Yep.
Yep. Okay, so we will break. We will be back here at 12:45.
So Maybe for the panel, I'm trying to plan when to have Jerry Hansen back.
Yeah, so we're breaking
Okay.
for 30 minutes.
Okay, so as long as Mr. Hansen has an opportunity to talk to Mr. Staley during the lunch break, we can come back if Mr. Staley's in agreement and do Mr. Hansen right after the lunch break. Okay, wonderful. Okay, are we ready to get started?
We are.
Okay, Mr. Staley, did you have an opportunity to talk with Mr. Hansen?
I did.
Okay, perfect. And just to reiterate, do you want to start? I'll start with you, Mr. Staley. Do you want to start by bringing Mr. Hansen up and either of you querying him, or would you like me just to go ahead and ask away?
I just prefer you to go ahead and ask away because I don't know what your inquiry was about. So when I chatted with him, of course, I wasn't aware of that, but I asked him just about a few things that I thought might be relevant.
Okay, Mr. Owens?
Same.
Okay, perfect. Mr. Hansen, if you'll please just come up, state your name for the record, and spell your last name, please.
N-S-E-N.
Can you just restate that just for the record, because I don't think your mic was on.
Gerald Hansen, H-A-N-S-E-N.
Perfect. And if you will, sir, the clerk is going to swear you in under oath. If you'll face her and raise your right hand.
Do you solemnly and sincerely swear or affirm that the answers you will give to the questions asked of you in these proceedings will be true?
Yes.
Mr. Hansen, I don't believe you've been present during the entire hearing. Are you aware of the topics that are being discussed by this hearing panel?
Some of them.
Okay, so this is specifically a remand hearing regarding the WID, LID, and RID districts over in the Turnagain area. Are you familiar with those?
Yes.
And are you familiar with the Pump Station 10 project?
That it was included in the project. What specifically the work was, detailed and not really, but yes, I am.
Okay, and just for the record, could you please describe for the panel what your position is with the municipality?
Right now, I'm the Deputy Director of Public Works for Project Management and Engineering.
Okay, and Mr. Hansen, are you familiar, do you recall the conversations that have been referenced regarding the Hitchens property?
I recall some of the conversations or meetings, yes.
All right, in your own words, could you please summarize for me your understanding of the Hitchens property in relation to incorporation or non-incorporation of the improvement districts? And just start with that.
Could you repeat that question?
Sure. Could you just describe for me your understanding of the Hitchens property, the discussions that transpired regarding whether you're going to include that property in the assessment districts, or if it would be at a diminished rate?
First of all, the Hitchens property, excuse me, was included in the districts. Specifically, I know about the RID. I don't know about the LID and WID, what they're, but that when the district was formed, their property was included in the road improvement district for them to pay their fair share of the cost of the improvements.
Okay, and just to follow up, who made the decision to include their property in the RID?
I think probably it was done based on the code at the time that defined which properties were benefited.
Okay, and so you don't know who it was who made the decision. You think it was somebody just looked at the code and said, per code, we believe this property. Would that have been Mr. Lampson?
I believe it would have been him.
Okay, and can you describe for me why the Hitchens property would be included and not the McLeod's property?
Well, I believe both of them were included as far as the assessment in the assessment district.
You're right. You're actually right. Can you describe for me why the difference would be that the McLeod's property would be assessed at around $1,800 and the McLeod or the Hitchens property would be effectively fully assessed for these improvements?
When the district was being formed, I remember there's some discussions with Mr. Lamson and Howard Holton, who was at the time the excuse me, municipal engineer and the director of project management and engineering. The McLeod's property had curb and gutter and pavement across a good portion of the property. The access, it went past their driveway, and they had full improvements for access onto the property. And at that time, prior to the actual formation, and I think it was Mr. Holton that did it, is they agreed that they would be assessed at a rate for the additional curb and gutter that was going to be placed in front of their property.
Mr. Hanson, you were here in the audience while, I believe, while Dr. Hitchens was testifying, but were you here during the deposition of Mr. Hitchens?
For a portion of it, yes.
Okay. Are you familiar with the email exchanges that have been highlighted here today between, apparently, I believe, your department, Mr. Lamson, and some emails between you regarding the potential agreed upon lower amount of assessment?
I saw that email when it was put up there. I don't remember it. I did see that my name was on it, but I don't specifically remember that particular email. I do not think that there was an agreement made. I was in one meeting with the Hitchens, Mr. Lamson, and I believe it was a couple of the assembly people from the there.
Okay. Mr. Hanson, Mr. Hanson, next to you there's a binder in which there's Exhibit 105. Could you please pull that up for me? 105? On page 2 of 2, when we start with the initial email sent from Jim Lamson to Sheila Selcraig, Harriet Drummond, Cliff Hitchens, on that you're CC'd, Mr. Lamson, what was his position in relation to your position with the municipality? Are you his supervisor?
Jim Lamson, supervisor?
Yeah.
No, I was not.
Okay, so what was your position in relation to him? Why would he be CCing you on this particular?
I was Howard Holton's deputy director at the time, and primarily my responsibility was project management and engineering, so it was part of the, this would have been a project. Also, I had been in a previous life with the Public Works. I had been in charge of preparing the final assessments for projects, so it's probably just more of a courtesy. I can't answer specifically why.
Okay, and Mr. Holtman that you referenced, can you tell me what his position was?
He was the municipal engineer, and at that time, project management and engineering was a separate department, and he was the director of that department. Okay.
Do you recall seeing, it looks like this exhibit, page 1 starting of page 102.
Excuse me, what?
Exhibit 105.
105, it says one of 6, but you're saying one of 2?
Oh, I'm looking at the top. I'm sorry. So it's one of 6.
Oh, okay.
Yeah.
All
yeah.
right.
Sorry about that.
All right.
So on one of 6, there are. It appears to be 3 separate emails on page 1 of starting on page 1 of 2, in which you are CC'd on each of these. Do you recall any of these emails?
As I said before, I don't specifically recall these emails. I was when I saw this earlier, but I don't remember the emails themselves.
Okay, now let me back up just a little. With regard to this specific project, what was your specific role in helping determine these assessments? Or did you have a specific role?
I did not have a specific role. As my understanding, the assessments or proposed assessments were calculated how the codes, the municipal code laid out how that was to be determined.
Okay. Since I was hoping Mr. Hansen was going to be one of the ones to tell me that he is the one or was helping be responsible to determine whose assessments are. It's obviously. Yeah, go ahead.
Yeah. I mean, the only thing I remember about this was the meeting with the Hitchens that we have. And as I said, with 2, I think it was 2 assembly members at the time, and Jim Lamson, where the adjustment that they would be looking for was discussed. And I'd have to say, I remember telling everybody at the meeting that, first of all, that this was, I don't know if this is something that the administration would be willing to propose to the assembly, because it would be it was a change in the amount of bond funds that would be paid back. And second of all, that the administration did not have the authority to do it, that it was the assembly, since the district was already formed, and my reading of the code on special assessments is that the assembly is the one that has the authority to make adjustments after it's been formed for inequities or whatever.
Do you have any knowledge that this issue was ever brought to the assembly?
As I said, there was, I think Harriet Drummond was at that meeting. It looks like Miss Selcraig was there. I don't specifically remember one way or the other what she was. I did discuss it briefly in just asking of Mr. Hall, that became the assembly person for that area, if they were going to do it, if he planned on doing anything, and I remember him saying no. I don't know why, but they said
Okay.
no, or he said no.
Okay, I think Mr. Evans has a question for you.
Sure, certainly.
You sort of answered my question already, but I will ask. I thought in the documents we looked at, there was some point where this issue of the Hitchens property was raised to you, and their claim that there was a diminished value, if anything else, or they didn't gain any value. And does that sound familiar? And maybe it wasn't you. Maybe I'm mistaking who it was. It said that you raised an interesting point and that you were going to look into it.
I don't remember that. But
I don't remember what specific document it is, but you indicated before that your previous position was in charge of assessments in some way?
Yes, but that was quite some time ago.
In that position, did you were in charge of assessments for RIDs, WIDs, LIDs?
Just RIDs.
Okay. No other questions.
Mr. Trini?
Jerry, you were Howard Holton's assistant, you said earlier, this time.
Basically, he was the deputy director for
Did you
PM.
see this letter that he signed on the amount of money he was lowering down from the clouds?
I don't recall if I ever saw it. I knew about it.
1493.
Pardon me?
It was down to 1493 as an assessment. So you didn't see it, but you remember hearing about it?
I remember hearing the discussion on it, but I don't know if I ever saw the specific letter. I may have, but
When did Howard pass away? Do you remember the year that happened?
yes, it was 2007.
But you don't remember anything dealing with the Hitchens property, you don't remember anything with the Hitchens property, discussing that with Howard either? With their
No, I
lawyer?
don't.
Okay. I was trying to figure out why the McLeod was treated one way, and it seems like the Hitchens just dropped off the planet.
I think the reason for the McLeods was that they had curb and gutter and full asphalt improvements across there was half or so of their frontage of their property, and it went past their actual driveway. Which was considered full improvements, which is curb and gutter and sidewalk, which was not sidewalk, excuse me, asphalt, which was required by for those properties in the slide districts by AO 78. It was an assembly ordinance that said certain properties in the slide area had to have full improvements.
And you don't have any evidence this thing that dealing with Hitchens ever came to the assembly at all?
I
It was
don't
never
know.
presented. Okay, thank
I
you.
don't. After that meeting, I don't know if they ever came to the assembly or not. I never attended those meetings. No, sir.
Well, thank you.
Mr. Owens, during your deposition of Mr. Hitchens, you referenced an email. I believed it to be from Mr. Hansen describing the differences between lots 10 and lots 11. Can you direct us to that email?
Yeah, I believe it's this one you were looking at, Exhibit 105. And in particular, I was referring to the first paragraph on the second page, where it reads, while the improvements abutting the Hitchens lot 10 are substantially greater than the upgrades to the adjacent lot 11, we've been asked to calculate the assessment on the Hitchens property using the same approach.
Okay, so it wasn't a separate email, so I'm...
Right,
Okay.
you're looking at the same one. I was just pointing out that even Mr. Lamson acknowledged that the properties were different.
Okay, thank you. I have no further questions. Would either of you like to query Mr. Hansen at all?
I don't have any additional questions.
Okay, thank you. Mr. Staley?
First of all, with regard to Assemblyman Evans' question about were you at some sort of a meeting where there was a discussion about the fact that this raised an interesting question. Again, if you'll look at Exhibit 105 at the bottom, this is Mr. Lamson's email sent to a number of people, including you, following up on the meeting. And if you look at the middle paragraph, it says, discussion focused on whether the benefit received by this property was proportionate to the assessment, and the amendment discussed was to eliminate or reduce the assessment on Lot 10, Block B, Simonson Estate subdivision. The benefit question on this property is very interesting. The issue of adverse impact on an existing home at the end of a dead-end street when the street was extended is not addressed in the code. It is also unique in that development restrictions established prohibited homes, blah, blah, blah. Do you see that?
Yes, sir.
So apparently Mr. Lamson's recounting that this discussion in fact occurred at that meeting. Is that right?
It appears so, yes.
And you just don't really have that great of a recollection of the meeting, apparently.
I do have a fairly decent about, especially about what I said.
Okay, but you don't recall that, or?
Yeah, I recall something about that.
Your testimony to this panel, sir, is that there was full pavement and curb and gutter in front of the McLeods, and that's just simply not true, is it? Prior to these improvements.
That was my recollection of why Howard Holton did this, is that there was curb and pavement at least past the driveway to that property.
If you'll take a look at Exhibit A12, sir.
I'm sorry, I'm not familiar with your exhibits.
They're on the notebook.
This? Okay.
And you can see that this is a pre-improvement photo, and you can see Lot 11, the McLeods, and you can see, it certainly doesn't appear from that photo that there's any curbing, correct?
Well, I can't specifically tell. This is not...
Fair enough. Take a look.
Plus, I don't have my reading glasses on.
Fair enough. Take a look at Exhibit I3.
I3?
Yes, I3. Page 2 of 2.
Right.
And sir, I'll represent you where you see that little balustrade with the reflector on it on the right. That's the McLeods there.
Okay.
And I don't see any curbing in that area, do you?
Well, I can't quite tell. It doesn't appear to be right there, but I can't quite tell.
Okay. And then if you take a look at A14, A14, this is afterwards, and you can clearly see that the road was completely rebuilt all the way in front of the McLeods with curb on each side, correct?
Looks like it. I'd have to look at the plans.
Okay. And then if you'll take a look at Exhibit I4, I4, and if you'll turn to the second page, this is Mr. Lampson's first email to Mr. McLeod back in October 2003. Responding to Mr. McLeod's inquiry, and he says, Lot 11, Block B, that's Mr. McLeod's lot. Your lot is included in the road improvement district because the road is being upgraded in width. It's going to install curb and gutter, and the road base is going to be completely replaced along the full frontage of your lot. Do you see that?
Mm-hmm.
Okay. And so you don't know that there was curb and gutter in front of that lot ahead of, before these improvements, do you?
I didn't specifically look at it. I think I was told that was the reason it was done that way.
And in fact, again, looking at A12, we can see that that existing road barely came to the first part of the McLeod's lot, and then it was a dead end. Basically, you had a dead end, and you had two driveways and a trail coming off of it, correct?
I can't quite tell, but it appears
I should loan you my reading glasses. And,
tough to get old.
And if you look up here, sir, this is the lot line between the Hitchens and the McLeods. And so you can see. Yeah, it is. The lot line between the Hitchens and the McLeods. The lot line between the Hitchens and the McLeods. Exactly, that's exactly where I'm pointing, Bob. Agreed? I agree. Okay. So that's the lot line between the Hitchens and the McLeods, and so you can see that that road, Marston, dead-ended just barely onto the McLeod's property, correct? Maybe a third of the way, correct?
It looks like
here's the one end of their property, here's the other end of their property, and the road basically dead-ended right there, correct?
Yep.
And then the road was completely rebuilt all the way across their property, new base, new pavement, curbs on both sides, correct?
Yes.
And notwithstanding that, your boss agreed to reduce the assessment for the McLeods to roughly $1,800. I think it was $1,300 originally, and I think it later went up because of the increased costs. But correct?
It looks like it, yes.
And then he passed away in 2007, correct?
Yes.
And nobody had even contacted the Hitchens at that point. The Hitchens had been writing since 2003. The Hitchens wrote in October of 2003, but nobody had even contacted them at that point, so your boss never even got a chance to consider the Hitchens request, did he?
I don't know.
No further questions.
Thank you. Is there any follow-up, Mr. Owens?
Just a moment. I would simply point out that on this same photograph A12.
In the microphone, please.
Yes. On the photograph of A12, the road extends, as Mr. Hansen testified, to the end of the driveway of Lot 11. He had access. It's consistent with what his testimony was originally. And similarly, on I-4, the email from Mr. McLeod, page 1 of this exhibit, verifies Mr. McLeod's statement that his property, Jim, I am resending this document as the first version left out the fact that part of my lot already has curb and storm drain. There was curb and gutter to Lot 11. It didn't extend all the way through. His testimony was consistent. It went at least to the driveway. His testimony was consistent. And so those attributes existed on that property. He was being honest and truthful. As for other aspects about justifying this property and comparing it to the others and the fact that it dropped through the cracks and all of that, it's true, that happened. But as far as his testimony and his validity, he's an honest man, and this will help prove that.
Any further comments from either of you? No? No for any further comments from the panel? No? Mr. Hansen, thank you for your testimony. Mr. Staley, your next witness.
Chuck Spinelli.
Mr. Spinelli, please state your first and last name for the record and spell your last name.
Charles Spinelli, Spinelli.
Thank you. And if you'll please raise your right hand and face the clerk, she'll swear you in.
Do you solemnly and sincerely swear or affirm that the answers you will give to the questions asked of you in these proceedings will be true?
I do.
Good afternoon, Mr. Spinelli. I'm sure a number of these members of the panel might know who you are, but go ahead and please tell them who you are, your background, how long you've lived in this community, and what you do for a living, sir.
Well, my name's, and I go by Chuck Spinelli. I have lived here since 1984. It was November of 1984. I was interested in Diddy's 10 years longer than me, but that's been 30 years. I was raised in California. My father was a contractor. He died when I was pretty young, but at any rate, I went to school. My father told me never to be a contractor, so I ended up with a teaching credential and working for the city of San Jose as a parks and recreation leader for about 10 years. Before I started teaching, or as I started my teaching career, I continued. In 78, I moved to Idaho and worked for my brother-in-law, who was a contractor, masonry contractor like my father was. And I spent a few years there, and then I got transferred up here with Bowen Construction in 1984. And in I worked for Bowen as the division manager, built 1,500 houses. The Depression hit in '86. I had a choice to stay here or go to Arizona or some parts unknown, and I decided to stay here. And fortunately for me, my mother loaned me a couple $100,000 that got me started in my business. And from there, I started Spinell Homes, and since that time, I've built 3,500 to 4,000 houses in Anchorage Bowl and the Matsu. I've also done a lot of development. I got some of this experience when I was in Idaho. I was a contractor, and then I worked for Central Premix Concrete Company, which was a concrete company that we used to do excavation for. So I got to know the excavation business quite well, and I'd known the masonry business since I was a little tiny kid. So at any rate, my involvement in this project.
Well, sir, have you as a part of your development, have you undertaken to build roads and things like that?
Yes, we've probably put in, 15 or 20, 30 subdivisions. I've been just a developer where I hired excavators to do it. And then at one point in 1995, I had an excavation company, Paisanos Dirt Works. My nephew had moved up here from Idaho, and we ran an excavation company for 10 years until the last crash. And I did, we actually did the excavation work for the subdivisions. And so I'm really familiar with how this business works from the ground up.
Well, let me ask you, sir. When you did subdivisions like that, and you would go in and put in road, water, sewer, and that kind of. First of all, if you do a subdivision and you're going to put in road, water, and sewer, has the municipality ever let you get away without putting in the shallow utilities?
No.
Okay.
You can't even think about doing that in the municipality.
But let me ask you one other question. So, when you do that, when you develop a subdivision and you put in road, water, and sewer, generally speaking, you've got construction costs, and then you've got other costs. You've got your design and your engineering and stuff like that. Is there sort of a rule of thumb in terms of, if the construction's going to be $1 million, is the design and engineering a certain percentage of that? Is there a rule of thumb if you can?
Well, I don't know that there's a rule of thumb of that, but for some of the subdivisions a lot, most of the subdivisions that we do, we have a pretty good feel for what this is, and we have, kind of budget numbers in our brain. And so, in today's market, for instance, I'd say the development cost of, like the stuff we just did in West Park, the development cost was $55,000 per unit, and the engineering and so forth was about $5,000.
So
that's like 10% or so.
Okay, so 10% or so, okay.
Yeah.
Fair enough. Go ahead. Your involvement with this project, sir?
So my personal involvement started in 1989 when I bought 3 lots on Sandstrom Drive, which is right next door to this property. These are lots that had been that went down in the earthquake. Al Sandstrom had owned them, or Bergstrom. He was a New York Life agent, and they went down in the earthquake. His house was ruined, and it later resold. And then somewhere in around 1981, this guy Huckabee bought the property and developed it. And when he developed it, he developed these 6 or 7 lots, or 8 or 9 lots, I should say. And my lot was one of them. And when the Great Depression happened in 84 and 85, or 86, I had, just started my business in 1987. It was like 89, I came along. A friend had brought these lots to my attention, and I bought the three lots. There were 3 lots on the lot 2, 3, and then one up on the corner on McKenzie. And so I proceeded in 1990 to build my house, a house there, and I lived there for 10 years, and then I sold it and moved next door. So I live on lot 2 of Sandstrom right now. So I've been aware of what you need to do to build houses in that subdivision. Basically, when I started my first house, I was at NBA Bank, and Rasmussen was there, and they were telling me how stupid I was because I'd never build on it. The geotechnical committee would never allow it, and the neighbors would go crazy. And we kind of lived with that for the whole time we lived there. I mean, we still live with that. And there are certain people that were traumatized by that earthquake that just never think that land could be built on. But it's a pretty cut and dried situation. Once the roads are put in, which don't need a lot of scrutiny, you just get the roads put in. You could, on a pre-approved subdivision such as this one, which was already existing, you would do it with a right-of-way permit. There would be no subdivision agreement. There'd be no platting process. It's just a matter of getting a right-of-way permit, installing the water sewer lines.
And when you say this one, you're talking about this?
Both of these.
Okay.
The one that we're talking about today and the one that my subdivision was done. And I've done some subdivisions like that myself.
And that's because there were pre-existing plats.
It's it's like a paper plat.
Okay.
Right. And those paper plats are approved, and so you don't plat them, you just build the improvements. So there would have been no geotechnical committee involved in building these roads. And once the roads are put in and you start to build a house or build a structure, public structure, then you're going to go get the Geological Advisory Commission involved. And so every time you build on one of these lots, you have to have 3 test holes. They've got to do a slide analysis. In the old days, it cost $5,000. On the last house I did, it cost $16,000 in a year's worth of time, basically, to go through the geotechnical committee.
And where was that house?
Lot 2, Pete's Place.
Okay, so you're now talking about even after this area got developed, the way that it got developed, when you wanted to build a house on it, you still had to go through this year-long process to get blessing, if you will, from the
Geotechnical Advisory Committee.
From the GAC, the Geotechnical Advisory Commission, to build a structure, correct?
Correct.
And it's your understanding, sir, that what the Geotechnical Advisory Commission is concerned about is when you build the structure, not the roads, correct?
Absolutely. There is no supervision of building roads. The only supervision comes in is when you build a structure.
Okay, sir, I want to stop you just there. I know that you've got more to tell me, but I'd like you to take a look at Exhibit 101. And I'd like you to turn to page 7 of Exhibit 101.
Yes.
You have that?
Yes.
And that is,
This email kind of confirms what I'm saying.
okay, so that is an email from Mr. Nuss, who we've heard from quite frequently in this hearing, to VEI and others, Mr. Oswald, a number of others, dated September 27, 2005. And he says, I have done some additional research based upon the discussion with the GAC today, going by AO 7884, development in the area is prohibited unless the Director of Public Works, yada, yada, yada. And the panel should please take its time to read this whole thing. But I want to draw your attention to the middle paragraph, last sentence, that says, these requirements relate to the construction of buildings and not roads and utilities. Last paragraph. Based upon the above and briefly looking through the municipal code, I do not believe we are required to show slope stability for the road, water, and sewer improvements. That's basically confirming exactly what you've said, isn't it, sir?
Yes. And, this, hit this however thing at the bottom, I guess, is his justification for bringing in the GAC about the homeowners may be unwilling to develop the properties without it. These homeowners, every one of these lot owners, knew the history of this property. They either owned it during the earthquake or they bought it because it was earthquake park or parts of it, and they were willing to do it. They'd seen, that we'd built houses there before on the property that was just reclaimed to the north and to the west where my house is and where Rasmussen was on the east. And so they're all acutely aware of the process here.
And not only that, it's not like Mr. Nuss came to you and said, gosh, we don't have to go to the GAC for your road, water, and sewer, but would you like us to? I mean, he never sought the property owner's permission to open up this can of worms about the GAC for the road, water, and sewer, correct?
No, he didn't.
And yet he acknowledges here that it was not required by the law, and that's consistent with your experience.
Yes.
Okay. And so I interrupted you. You were talking about your involvement.
So I built houses, on my lots. I've seen the soils reports. I've done what you needed to do to build those houses, and I was watching this project, kind of with bated breath, waiting for something to happen. Finally, in 2003, Matt Fink came along to me, showed up in my office, and said he had a plan. And he and all these homeowners have been trying for years to get this development going, and they just couldn't get the muni to do it. They couldn't, they were totally frustrated. And they said, would you be willing to, be the developer and develop this property? And I said, yeah, I'd be interested in doing that. And so we spent, a couple of months or so talking about how we could do it. I hired an attorney, David Schmid, to come up with this idea of how we could do it. And basically, in a short form, I was going to take these properties in on, quitclaim deed so that I could finance the project. I would build all the roads and sewers and everything for a fee of $150,000. And when I was done, I had to pay the loan back. And so each owner would have had to go to a bank and get a loan for whatever the development costs were based on my estimate and so forth. And so we drew this all up. It cost me, $10,000-$15,000 to do it. We sent a letter out to all the home buyers in the area, or lot owners, I should say, and said, look, we're ready to do this, do you want to do it? And prior to that, we had, part of my due diligence is I got a right-of-way permit to go through the right-of-way, and that's where I first met the Hitchens really up front personal, because I was in their yard digging test holes along where this road was going to be, because I really wanted to be convinced that you could build the road and do it, at some price before I started, doing all this stuff. So
you actually undertook the cost of boring these test holes?
Well, I didn't bore them. I dug. I don't believe in boring test holes. I believe in digging them with a backhoe, because in this area, there was so much rumor about what went on here, and I saw, three big holes dug on Sandstrom. My house, the house next door, and the house next door, Tony Kilpatrick's. I built them all. I saw all what was there, and I knew what was there, and so I wanted to make sure that this area, because if you look at the photographs, it's a lot different over on that side, because it was just so much more. They had gained 3.5 acres of land, and when this quake went down. So I went over there and went along the road every 300 feet and dug a test hole, a pit, and saw what was there. And what I found was sand and a clay layer below it. And that's what you'd expect there, is sand and clay. And a lot of the soil reports talk about a mixture of those two, and I think that that's at a depth below, the 15, 20 feet we were digging. So at that point, I was convinced that we could build a road there. I just built some similar subdivisions. It was a pretty straightforward, straight-through shot. We expected to put a lift station at the far end by Linary Park and pump it back up on 4 acre and connect in. I'd done a similar project in Rebecca Scott off of Clatt Road. We'd done the lift station, was like $150,000. I had these numbers, in my desk, basically. And I had PTS, Professional Technical Services, give me an estimate of the engineering costs. And, we had the whole package put together. And with the utilities and all, the gas, electric, and everything, it was $1.9 million. And then
so that was $1.9 million for everything, including the shallow utilities.
Including the shallow utilities, interest carry, the whole 9 yards. And so at 31 people, it was like $60,000 per lot. And it was a bargain. And, so Matt was telling me, you've got to get involved in this thing. You've got to be more involved. And he had this lady, Tucker, that had a lot there in lot 8. And she was trying to sell it for $50,000. So I said, I'll buy it. I think that this is going to go. This is going to happen. So I bought the lot. And so he really had me hooked at that point. So, we went along and notified all the home buyers, got everybody's consensus back, and there were like 5 or 6 people who said they didn't want to do it. And so the other 30 or 25 people said, well, if they're not going to do it, we're not going to do it. And I was going, look at it, it might be $90,000 per lot. It's still a really good deal. We should just do it. We won't have to put water and sewer to their lots. They'll have the road in front, but, let sleeping dogs lie. It would be good for all of us anyway. And I was outvoted. They decided, well, we're going to, if all for one for all, we're doing an RID, LID, which I didn't really want to be involved with because I thought something really messed up could happen, and sure enough, it did. But I owned a lot, so I had to participate in some degree.
And so when there was a ballot that went out do you approve this going forward with an LID or RID? I assume that you agreed to go forward.
Yes,
with that.
I agreed to go forward.
Okay.
I mean, I'm all for one for all. I mean, that's the way it is. So we did that, and so we had Plan B, which was the RID, LID. And, we believed, at least I believed, from my time in public service, that the municipality would treat us fairly and do the right thing. And, I was totally disappointed to find out how this all transpired as we learned more. But, putting the AWU in charge of our subdivision was a huge mistake. And they had a separate agenda, we had an agenda, and I think what happened is their agenda got pressed and we got shafted, basically.
Basically, there was a conflict of interest there. I mean, AWU had a separate project they were interested in pursuing, and by co-opting your project and bringing it into theirs and letting them more or less oversee it, they were able to influence how these projects the money would be allocated between them, correct?
Yes, and I think that, the thing that, the most glaring mistake that I see is this deep water trench and this subdrain that just really, really, really makes me upset, because when I went to go to build a house and connect my daughter's drain to this $1 million drain system, they didn't bother to put a stub out for us. Now, in any other subdivision that had water problems, there would be never, the Public Works would never let you do that without putting the stub outs. And maybe their philosophy was, that this is just going to solve all of that, but that drain is at 40 feet or 25 feet. Our houses are at 10 feet. So whatever water comes to our houses, it's going to be around our houses, and then it's going to have nowhere to go. And where we're going to put it is in the street where they don't want it. And so we have to hide it, when we're doing these things in order to get rid of the water, because you're not allowed to put it in the sanitary sewer. So, I don't mind paying $1 million for the thing, but at least they could have had the common courtesy to give us the value out of it, which is that $3,000 drain. But
so let me back up, though, because I know that you understand this, but I want to make sure that the panel understands this. And so if the real purpose of this subdrain was for the homes in the subdivision and not for the pump station, you would have expected there to be stub outs, correct?
Yes.
Because you have drainage issues around the houses, correct?
Right.
And the fact that they put this deep subdrain in and they put it so deep, that assists down at that level, 25 feet or whatever, but it doesn't necessarily assist you at 10 feet where your foundation is or your basement is for your home.
No, all the drainage is going to go, if it goes to that subdrain, it has to go through our property to get there, or through our homes to get there, which is absurd. And the thing is, if you study this earthquake, and I know a lot about it because I've had to defend building there a lot, those blocks of clay, and they're talking about blocks of clay 100 feet long that are moving, they're down at 80 feet below the surface. They're not up at 40 feet. You're not even, so putting the drain in there is not doing anything other than helping that lift station, keep water out of the lift station, out of the wet well. So us paying for that is just obscene, in my opinion.
So by having this deep subdrain, and it's not just put slightly below the level of the sewer line, it's put 5 feet below the lowest utility. And by having it that deep, it does assist the deep wet well on the pump station, correct?
Yes.
But it really doesn't assist the homes.
Right, well, the sewer line goes from our line to the wet well, so it's 5 feet below that wet well all the way to the wet well. So it just takes all the water out of the wet well, or for the wet well. So, it is just totally frustrating that you would put your trust in the municipality of Anchorage and AWWU, and then come to find out what they did was just push the bill over to you. And I've done a lot of talking with Matt about this. They charged us $7.8 or $9 million for this thing. They got $1.5 million for
grant money
for the grant. And the construction contract was $7.8 or $7.9 million they paid to Pruse. So really, they had $8.4 million, and they only paid a contractor $7.9, but yet we're getting charged 7.8 or whatever that number is to do it. So we really paid for 100% of this thing, except for what came from the state. So the AWU got a lift station for free. And to me, that is obscene. And so, I have a couple more things to say. This development, the municipality has stumbled or just got in our way and created havoc for us since day one. And I found out the reason is because the guy who was trying to find out who owned the land got here in 1990 or 2004, hadn't been around. He didn't know that land belonged to the homeowners. So he goes to Heritage Land Bank and asks them who owns the land. Well, when I bought my property over on Sandstrom in 1989, I got 2 deeds to my property. One deed showed the original lot, which was a 1949 plat, and a second deed that showed from my lot line to mean high tide. And I'm a builder. I built 1,000, 1,500 houses. I'm going, what is this? Why are there 2 deeds here? So I called up the title company. I said, what's the deal with these 2 deeds? I mean, how did I end up with 2 deeds? And they go, well, when the Tony Knowles Coastal Trail came through, the city realized, and they were looking close at what was going on and who owned the property, and they realized that those lot lines extended to mean high tide. And all over the West Coast, they told me, from the border of Mexico to Alaska, there were plats done in the old 40s and 50s that when the surveyors did it, they didn't walk out in the ocean on a high tide and mark the ocean when to where that lot line was. They would just go along the coast and put the lot lines in. This was 1949, and so that's the way these plats looked. But the plat intended and the I forgot the thing that they call you, the patent that you get from the government. Those were to mean high tide. So the city knew back when Huckabee owned my lots, and when they put the coastal trail through, they got an easement through that second piece of property to put the coastal trail in. So I'm entitled to that property. They have a coastal trail through it. So this property was right next door to it. It's exactly the same stuff. And if you go on Anchorage Live and you look at, the way the property is divided, you'll see on my properties in those Sandstrom things, it's blue all the way through both lots so that the city knows who owns them. But all of a sudden, the AWU wants to buy the property, and I think, in my mind at least, they're thinking, well, we could deal with one person or we could deal with a lot.
Okay, so again, let me just back up. So you're talking about now about the Simonson Estates and the fact that, and I think that we saw it. I want the other. Looking at Exhibit A6.
Is that in here?
You're talking about this area out here. You can look up here, Chuck. I think you can probably see it. So you're talking about this area up here.
Yes.
And so you can see here where the new pump station site is, correct?
Yes.
And so what you're talking about is that sometime in 2004 or before, the municipality attempted to contact one person, instead of all the owners of these lots, they attempted to contact one person to acquire that land to build the pump station. Is that what you're talking about?
Yes.
Okay.
Selma Simonson was the
Selma Smith.
Selma Smith was
the heir
of the Simonsons, was the clerk at the municipality of Anchorage back in 1950, and her parents had died. That was their homestead. All the brothers and sisters did a trustee's deed to her to develop that property. She developed it into Simonson Estates, and they sold the property in the 1950s to people. It was on the bluff, and there was that 35-foot bluff there, and they went on their way. And so we had to have this court case because what the city figured out was, well, because the plat wasn't clear, it just had a little squiggly line there. And said, the mean high tide, that they didn't sell that property to us. Although, there was a couple people there that were the original owners that said, yeah, they sold us bluff property. When Selma Smith took the trustees' deeds, she got all of the trustees' deeds. When she sold the property, all of the property was gone.
Chuck, I'm gonna cut you a little bit short here because we got to wrap this up today.
Sorry.
So at any rate, there was litigation. So the municipality went to the heirs of Selma Smith, attempted to buy that land. As a result of that, there ended up being litigation as to who owns it, and eventually the municipality condemned that.
It ended up in the Supreme Court, and we prevailed. Yeah. And the thing that I say in the Supreme Court is that they came back saying, look, although the plat isn't very clear. And obviously from the look of the plat, your lot stop here, but it's obvious that you own to the mean high tide. Okay. So we owned, our lines extended to the high tide, and that was the end of that. We thought that was the end of that. So that's the first thing that really irks me about this municipality.
No, but we don't want to get too far afield here, Chuck.
Well, can I just mention the other things?
What's that?
Well, they turned our purse strings loose to AWU.
That's more relevant.
That's number 2. And number 3, today, we're still arguing with the tax assessor on this property.
Okay. Let me just ask you real briefly. When the original assessment or original estimates came out to build the RID, WID, and the LID, it was roughly 3-point-something million, which seemed high, correct?
It seemed very high to me.
When they at some point they came up and they said it's more than doubled to more than $7 million. Do you recall that?
Yes.
And were there discussions where they basically, I'm sure you expressed some outrage about that, correct?
I just thought they were completely off. I mean, right. I thought my opinion was this isn't true. When they actually bid it, they're going to find out what the real deal is, and we're going to go on. We didn't know about the lift station as part of the program.
Okay, and so that I guess that was my question. When they came to you and said that they had new estimates, did they say that, gosh, we're doing this lift station and AWU is now combined these projects? They've got the same design engineer, and we're working them together.
No, and from our position, we were thinking, God, this lift station's going forward. So they're putting the lift station in. That means we're not going to have to put in a lift station, and we're going to save money in the long run. Right. That's what we were thinking.
So you didn't realize the way that they were basically had turned your project over to AWU to design and develop these, commingle these together, if you will.
Right.
And did they tell you that you would be did they tell you that you would be kept abreast, that you would be allowed to encourage yourself or others to bid for the road?
Yes.
Okay. And when was the first notice that you got that they had combined these and were going to put them out into a combined bid?
I think it was right before the bid came out, days before.
June 23rd, 2008, I believe. We've seen a letter of June 23rd, 2008.
Yeah, that's when we found out. And
3 days after the invitation to bids went out on June 20th, 2008. And that's when you found out.
Yeah.
And then when you found out that only 2 large general contractors had bid, and that one was going to be allowed to withdraw, did you tell them, do not go forward with the WID, LID, and RID? Let's rebid this. This is crazy?
Yes.
Okay.
Matt and I went in there, had a meeting, said to stop. We didn't want to be involved in it. There was somebody said that it doesn't matter to bid in June. I'm in that business. I know that you bid in January, February, and the longer you wait, the higher the bids, because these guys get booked up, and so then, or they've lost every bid until then because they're the highest bidder, and then you finally, they still need work, and you get the highest bidder finally bidding on it, and that's exactly what we had.
No further questions.
Mr. Owens?
Mm-hmm. Good afternoon, Mr. Spinelli.
Good afternoon.
I just want to clarify one aspect of your testimony. We've met before, and I've been involved with the litigation involving the Selma Smith case and with the adjacent parcel. Really, those have very limited relationship to the present proceedings, although in your testimony, I just wanted to confirm that you were talking about the Selma Smith parcel. Was this part here adjacent to Pete's, and it kind of runs down to this line down here, correct?
Yes.
And the pump station ended up getting taken from, or placed right over near Pete's place.
Yes.
And part of the way that that land was acquired was by the municipality condemning that parcel, isn't that right? It was through condemnation.
Domain, yeah.
Correct. And in fact, the litigation involving that parcel, the municipality didn't claim any interest in that land except for the easement along the coastal trail, isn't that right?
Excuse me? Say that.
The plaintiffs, the real parties to that action were the estate and the heirs of Selma Smith and the owners of the upland property.
Well, the municipality was involved to begin with, but we made a deal with the MOA to give them everything south or north of the 64 high tide line.
The original high tide line.
High tide line. So they stepped away and just let us fight it out with
Right.
Selma.
That was the only area of contention that the city claimed an interest in, was down near the beach and where the coastal trail is.
No, they claimed they said they owned the part that they were trying to sell to, well, they didn't say they owned it. They said they thought that Simonson owned it.
Well, we were trying to figure out who owned it.
That's sort of a mystery to me, since you knew that you had owned, or, you know, the lots next door on Simonson where I am, you knew that in 1980 that they belonged to the property owners.
Well, in any event, the real litigation involving this property started out with the heirs of the estate of Selma Smith on one side, the property owners on the upland lots on the other side, right?
Well, I thought the muni was in that
the
lot.
municipality was named as well.
Yes.
And the municipality came in and asserted an interest in the area where the coastal trail was, worked out a deal, and then backed away. Isn't that about right?
Yes.
Okay. And then after the case was resolved and title to the property was finally resolved, then the condemnation occurred and the city acquired the pump station parcel.
That's true.
Okay.
It brings up another sour note, you know, on this tax thing, that they were allowed to sell the property to, or give or pay lot owners 1, 2, and 3 money that the city now says is owned jointly by all of us, but they only dealt with the 4 that had lines that intersected it. So,
and I understand that's a bone of contention, but as far as what we're dealing with today, it really isn't pertinent to the question now of the pump station. And I'm not trying to be disrespectful.
To us, it's very personal and it's very pertinent.
Okay.
Maybe not to you.
Okay. So moving on from there. You testified earlier that you had an idea and a plan for doing this development of the road, water, and sewer in the Marston Forker area through the private development process. Is that right?
Yes.
And at some point it became apparent that not all the owners were going to agree, and so the decision was made to go with the special improvement process instead.
Correct.
And by doing that, you knew that when public works process, it generally can cost a little more than the private process.
Yes, I would agree with that.
So you knew that going in.
Yes.
Did you know, as a developer, do you monitor and keep track of kind of areas of town where development is occurring and where roads might be extended and what land might be coming available over time?
Yes.
And in that process, do you monitor the capital improvement program or some other development plans maintained by the Public Works Department for roads?
Not really.
But you just kind of keep your ear to the ground?
Yes.
So in that context, did you ever see the Marston Drive Road on a future development list? An area that the city intended to expand?
Not that I know of, no.
Did you have any reason to believe that the municipality intended to build that road itself?
But we asked for an RID, so I believed it when we did
Sure,
that.
but on its own, without the improvement district, through the Capital Works project.
No, it would. There was no interest in that.
So the odds are that the Muni was not going to build this road unless the owners of the adjacent properties requested it through an improvement district.
I agree with that.
Now, you testified that you came up with an estimate of about $1.9 million
Yes.
to do this work. Did you include deep subdrains in that estimate?
Deep subdrains?
Yeah.
No.
Did your estimate include Davis-Bacon type wages that a public works contractor would have to pay?
Well, they wouldn't have been necessarily the Davis-Bacon wages, but road construction contractors, when in our business, had to pay those wages or we wouldn't get operators. So even though we didn't classify them as Davis-Bacon, we paid high wages because if you didn't, they'd all go to work for the union contractor.
And honestly, I'm not trying to suggest that you're anything but fair with your people. I'm just wondering, in terms of the overhead, the labor expense, it might have been less in your account than it would have been in a public sector. And I appreciate your answers. They're probably pretty comparable.
Yeah, I would expect our bid to be, or my estimate to be probably 30%, 40% lower than if it was done as a straight project by the MOA or somebody.
Okay, good. Did you ever update your 1.9 value? Was that prepared in around 2003?
February 18th, 2004.
And did you ever update those figures to 2008 values?
No.
Okay. So would you agree today that the value of the road would be at least your estimate moved up to 2008 values?
I would say it'd probably be in the neighborhood at $2.2, $2.3 million. I mean, we're developing similar stuff right now in West Park at $60,000 a lot.
Right.
And that's what this amounted to. But so I would think that you'd be at 85,000 a lot for this to be done today in that subdivision with all the utilities in.
Now, in 2006, when the design study report came out with the revised estimates for the construction costs for the WID, RID, and LID, you examined that pretty closely and reviewed the estimate you had a free access to that and were able to review it?
Look, at that point, I was pretty disgusted with the homeowners for not doing the conservative approach to these numbers. So I didn't do very much. I thought that they had taken control, and I just kind of let them do what they were going to do. And, I didn't get involved until it started getting astronomical.
I see. So fast forward then to the time when the ballot occurred in, I believe it was the fall of 2006, and you voted in favor of creation of the road improvement, water and lateral?
Yes.
And did you do that with having at least some degree of knowledge of what the cost was and acknowledging, recognizing that you were making a decision in context of that new revised estimate?
Yes. I was assuming that that estimate was in good faith at that time, too. I mean, I didn't expect them to be shifting, the certain items to us that really belonged to the lift station. I thought they were operating in good faith. So I had 100% faith in what was going on. And it wasn't until later that I became skeptical of all this.
Okay. Well, understanding your skepticism, you agreed that to repay, if the work was completed on the road for $4.2 million, you agreed that you would pay your share of that money back.
Yes.
And you agreed that you would pay $1.2 million for the water improvement district,
Yes.
your share of
Yes.
it, and your share of the lateral improvement district
Yes.
of $1.7 million. And you knew at that time that the projects wouldn't go forward unless the owners agreed to repay those costs.
Yes.
And you understood that the municipality wasn't going to put any more money into these projects over and above what it already had unless it had a commitment from the property owners to reimburse those funds.
What we didn't know is that the two projects were combined.
But you understood.
That is what we didn't know.
But you understood that the city wasn't going to go forward without the commitment of the property owners to reimburse those expenses.
Well, that's what an RID and all those things are about.
And you understood that your vote was a commitment to pay if the districts were approved.
Yes.
Now, after the projects were completed, 2010-ish, you actually purchased more lots on Marston Drive, didn't you?
Yes.
And in that acquisition, you agreed to assume responsibility for paying the assessments.
Yes.
And you understood at that time, even though the assessments were disputed, you understood and agreed to take the risk that if they were assessed in full, you would pay that.
Yes.
And you were willing to take that risk to acquire those parcels.
Yes.
And that was a free and voluntary decision. Nobody put a gun to your head on that.
Well, my daughter might have.
Okay, touche. So you now have a road that you can drive up to those lots on.
Correct.
And you've got water coming out of the new taps that you've constructed there.
Correct.
And you can use the toilet. There's no septic system on those lots.
Correct.
All of these features were required to develop those lots under the code, that there had to be existing road, water, and sewer utilities before development could occur. Correct?
Correct.
And these homes wouldn't have been possible to build if the road, water, and sewer wasn't actually constructed and installed at the request of the owners.
Correct.
And so far, you haven't paid a dime for the road or the water or the sewer service to those lots.
Well, we pay taxes, but I don't know.
You haven't paid anything for the assessments. It
No, it
hasn't been
doesn't.
assessed. You haven't paid a dime on those improvement costs. So is it really your position that you shouldn't have to pay anything for those improvements?
No, I think it would be fair to pay the fair market value for those improvements, but I don't think we should be paying the amount that's there.
So what do you consider to be fair market value?
Well, I'd gladly pay $80,000 per lot
For the road?
for all of it, road, water, and sewer.
So then your dispute then is just the difference between 80,000 and the actual full assessment for the lots.
Yes.
Now, you understand too that as this special improvement district, the road, water, particularly the road improvement district, was proceeded and went through the assembly, because it was part of the public process, it went a different route than private development would, and it had to receive assembly approval to be implemented.
Yes.
Right? And you understand that it was in the context of the assembly approval that the specific requirement was imposed to route these projects through the Geotechnical Advisory Commission.
Well, I don't think the assembly thought that up. I think that was something done by AWU, who knew that it had to go through there because they were building a building. They'd done the research in '05 and found out that they were going to have to go through the GAC to do it.
But you understand that that was in the ordinance for each of the improvement districts, and the Assembly imposed that requirement.
I didn't know that at the time. I know that today.
Okay. For example, Anchorage Ordinance 2004-2, which was the original ordinance for creating the RID, required a reference to the GAC. And 2002.
The implications of building a building and a sewer lift station and building a road only going through the GAC is like night and day. You know, those things, building a road, you know, is not a hazardous endeavor. Building a house or building a public works building is hazardous. There can be people inside when an earthquake happens, and that's what they're trying to protect life. If you're on a road, you know, it's a different deal.
And I'm not arguing with you on that, but because of the nature of this process and the fact that it did go through the public process, it was subject to Assembly approval, and that was a condition imposed by the Assembly, we can't debate that. With the project manager simply had to implement it. Wouldn't you agree on that?
Well, yeah, if the Assembly requires it, it's the agreement. Our rub is the two projects, if they weren't together, if they were separated, we would have been able to probably avoid that.
Another thing that you were mentioning is the fact that this was a $7 or $8 million project, and fundamentally, you said we paid 100% for this thing. Isn't that what you testified?
Well, the $7.9 million it was a 70-30 split between the city, and then the $1.5 million equaled the, I think $500,000 more than the Prue's construction contract is what I understood.
Nonetheless, you acknowledge that it was a 70-30 split, and the municipality subsidized this project to the tune of 30%.
Yes.
And in addition, the municipality owned property in the district. Linnery Park, the Marston Pocket Park, another parcel as well. Is that, you know that?
Yeah.
And
they didn't pay the money for those. You know, they're collecting the fee from us.
They represent 17.5% of the area within the district, and they are allotted and assessed for the same at the same rate as other parcel owners. You understand that?
Okay, yes.
So in effect, the municipality is paying 47.5% of this project, isn't it?
Or the RID?
Of the RID.
Okay, let's make that clear.
Right. For the water and lateral, it's 100% to the owners. For the RID, though, it's 47.5% paid by the municipality.
Well, the water and sewer are the real culprits with that storm drainage system. It's where we went awry.
Okay, but you acknowledge the city's paying nearly half of the road.
Yeah, 17%.
Plus 30?
I think there's a rationale there that we're going to be paying taxes on that road, considerable taxes.
That's all I have. Thank you very much.
Real briefly, Mr. Spinelli, when they gave you these increased estimates and it was put for ballot and you approved it, again, it was with the it was first without any knowledge that these projects had been combined, correct?
Correct.
And it was with the understanding that it would go out for competitive bid, correct?
Yes.
And it was fully your contemplation that if it went out to a competitive bid just for your project, it would come in substantially under that, correct?
Yes.
It might have been 30 or 40% more than what a private developer could be, but it wouldn't be 240%, correct?
Correct.
With regard to the fact that the Assembly required the routing it through the GAC, the Assembly approved whatever the municipality put in front of them, correct?
Correct.
And so I'll draw your attention to the municipality's Exhibit B12. And I'm going to put it on the board, but this is an amended, I can put it on the board for you, but this is an amended and approved ordinance, and the amendment is underlined, and in fact, the amendment is this particular requirement that it be routed through, correct?
Yes.
And you don't know why it is the municipality asked for that to be amended, correct?
Have no idea.
No further questions.
Okay, no questions, Mr. Owens?
Nothing.
Okay. Any questions from Assembly members? Sure. Okay, seeing no questions, thank you, Mr. Spinelli.
Thank you guys for sitting
We
through all this
appreciate
in
it.
3 days. It's cold in here.
At this time, we are going to take a brief 10-minute break before you call your next witness. And your next witness, Mr. Staley, is going to be, is that Mr. Fink?
Mr. Fink, yes.
Okay, very good. We'll take a brief break. Okay, we'll go ahead and call this back to order. Mr. Staley, your next witness, please.
Grab the microphone. Matt Fink.
Okay, thank you. And Madam Clerk, we are back on the record, correct? Thank you. Mr. Fink, could you please state your first and last name, spell your last name for the record?
Matt Fink, F-I-N-K.
Perfect. And if you would please face the clerk, raise your right hand, and she'll go ahead and administer the oath.
Do you solemnly and sincerely swear or affirm that the answers you will give to the questions asked of you in these proceedings will be true?
I do.
Good afternoon, Mr. Fink. Just please tell the panel members, who you are, your background, what it is you do for a living.
I'm a real estate, commercial real estate agent. Also sell business brokerage. I own multiple lots down in the subdivision in question here.
Okay. And you were instrumental. I mean, you sat through and heard Mr. Spinelli testify, correct?
I did.
And, I mean, do you concur that you were sort of intimately involved with trying to get this developed first initially?
I was kind of the ringleader.
Okay.
Back in 91 is when we first started, actually.
Okay. And I don't want to spend a lot of time because I do want to get through this. I do want to touch on one issue, though, that Mr. Owens raised with Mr. Spinelli having to do with that previous litigation and who the parties were. And indeed, it was lot owners, and you were a party to that previous litigation, right? The Selma Smith litigation?
Yes, I was.
And the municipality was a party, correct?
Correct.
And the heirs of Selma Smith were a party, correct?
Correct.
And the reason that litigation got filed was because somebody at the municipality went to the heirs of Selma Smith and said, hey, you may own this, right?
Not only that, but they gave them a plat and showed them how to put 9 lots in front of our subdivision on the ocean where the lift station now sits.
And so, but for the fact that the municipality basically went to these people and said, hey, we think you own this and this would really be valuable for you and all you got to do is sell us this one lot, you wouldn't have been in litigation with them.
No, we wouldn't have. We found out that, and that's what started the whole litigation on that process.
And that's why the municipality was originally named, was you were basically suing them for having platted this, saying that these heirs own it.
Correct.
Okay.
And then they settled out of it, yeah.
So I want to jump into this. So Chuck went through sort of the history of what happened when, you tried to possibly get the lot owners to agree to do this through private development, didn't work. Went through the public WID, LID, and RID program. And when the initial estimates came in at roughly 3.3 million or whatever it is.
Well, the very initial estimate was 80,000 a lot.
Okay.
That was the very first time we went through the process, and it took a lot to get everyone together to rope everybody in and get them to approve that ballot. So that was the very initial estimate.
Okay. And I think that probably was a total project cost of some 3-point-something million dollars, but when you divide it between the lots, including the municipality's share, it turned out to be about $80,000 a lot.
Correct.
Okay. When the municipality came back and said, we've got new estimates and it's more than doubled to 7-point-something million, what did you think?
You know, I never really looked at the total amount. I looked at what they said our assessment would be, and it was 2.5 times what they initially said it would be. And, you know, that was a huge heartache. And so we all sat around and talked about it, and we went back to them, and they said, well, this is just an estimate. You know, the economy's changed, products changed, blah, blah, blah. But, you know, it doesn't mean it's going to be this much. And we said, okay, well, we want to have the opportunity to be involved in this. We want to be able to solicit construction, concrete work, asphalt people that build roads, and be involved in the process. And they said, yeah, you can be. So it took quite a bit of meetings to get the people to say, look, this is just an estimate. It doesn't mean anything. They're hedging their bets. They're putting as big as numbers on it that they can. But when the dust settles, it's going to be substantially less than this, because it can't be 2.5 times.
I mean, if it goes out to a competitive bid and you've got Quality Asphalt Paving, Wilder Construction, some of these other folks bidding on it, presumably they're going to want the work and they're going to honestly bid.
And I made a huge point, if they have the record, where we got them to agree that they had to bid it between November and February. In the wintertime, when everyone's hungry, everyone's looking for work. They said, oh yeah, we're going to get it out there. We're going to get it out, in the wintertime. And we said, okay, well, make sure that happens. Tell us when that happens, because we want to be involved. I want to solicit the contractors. I know contractors because I do some development, other things. And they said, oh, we're going to keep you all abreast. You guys are paying for this, so you're part of the holistic thing. That's came up this whole last 2 days, and it's the only time I've heard it.
I'd like you to look at Exhibit 96. And this is a letter dated
I'm going to
June.
switch my glasses real quick. Okay, sorry.
This is a letter dated June 25th, 2008, sent by certified mail. If you turn several pages in, you'll see it's got the list of property owners that it went out to. And is this the first notice that you had that the municipality was planning to bid your project together with this Pump Station 10 project?
Yes.
And what did you do when you got this and learned of this?
I got extremely upset for years, since 91 and then 2004 with the first vote and then the second vote. We'd always been our own standalone project, our road, our sewer, our utilities. And now here they didn't put the thing out to bid February through or November through February. And now we get notice that it's one project and we're piggybacked onto this lift station. So I was extremely upset.
Okay. And did you talk to the municipality about it? And
I know I met with them on the following month. I think I probably initially called them in Said, what's going on here? And then they said, well, we feel that it's better. But actually, the story I got from the municipality was, well, we cut a deal with the Turnagain Community Council, and they wanted us to do these things together, and there's this community involvement, and this was all under Mark Begich. And they said that we have to listen more to the community, so we've elected to put these together. That's kind of what I remember hearing.
Okay. And at some point in July, bids were opened, is that correct?
Yes.
And when bids were opened, did Quality Asphalt Paving bid? Did Wilder Construction bid?
There were no road builders that bid that construction, and the reason being, in my opinion, is that the primary focus of that bid was the lift station, and the alternatives was the road. We were, piggybacked onto a big civil sewage pressurized, mechanical building, and so no road builders. They looked at it and said, I don't want to do that.
And did you have a meeting with the municipality? I think we can. I'm going to put up on the overhead here an email from you dated August 11th, but I'm putting it up primarily because you reference a meeting that you had on July 25th.
On July 25th, I figured out who was in charge of the bids, and that was Joe Burton Neely, I think, and I requested an immediate meeting to go in and meet with him. And I called Chuck Spinelli, and he came along, and Carla Grumman, and we walked in there, and he said, here's the bids, and we said, look, stop right now. I've been working on this for 17 years, and now all of a sudden you've piggybacked this with a sewer lift station, and we're not comfortable with this. We want you to stop. And I asked him, have you accepted the bid? He said no. I said, good, because we're pulling out. We're pulling out right now. And their bid, I've learned later from you that their bid actually said that you can do the lift station and the alternatives are just that, an alternative. And so we said stop. And at that point I had 4 lots, and so my ownership interest was 9.5%, and the vote was only 56%. So me telling him right then, stop, taking away my support from this, took it below the 50% level. Chuck was there. Chuck had a lot. Grumman's had 2 lots. So I think combined we had 15%, which would have brought it down to 40%. And I sat here the other day and watched Joe Burton-Neely, and he asked him, he goes, well, why didn't you listen to those guys? Well, because I didn't have to. And it's like, well, how does he not have to listen to us? I sat in his office and I said, you're going to ask us to pay 70% of this bill you're showing me, and we don't have a say? Well, you already approved it. I said, I'm here now to tell you I haven't, and you have not approved this bid yet. So just stop, And he's like, well, I'm not stopping. I'm not stopping. He didn't offer to go, hey, go talk to someone here, go talk to Jerry Primo, go talk to this person if you have concerns. Call Bob Owens. He didn't say anything like that. He just said, we're approving this. It's going to happen.
And when you said that you're going to pay 70% of the bill, actually you're paying 100% of the WID, 100% of the lid, and 70% of the RID, correct?
Well,
whatever it is.
I know it was a lot of money.
Okay.
And when I looked at the bid, and it was 3.3 or 3.4, I was complaining about that number. I didn't know it was 7.9. I was in there looking at the bid, and Prue's paid 3.4 for the construction. I go, 3.4? We had 1.9. I didn't even know I was fighting 7.9 then. I was fighting 3.4.
And I'm going to put up on the board another email from you to Jeff Coleman, got Joe Bernardini, Russ Oswald, a number of other people. This is dated August 11th. And again, you state first of all, you had asked them to do a comparison between the cost for this project and other projects. Is that right?
Through the process, when we were on our own, we were working a lot
Just a moment. Could you tell the panel what exhibit we're looking at?
Oh, it's certainly. It's Exhibit 34, page 3 of 4.
Thank you. Mr. Staley, could you repeat your question, too?
Sure. So this email starts out by saying, I was out of town last week and just had a time to review your comparison. And So my understanding is that you had asked them to compare the amount that was bid on this for other projects. Is that right?
We're back to, what year is this? 09?
This is 08. This is
Okay.
before the bid is accepted, before the contract's been let out. It's when the bids have been opened.
My recollection is I got to know Jim Lamson pretty well at the roads. He was there with Howard Holton, and Jim was heading up our whole project the whole time. And so when some of these numbers come down and I was trying to understand them, I contacted Jim. I told him what was going on, and I think I asked Bertinelli could you give me a comparison of these numbers, because you've only got one bidder, to the other RIDs and LIDs that you've done in the last couple of years. I kind of recall that.
Okay, and so you say you were out of town, now you've reviewed it, you say, number one, do not award the bid to the sole bidder, pull it and rebid it of November of this year, and you go on to make a number of comments about that number one bullet point, but basically what was your concern and what were you trying to express there?
The way that the process went down, in that we were our own entity building our road, and them not telling us and actually putting it out on the street, combining it with a certified letter. They sent us a certified letter saying, oh, by the way, it says right here, I would like to introduce myself as the new project manager, Bruce Robson. It's like, what are you talking about? We've been working on this thing since 2004, and now it's 2008, and it's completely under someone's different management we don't even know, probably haven't had meetings with. And I was concerned that they tagged us along with this AWW sewer system, and it was going to greatly impact what they were going to do to us. I was very concerned about that.
Okay, and so your number two bulletin point again, I don't know if you can read that up on the board or up there on the board, but
I can't.
Your number two bulletin point was pull the pump station 10 out of the bid, correct? In other words, separate these projects.
Yeah, I mean, at that time when I wrote this email, I didn't know that the pump station was the primary bid and that we were the alternatives, because I didn't see the bid. I never saw it go out. So I said it backwards. I said pull the pump station, and I should have said pull us out, because we are the alternatives. But I didn't know the difference at that point.
And at some point, you basically asked Mr. Bernardini for a week. Isn't that right?
I pleaded him for a week. I said, look, I've got 17 years of my life into this. When we voted the first time, it was 2004. It's now 2008. You guys have taken 4 years to finally get a number that we can look at, a real number from a contractor. I need a week to just digest it, take it to the owners, understand it. Nope, we're going forward. We're going to go forward with this. And I said, please, could you, I literally begged him. And he just said, no, we're not doing that. And so if you read my emails, I'm basically I'm pleading with the man. And he just said, no, we're going forward. And I just couldn't believe it.
And did you, in fact, then go and talk to the other owners about this?
I immediately was keeping all the other owners in the loop. And so very shortly thereafter, you're going to probably show the petition, I reballoted all the owners. And I said, hey, guys, this is what's going on. And we need to get out of this. We need to let them build their lift station or whatever, but we do not want to be attached to what they're doing down there.
And so,
is that?
Yes, I'm putting on the overhead the petitions that you filed with the municipality, signed by various owners. The first one is, and basically asking that...
Exhibit number, please.
It's Exhibit 35.
It's still 35. Oh, okay.
Exhibit 35, and basically you've asked that they not accept this bid and that the project be rebid. Is that right?
Yeah, we request for rebid, and I've heard Bob Owens say, well, they didn't tell us to stop. And it's like, if we're requesting them to rebid it, I think we're telling them to stop. We're saying, we don't want to accept this bid. We're asking you right now to rebid it. And if you read that paragraph, and go through what it says, the second paragraph says it all, questions of financial responsibility, reasonableness of the total costs, the fact that the project may be negatively affected by being connected with the pump station. We try to lay it all out for them. We think this is bad for us.
Then you've got Mr. Mucha, if I'm pronouncing his name right.
Muka,
who's the owner of lots 9 and 10, has signed it. Gwen Hendrickson, the owner of lots 13A and 11 of Block K. Clark Rush, the owner of Lot 4, Block C. Diane Wilkie, the owner of Lot 5A, Block K, Turnitin Heights. James and Joan Curley, the owner of Lot 2, Pete's Place. That's what I'm having a...
In total, we had 17 of the 31 lots.
Okay.
Said stop. And so after I gave him the petition, I said, well, okay, so now you're going to stop, right? We can't stop. We've let the bid. And I said, you still have the right, because you haven't started construction, from what I understand from the law, you still can go back to them and say, these people have bowed out of the alternatives, because these were alternatives. The road was an alternative. We just want you to build the lift station. So would you please have that conversation? Well, I'm not going to do that, because we could be sued. And I said, okay, well, how about this? Would you try to have that conversation? And then if they threaten to sue you, then you can call me back and say that you're going to be sued. But you can at least try to call the contractor and tell them that these people don't want this built. I'm not doing that. We're building this. I mean, I was just losing my mind.
I have no further questions for you unless you've got further comments that you want to make.
I just want to surmise a couple things I wanted to say is, I think that we're going to pay what we should pay, and I don't think it's fair, one, the way they went about it, and basically it seems from all the documents I've seen that they planned back in 2004 after our first ballot, and we were at 80,000 a lot, that they then planned, okay, we need a lift station, where we're going to put it, let's piggyback these things. And they took 4 years before they notified us of their plan. I think that's pretty underhanded. So consequently, I think that the deep drain, from what I've learned from reading everything since we started, I think that subdrain is a complete function of that lift station. And I don't know why anyone here hasn't said that, because I believe if that lift station wasn't there, there would be no subdrain. There's no subdrain to the east, and their soils are worse than ours. In '92, we had to get a soils analysis for our area. And as you move west from where turning in southeast it gets better and better and better. So Sunstrom was built first, and then to the east was built, and then us. And our soils are better than over here, and there's no subdrain over there. And there's no subdrain over in Sunstrom. So this whole subdrain thing came about by them wanting to put that lift station there and protecting their asset. And I wouldn't be surprised, maybe, if through the EPA and the grant money they've got, that they had to put it in. I don't know. I mean, I'm thinking this huge sewer tank next to the ocean, and you have to protect that. So I understand that, but they're trying to pass that cost on to us and saying, oh, it's for your benefit. I think that's just wrong. I think that's wrong. That's one thing I think is wrong. I think the fact that they threw Lineary Park's improvements into our bid and into our assessment, and then later said, oh, yeah, we found an accounting error. We're going to take back the levy, and we're trying to fix that. So then we asked for an audit. We still don't have an audit. I have not seen, personally, an audit of what that $7.9 million is. I've asked for it. I've not seen it. I think the road to their pump station that we're paying for is completely unbelievable. I mean, on top of everything that happened to us, it's like just frosting on the cake. Oh, and you're going to pay for our road to our lift station. Thanks. And most of all, I think the engineering fees for our road were kind of thrown together, and it's like, think about engineering for this lift station and what it's going to take to get it approved by the federal government and the Clean Water Act and what they have to do to go through to get this thing. And then think about this road that's just a straight road. And these engineering fees are all come from the same company. And so I say, okay, if the construction was $3.2 million and they're charging us $7.9, that's $4.5 million in overhead. And how is that possible? It's just inconceivable to me. So I hope that if you guys listen and you're here and you say, you know, we're here because we want to know the truth and we're the governing body and we want to get down to the truth of this, that you're going to hear all this and you're going to say, I think there might have been some injustice here and hopefully we're going to get somewhere. I hope. That's the hope.
Mr. Owens, redirect.
Mr. Fick, you stated early in your testimony that when the design study report came out and the revised estimates for the cost of construction doubled or doubled and a half, that you had conversations with, I assume you said, somebody at City Hall that told you the estimates don't mean anything. Is that what you were saying?
They said that, you know, this is the worst case scenario and that we think it's going to come in a lot less than this.
Did they say that the estimate doesn't mean anything?
You know, if I have to recall those exact words, I can't recall those exact words, but I would say that they said that, you know, this is the worst case scenario. But, you know, what does an estimate mean, really?
And did they tell you that there would be any particular amount less, that it was a number that was any certain amount above? Did they give you any number that you could rely on other than the estimate?
No.
Who told you that the estimate was sky high and probably wouldn't be the final number?
Who told me directly?
Yes.
You know, we've had so many meetings with so many people. I couldn't recall who that would be.
And yet you relied on that statement?
No, I relied on the fact knowing that it was going to go out to bid and that we would have the opportunity to be involved in that bid. And I relied on the fact that it was going to be independent of itself. And so I didn't know why their numbers doubled or tripled, but now I do. I know now. I know because of the pump station. I know now.
And you said that you thought you had an understanding that it would go out to bid between November and February?
That's my understanding, yeah.
And who did you have that understanding with?
You know, I wish I would have taken notes. I wish I could tell you. It's someone at AWW, and I would probably say it was Voss, Nuss, or even that guy right there, but I can't remember his name. Russ Oswald. Mm-hmm.
With PM&E. He's not at AWW. Did you deal with project management as well?
Say again?
Mr. Oswald is not at AWW.
Well, we never really met with AWW. I mean, the whole process started at the city, and I think that's probably where I met him.
Well, I thought you said that the person who told you that the bids would be put out between November and February was at AWW.
Okay. I don't know if they were at AWW or at the city. To me, it's all the same. It's one and the same. It's all owned by the same government. So I can't tell you if it was AWW or Russ Oswald.
Do you know where you would have met with them or how you would have?
We met multiple times. We met with Jim Lamson, Howard Holton. I think he was there. I think BEI was there out at Elmore. We met after the fact when it all got changed over. I think we might have met at AWW in the basement.
And where is that office?
Off of Arctic.
Okay, so there's one on Arctic and there's one out at Elmore.
Right.
Do you recall where you met when you were told that the bids would be between November and February?
One of those places.
One of those
You're
places.
talking to me for me to recall something 6 years ago and exactly what room I was in and who I talked to.
I'm just trying to look for triggers that might refresh your memory.
Okay, thank you.
If the bids were going to be let out between November and February, when would you expect the contract award to occur? Did you have any expectation there?
I didn't, other than I think they let it out in June and they got it back by July, so it seems to me it would have been 30 days, you know?
So under your scenario, if it was released in February, you would have expected award sometime by April?
March, April, yeah. With construction starting in May.
So if you could take a look at Exhibit F8, please, Frank 8. You have that in front of you. It's a letter dated January 29, 2007.
Uh-huh.
And it was written by Bruce Robson and Russ Oswald on page 2.
Okay.
And you see that this is, yeah, they
Okay.
signed it. Going back to the front page, you see that this is a status report for the RID, WID, and LID projects. And it's the first sentence, paragraph there is announcing the reballot results.
Okay.
So in January of 2007, they're announcing to, I assume you as well as everybody else that owned property in the district, how the reballot turned out. Do you recall this letter?
I don't know.
Any reason to think you wouldn't have gotten it?
No.
And you see down in the section called funding that there's a breakdown of each project, the RID, WID, LID. And it shows that the project estimate for the total of the three was $7.3 million. The RID was 4.418. So those are consistent with the information that was provided prior to the ballot that you voted on and earlier and prior to this date, correct?
And these were all estimates, correct?
They're estimates, certainly. But those were the numbers that were on the table when you voted in 2006.
Correct, and we never believed they would hit that high, based on the fact that we had a bid at $1.9 million.
Based on what?
Based on the fact that Chuck had done the math on it, and he said he could do it for $1.9 million.
Right, but you knew that the information provided to the owners prior to the ballot showed these values, and those were the values you were voting on.
I knew those were the estimates that we would vote on, yes.
And then if you could turn to page 3 of this exhibit, it contains a schedule looking ahead down the road. Granted, it's an estimate, but you'll note that it has on here the contract award date for construction of June 2008 and construction notice to proceed in June of 2008.
Is that what happened?
It was actually August. So this was within 6 weeks of when actual award.
I wish I would have read this.
So you...
Because I would have complained immediately if I would have saw this.
It's okay.
Because what kind of sense does it make to put a bid out on construction in June with any contractor for any type of property?
Sure.
Doesn't matter what it is.
Sure.
But I think you agree
were
with
on the
that.
mailing list. You were a property owner. This was sent to you. This was information at your disposal.
Okay.
And you took no action on it.
Well, obviously I did not. If I would have read this, I would have taken action.
Now, before the work began in 2008, how many lots did you own on Marston Drive?
4.
And how many is that counting lots owned by companies you own or control?
4 total, yes.
Okay. And how many do you own now?
3.
And how many have you sold since the work was completed?
1.
Which lot?
Lot 5.
Which subdivision?
Simonson.
Simonson Estates?
Simonson Estates, yeah.
Which block?
I couldn't tell you. It's on the same side as the lift station.
Okay. On the north side of Marston Drive?
Correct.
And were there sales documents and closing papers, earnest money agreements?
Yes.
Did I ask you to deliver a copy of those?
Yes, you did.
And did I provide a subpoena from the clerk?
Yes, you did.
And is there any reason why you ignored that?
Well, I kind of figured that we've requested an audit of the 7.3 over and over and over again and never got anything. So I figured you'd get it ultimately. I have no problems with telling you what I sold the lot for, if that's what you want to know.
What did you sell the lot for?
$200,000.
Did the sale include, as additional compensation, the buyer's agreement to assume responsibility for the assessment?
The $200,000 value was a result of the fact that we won the lawsuit for the additional land. So the lot size basically went from 16,000 feet to almost 40,000 feet.
That wasn't my question.
Well, no, I'm just answering why it was 200,000. So yes, it's 200,000 plus whatever the outcome of this proceeding.
And in that neighborhood, it was about $170,000 for the assessments on the rolls as they're being proposed today.
I don't know exactly what my assessment is, but that's probably right. I think it's higher than that, actually. I think it's 192,000.
Okay. And you found a buyer. This was an arm's length transaction?
Actually, no, it wasn't. It was my best man in my wedding, and he's probably going to hate me forever.
Okay, but he agreed to pay that.
He agreed to buy it, yeah. I actually told him not to buy it at closing. I said, "You do not want to buy this." He goes, "I want this lot." I said, I don't want to sell it to you, and if you want to get him in here, he'll testify. And I called his wife and said, "Don't let him do this." So
on the other lots that you still own, you can drive to those lots now?
Correct.
And you've got water service to the lot?
I have water service and sewer service, but today I can't get a building permit if I wanted to.
And that's a separate question, but you couldn't have gotten one without the road, water, and sewer improvements to begin with.
There's no definite that I've benefited from this.
And you knew when you issued your vote in 2006 to approve these improvement districts that you were committing to pay the assessments and the cost of the construction when it was completed.
I knew I had the right to withdraw my vote as well.
And was that a yes, you knew, and you were committing to repay?
I was voting to move the project forward to see if we could get a viable transaction.
And if it was built within the budget that was established, you would be committed to repay it?
The budget is what we're arguing about.
But the ballot stated that you agreed to repay the costs if it came in at a price not exceeding the estimate at that time.
Yes.
And you knew that the municipality was not going to go forward with any work on this road or the other improvements unless the owners of that subdivision agreed to reimburse those costs.
It had been a 19-year process and 5 years since we first got our ballot. So I guess so is my answer to that.
No, I don't want you to guess. I'd like you to state definitively you knew the municipality knew or didn't.
I hoped.
You knew or did not know whether the municipality was going to build that road on its own?
No, they wouldn't build it on their own. They needed our support, absolutely.
So finally, the same question I asked Mr. Spinelli. What do you consider to be an appropriate charge for these improvements?
I think that that the $3.2 million that it cost to build the road and put in the water and sewer, plus an overhead charge of probably 20% is probably reasonable.
And
I don't think we should pay for all the extras, is what I'm saying.
Okay. So there's no question, though, that you received benefit, that you received payment of 100% on the lot that you sold for the value of these assessments. And have you purchased any lots in this subdivision since it was completed?
No, and I'd sell all of them.
Okay, thank you very much.
Now, if I could.
Mr. Fink, when you approved the ballot with the higher estimate, you weren't agreeing to necessarily pay that amount, were you? I mean, you weren't
It's not my
agreeing.
intent to give them carte blanche to fill the gaps, and
Right.
that's what I think they did.
Okay.
I think they looked at the highest number and said, how can we get up to that number?
And so what you were agreeing to was that you would pay the cost, the reasonable cost for that improvement district as a standalone, not pay for infrastructure or anything like that, based upon a competitive bid.
Based upon the fact that they were doing it prudently, and they had a duty to me to make sure that I'm the taxpayer and that they're going to, I thought they had a fiduciary duty to do the right thing, and I don't think that happened at all.
And I want to draw your attention to F8 again. I think you've got it in front of you. It's the one in front of you. That third page that he had you look at, nowhere in here does it say they're going to wait and not put this thing out to bid until the end of June, does it?
No.
So this isn't inconsistent with what you thought in terms of when the bid would go out. It says that the construction is going to begin in June.
Yeah, it says construction award in June, so they could have put the bid out in February and awarded it by June.
And indeed, construction notice to proceed in June. And so the idea was that construction would start in June. The bid easily could have gone out in February, correct?
I would agree this does not put me on notice of what he was trying to prove, yeah.
I'm going to put on the overhead Exhibit A6. And the lot you sold is Lot 5, Simonson Estates. That's this one here.
Correct.
Okay. And what you sold wasn't just the lot, but you also sold your right to land behind
All
the
the
lot.
above, all the land up to that line there, yeah.
Okay. And so if we look at what the assessor assessed that lot for, I think after the improvement districts, he assessed that lot for probably somewhere in the neighborhood of $235,000 or so.
245,000. That you know, I don't want to be like Chuck and say I got another rub, but I'll tell you, as soon as this thing got done, that they increased the taxes 500%. And so since it got approved till now, I've paid over $50,000 in taxes so far. You know, not going towards the assessment, but just $50,000 in taxes on land I can't get a building permit. I can't get a building permit because there's no gas, there's no electric down there.
And so when Mr. Owens asked you what you sold that lot for, it wasn't just the lot that you sold again, it was that lot plus the land behind.
The reason the value of 200 is because of the size of the lot. That's correct.
It's because of the land behind goes all the way to the water as well, correct?
Correct.
No further questions.
Mr. Trini?
Mr. Fink, you mentioned the Turnagain Community Council earlier in your testimony. Were you ever invited to that where this was brought up?
You know, I was, and a couple times I tried to attend, but it was almost like a witch hunt. And so what I elected to do is to call the, I think it was Redmond at the time. Mary Redmond was the president, and she said, could you come? And I said, Mary, I'll meet with you and I'll meet with your whole board. But every time I walk in the room, I feel such hatred because I'm the guy that's taken away the parkland from Turnagain. And another, I'd like to add something to that since you kind of just jarred my mind, is that one of the costs in this whole thing is every time the Turnagain Community Council had a meeting, they would always request people from AWW in the city to show up. And they would show up and they'd have more meetings and they'd show up. And finally I said, I get all these notes. Are you charging us for that? And they said, yeah, we charge you $385 every time per hour, every time we send people over there. And I said, so if they keep asking you to come over and you keep showing up, you're charging us $385 an hour? And they said, yeah. And so I got everybody involved. I said, you got to stop that. You can't charge us because they're just, it's kind of like just the bill just kept going up, right? So I actually have an email somewhere that someone at AWW, and I'll try to find it, says we will no longer charge your project $385 an hour if we send people over there. Because it got ridiculous. I mean, it was very political, I'm sure you know, that everyone in Turnagain did not want this development to go through. It got so bad that my sister has an Oktoberfest, and she lives on Marston, and she uninvited me to it. She goes, "You can't come here. I'm telling you, they're out for you." So I'm like, "Oh, you got to be kidding me."
Well, thank you, Matt. I appreciate it. Thank you.
Mr. Evans?
Thank you, Madam Chair. Mr. Fink, just if you can look at that document again, F8, I think it's still in front of you. Regarding, on the first page of it, again, regarding the numbers that are presented, and as I understood your testimony before, you were indicating that your view of these as they were estimates.
Well, I mean, it says project estimate right there, 2008.
Sure. And if you could look under the title above that that says funding, and in the first sentence, it reads, "The breakdown of costs relative to what the property owners will be burdened with and what the municipality will incur is provided here." So it seems to be saying these will be the costs that you'll be burdened with, does it not?
No, there's no doubt that I looked at this and said, is that a possible number? Gosh, I hope not. And if it's done in a prudent way, it won't be. Because if the private sector can do it for $2 million, how does the government spend 7.3? It was beyond me to think that that's possible. But I saw those numbers, yes.
And if you would look at those two sentences below the numbers as well, it says the costs listed in this table are based on information dated December 15th, 2006. Slight adjustments may result during development of the revised assessment rolls by AWW and PW. It seems to me when I read this that they're saying this is pretty much the cost. There may be some slight adjustments, but this is what we're telling you it's going to cost.
And they sent this same letter out when it was $80,000 a lot. And so why can't it go from 80 up to this back to 80 when the bids come in? I mean, you got to remember, we were kind of, when I bought those lots in 91, I immediately started to try to get this process started, and I got put off and went to meetings, and so then I got all the groups together and all the owners, and they said, well, you got to go to the Geotechnical Commission. So we did that and paid $100 and some thousand for a soils test, and it came back better than the east. So we're like, okay, we're going forward. And so finally, after 6 years of meetings, Sandy Notestein over at AWW says, "Hey guys, come here." And after the meeting, she says to us, "You know what? If you send us a written email that says that you want to do this, we have to do it." And I'm like, "You're kidding me. We've been coming all these meetings. You're finally saying." She goes, "Yeah, just demand that we do this." So that's what we did, and that was in 2004. So then we get the 80, and then, the prices double. I mean, it's just been this process of fatigue to where, it could have said $100 million here, and I think I would have voted yes.
Thank you.
I have one.
Yes, Mr. Owens?
Could I do a little follow-up?
Mr. Fink, could you take a look at Exhibit F7? I think you're at F8.
Page.
This is a letter, or memorandum dated September 25, 2006.
Okay.
This is a letter or a memorandum from Russ Oswald and Bruce Robeson to the Improvement District property owners in September of 2006. And it reports on, towards the lower portion of page 1, activities since first of the year to the present. And beginning there, it lists a number of activities that occurred. And on the next page, it talks about a meeting in April of 2006 to discuss the status, a meeting with property owners in May of 2006, a meeting of the Geotechnical Advisory Commission in May.
A lot of meetings, I agree.
A lot of meetings. You attended some of these meetings, didn't you?
I think I did, sure.
And in particular, the one on May 5 of 2006 was to review project costs with property owners. Do you recall a meeting where you prepared an agenda and a list of items, having reviewed the estimate in the 35% design level and
Do you know where
seeking
that meeting
additional
was held?
appraisal. Excuse me?
Do you know where that meeting was held?
Perhaps.
I recall a meeting that we were told that they were going to hire an engineer to draw the road, and they wanted our permission to spend $250,000 to engineer this road. And we said, okay, if that's what it costs, that seems like a lot of money, $250,000 to draw a straight line on a road. And in the meeting, and it may have been this meeting, they said, okay, so we gave the engineer $750,000. And I just lost a gasket. I don't know, Russ Oswald was there because I said I'd take his job. I was in the meeting and I said, you guys said you're going to spend $250,000. You spent $750,000 to draw this road. How is that possible, And they just said, well, that's, it went out to bid or something, this and that. And I'm just pulling my hair out in this meeting. And I offered to take Russ's job. Do you remember that, Russ?
Well, getting back to the meeting of May 5.
I remember that meeting.
It states that it was at the offices of PM&E. And we have at Exhibit F4 some notes of the meeting. It indicates that you were present along with several other property owners, Mr. Oswald, Mr. Lamson, Gary Jones, Brian Boz, and others.
Was that over at Elmore? Because that's the meeting.
I believe that's the date that in the letter that is marked as F7 says was over at Elmore, yes.
Yeah, I was so upset at that meeting.
Okay, and in this notes of the meeting, Exhibit F4, it says you had prepared an agenda for the meeting, and the meeting, yes, that you prepared the agenda, and the group generally followed that agenda.
And where is that exhibit?
F4, Frank 4.
The green sheet will tell you the number.
Okay. Okay.
So in May of 04, the meeting occurs, you have the agenda.
06.
I'm sorry, May of 06. And you prepared an agenda with a number of issues, and the minutes indicate, sort of follow the agenda items that appear to be on your
delete
list.
sidewalk, number one. I remember that.
Right, delete sidewalk, delete secondary drainage, and there's 13 different items in total. Maybe there were more, but at least 13 occurred on this note. Does that revive your recollection that you had a list of items?
No, I remember being there, yeah. And I probably had this because I think I looked at something and said, what's this, why is this in there, why is that
Right.
in there? Yeah.
Would it have been the estimate at that time that was released as part of the design study report?
Well, this is 2006, so this is 3 years before it went out ultimately, so.
Sure. This is at the point that the costs are doubling, right, in 2006?
Were we balloted of the new numbers?
Yeah, just before the
this?
reballot. The reballot occurred in the fall. This is a meeting in May.
So then I went in there to take the cost down.
Yes.
Right,
And-
that was my attempt anyway.
And my question is that whether you studied the cost estimate that had been released about that time in anticipation of this meeting.
I can't recall if I studied it or if I looked at it for things like sidewalks that we didn't request, and they had a road in there down to the park that we didn't request that they wanted to have us pay. I can't tell you that I looked at every item and every number. I looked at captions of things that I thought, why is this in here?
Okay. Now, if you look at, keep your finger on that one if you like, but if you look forward in that binder, there's another tab, C is in cat or Charlie, towards the front. And in particular, I'm interested in Exhibit C is in Charlie 4.
This is back here.
Yes.
Okay. I think, yep, I got it.
Do you recognize that document?
No. I mean, I may have seen it, but I don't recognize it, no.
It's entitled the Marston Foraker Drive Road Improvement District Design Study Report Construction Cost Estimate. Would that have been the sort of document you reviewed in order to develop your agenda for the meeting?
I don't know if this was it or not. I see all this stuff on the left that would make me have questions. Like dewatering, $50,000. You know, I'm sure I'd ask a question like, what does that mean? I felt like I was doing their job for them.
But do you recall going through the estimates that had been developed in 2006, such as this?
Well, I recall, like you said, I think I had some issues, and I met with them and said, what is this and what is that? Yeah.
And so would it have been this estimate?
I can't say if it was this or not. I mean, it could have been.
Or something similar?
Something that was detailed enough to make me want to ask questions.
Did you obtain a copy of the design study report that was issued in 2006?
I can't recall.
There was a key document that was released that is very thick. It contained a number of assumptions and statements.
I've got a box at home that's about this, like this, and like this, with stuff in it.
So you did review something that had the items at least that you're referring to here: sidewalks, secondary drainage, cleaning and grubbing, landscaping, and the like, and attempted to revise those items from the project.
I think I saw the number and I thought it was high, and I tried to go through and see what should be involved and not involved.
Okay. And I direct your attention to page 2 of this document. This is the continuation of the Road Improvement District cost estimate. And you notice up at the top there's a note that says the items below this, of that where the note is, the items below it, were work to be funded by the Road Improvement District but would be constructed when the Pump Station 10 upgrade project was constructed. Do you recall observing that note before?
No, I don't.
Okay. No further questions.
Staley?
One very brief follow-up. The agenda, the first thing on the agenda was remove the sidewalks, right? You don't have to go back to it.
Okay.
You can remember that, I think,
Yes,
can't you?
yes.
Remove sidewalks. They saw it. Charlie 4, nothing on sidewalks on there, is there? Charlie 4, nothing on sidewalks on there, is there?
No, I don't see any sidewalks.
I don't see any reference to sidewalks on there, do you?
No.
No further questions.
Are there any questions from the panel? No? No further questions from either council? No. Thank you for your testimony, Mr. Fink.
Thank you for listening.
Our pleasure.
Brief 5-minute recess.
Okay,
only
5
because I've been
minutes.
drinking a lot of coffee and water.
5 minutes. And I do want to let the public know that we will be taking public testimony prior to closing statements of council. I think there's one more witness left.
Yeah,
and
I may have a brief recall of one witness.
Okay, perfect. So we'll do the witnesses, and then if anybody's here to testify, anybody wants to talk on this topic, we'll take those prior to council making their closing arguments.
And did the panel still wish to direct questions to Mr. Boss?
No, I don't believe anybody had asked to. Yeah, I was going to say, we questioned him yesterday, I believe. So, yeah, I think we're good. Okay, brief 5-minute. Alrighty, are we ready to get started again?
We are.
Okay, wonderful. Mr. Staley, if you'll go ahead and call your next witness.
Call Mr. Vern Rolfs.
Mr. Rolfs, if you'll come up to the microphone, state your first and last name, spell your last name for the record.
My name is Vern Rolfs. It's spelled R-O-E-L-F-S.
Thank you. And Madam Clerk, we're still recording, aren't we?
Yes, ma'am.
Okay. And if you'll just face the clerk, raise your right hand, and she's going to administer the oath.
Do you solemnly and sincerely swear or affirm that the answers you will give to the questions asked of you in these proceedings will be true?
I do.
Good afternoon, Mr. Rolfs. Can you please tell the panel a little bit about yourself, your educational background first?
I'm a professional civil engineer. I have about 38 years of experience. I have a bachelor's degree from St. Martin's College and a master's from Oregon State University in civil engineering.
In your master's degree, does it have some sort of a specialty with regard to sanitary?
Yes, I specialize in sanitary engineering and construction management.
Okay. And how are you presently employed?
Yeah, I'm president of VEI Consultants.
And how long have you been president of VEI Consultants?
About 12, 13 years.
Okay, and prior to that, were you vice president?
That's correct. I was vice president.
And even though you're president of VEI, you still are active as an engineer, is that right?
Yes, that's correct.
And you're here today because I subpoenaed you to be here today, correct?
That's correct.
Now, VEI had a contract with AWWU regarding both Pump Station 10 and the improvement districts, is that correct?
That's correct.
Okay. And you were the contract manager for those two contracts?
Yes, I was.
Pump Station 10, it had long-standing problems, right, dating back to the 90s?
Yes, there was some issues with the pump station.
And basically a decision was made that this pump station was going to have to be replaced, not repaired, sometime prior to 2002.
That's correct, in that time period.
Okay. And when it was looked at, or when it was decided sometime prior to 2002 that it was going to have to be replaced, not repaired, there were concerns about location because its present location was too small, correct?
That's correct.
It was basically on a residential lot. It was on an easement on a residential lot, and there really was no room to replace it and upgrade it on that lot, correct?
That's correct.
In addition, one of the problems with this pump station was that it had no standby power, and so that it was going to require a location with more room so that you could add that standby power. Is that correct?
Yes, standby power was one of the major issues.
And as a result of the fact that it had no standby power and the fact that it was old and perhaps not it was more than 20 years old, I think, at that point, wasn't it?
Yeah, I think 1977 was the original construction.
And so as a result of its age and a number of other things, including the lack of standby power, there were actually instances where raw sewage was being dumped into the Cook Inlet in violation of the Clean Water Act.
That's correct. There were overflows.
Another problem with it was that it had a small wet well where the sewage is stored, correct?
That's correct, yeah.
And in about 2002, VEI got a contract to study some problems with this pump station. Is that correct?
That's correct. More the drainage basin, but also the pump station, yes.
Okay. And it was an inflow and infiltration study or something?
That's correct, looking at excess flows beyond the domestic flows that were coming into the pump station from groundwater and surface water infiltration.
And as an addendum to that contract, you began to study and look at alternative sites.
That's correct, yes.
I'm going to put on the overhead, and I think you should be able to see it, A7. This one might be clear. And this is basically, I know I'm jumping ahead a little bit here, but this is basically the new Pump Station 10 design, correct?
Yes, this is overall layout here.
And I just want to draw your attention, and again, if you look at the overhead, you can see where I'm pointing, but this is the old, what they would call the east trunk line going down to the old pump station. Is that correct?
That's correct.
And you can see it flows, it goes between these two homes, relatively close to them, correct?
Yes.
And Mr. Nuss testified that that old trunk line was only an 8-inch line, and so it was not sufficient. And I think that you testified at your deposition, you recalled that there was some sort of a problem with that line that needed to be replaced. You weren't sure what it was. Is that right?
Yeah, it's going through the back lot lines and everything. It's not a favorable design for sure.
Okay, and so in addition to the line itself being too small, the location of where it went is not favorable given the fact that it's very close to these homes. Is that correct?
That's correct.
And sometime in 2004, VEI got a contract with AWWU to design the new pump station. Is that correct?
That's correct.
And it wasn't until sometime after that that VEI got a contract to also design the improvement district.
That's correct.
So pump station 10 came first.
Yes, that's correct.
In one of the early aspects of the Pump Station 10 design project was the site selection.
Yeah, that was one of the first things that we worked through.
He's going to need 67. And Exhibit 67 is called a Pump Station 10 Replacement Feasibility Study by VEI Consultants dated June 2004, front page. And again, it references the fact that this pump station has been slated for replacement, discusses previous reports, both a report from 1998 and then a VEI report from 2004. And at one point, an alternative site had been looked at on the corner of Sandstrom Drive and Kissy Court. Is that correct? That's correct.
Can you please make sure your microphone's on, sir?
Okay, it must have got pushed or shut off there.
Perfect. Thank you.
Yeah.
And the second page of this is in fact a map. And on this map, we can see the existing Pump Station 10 site, which is on the homeowner's lot, correct?
Correct.
And then the initial proposed replacement site at Sandstrom and Kissy Court, correct?
That's correct.
And then by this point already, you were considering a new proposed replacement site, which is actually where it was ultimately built.
That's correct.
And on page 3 of the report, talks about the elevation of this proposed site and the fact that the wet well is actually going to be below groundwater. Is that correct?
Yeah,
Or
I
actually
imagine
below
that's
tidal groundwater.
I don't.
You
Where's
see
that in
page
the
3, top of the page?
top of the page? Mm-hmm. Yes.
And again, referring to the first page of this exhibit, you were aware at this point at least, and AWWU was aware at least at this point, that there was this potential Turnagain Heights Improvement District that would be scheduled for design sometime later that year or the next year, correct?
Yes, it was coming up through AWWU. We received word, yes.
Okay. And so one of the things that was being considered already at that point was whether or not there might, and it's referenced here that project, the Turnagain lid, if you will, had anticipated its own little small pump station for that neighborhood. And so at this time already you're considering looking at whether or not it's possible to construct just one pump station instead of two. Correct?
That's correct.
And the reason why you want to have one pump station instead of two is because of the maintenance costs, essentially. It costs much more. I mean, you could have one big pump station or 10 small ones, and if you have 10 small ones, it's going to have basically 10 times the maintenance, right?
Yes, we want to minimize the number of pump stations on the system.
So with regard to this site selection, then, there's a number of considerations that went into it. One was that you needed a fairly large area to construct this proposed new pump station. You didn't want to cram it into a neighborhood or around houses. Is that right?
You needed more space.
Needed more space. Elevation is a concern. It needs to be low enough. Is that correct?
Yeah, that's a major one on this, to get low enough so that low enough elevation for the site so you don't have to build the sewer lines real deep.
And then the potential for cost savings if you can eliminate a pump station. Correct?
Correct.
I just want to, this is kind of an aside, but if you look at page 5 of that document, it references the fact there's a cost estimate on the bottom of page 5. And it says, the following cost estimate is a planning level of confidence. The rule of thumb, 8% of construction cost for design engineering and 12% of construction cost for construction engineering was applied, correct?
Yes, that's correct.
Okay, and so you combine those two things and that's like a 20% rule of thumb for both design and construction engineering?
Yes, I would say it's, those numbers aren't really thrown around anymore.
Okay.
It's hard to accomplished design and construction for that percentage.
Okay, but in 2004 at least, you know, I mean, it's in your document that VEI was still using that as sort of a rule of thumb. I realize this is for planning purposes, but it's kind of a rule of thumb for just trying to get a handle on what the cost might be, correct?
A lot of times in a quick estimate, yeah, a number like that will come out.
And design engineering includes surveys, geotechnical investigations, civil, structural, and electrical design, public involvement, all of those things, correct?
I think the way it was applied here, that's correct, yes.
So essentially the full spectrum of what VEI was eventually hired to undertake, both with regard to Pump Station 10 and the Road Improvement District.
Repeat that one.
Sure. Basically, the full spectrum of services that VEI was ultimately hired to provide with regard to both the Pump Station 10 project and the Improvement District project.
Correct. Could I add something there?
Sure.
Yeah, typically when you add or use a percentage like that, soils and survey are separate, as well as, you know, permitting and several other detail. I don't think that's the way it was applied in this case, so.
You think it was applied to be more broad?
I think so. The way it was added in, yeah.
Pretty much encompassed everything, that rule of thumb, 12% and 8%. Okay, and so I want to draw your attention to Exhibit Charlie 1. And this is a letter from VEI to Stephen Nuss dated April 6, 2005 regarding the Pump Station 10 upgrade. And its subheading, if you will, is Life Cycle Cost for Turnagain Heights LID Lift Station. And if you need to refresh your recollection on it, you can. But basically, you were asked by AWWU to calculate sort of what the present value would be of the cost to them to maintain this lift station, correct?
Correct.
And you weren't asked, the initial cost of building this lift station was $150,000, but that was going to be borne by the LID. So what you were really asked to look at is, well, what's it going to cost AWWU to maintain this thing so that we can decide if it's in our interest to get rid of it, right?
Yeah, figure out what the total cost is going to be.
And the present value of those maintenance costs was $104,000.
Correct.
And so that was another factor then that went into deciding where to ultimately place this new pump station if you could get rid of that maintenance cost, correct?
Yeah, that was, I think, in the total evaluation.
So the site that was ultimately selected, again, I'm looking at A7 and it's up on the board there for you. The site that was ultimately selected there was really an excellent site in the sense that it had a large location. So it was good in terms of size. It was good in terms of elevation, and it also presented the opportunity to save AWU money by eliminating the maintenance costs on a second pump station.
Correct. And also the cost of the second pump station.
This site, however, was in the Turnagain Slide area, is that right?
Yeah, yes, the whole area is pretty much in the slide area there.
Okay, and so it was going to be controlled by AO 78-84 and was going to require special care with geotechnical investigation and design of foundation and trenches and such, correct?
Correct.
Now, with regard to AO 78-84, you're aware that there had been geotechnical studies for the broader Turnagain slide area, if you will, over the course of a number of years, correct?
Correct.
And so there was a study that was done for Turnagain, what I'll call Turnagain Northeast, on the east side of Turnagain Park. Many people know it because it's got the Rasmussen's big, beautiful home, former Governor Sheffield's home. There was a study that was done there in the 80s, correct?
Correct, yeah.
And that study basically said that that area was stable for development and those homes were ultimately constructed, correct?
Correct.
And then in 1995, there was actually a study done for Turnagain Northwest, the area that encompasses this improvement district that we're talking about today.
Correct.
And again, that study said that the land had stabilized and it was appropriate for development, correct?
Correct.
Now, it's true, is it not, Mr. Rolfs, that with regard to the requirements of AO 78-84, you need to go to the Geotechnical Advisory Commission to show slope stability if you're going to build a building, correct?
I don't recall all the particulars in the ordinance, but I know for this project we needed to get approval from the Geotechnical Advisory.
Okay, for this Pump Station 10 project, you needed to get approval, correct?
Well, and the improvement district also.
Okay, but it's not required for road, water, and sewer, is it? Under that old ordinance, AO...
My understanding, I mean, we had to get approval for both.
I'd ask you to take a look at Exhibit 101. And in particular, page 7 of that exhibit. 101, page 7. And this is an email from Mr. Nuss to you and others, dated September 27th, so almost the end of September of 2005. And Mr. Nuss reports that he's done some research regarding AO 78-84 and the prohibitions regarding development. And, it's got a number of things in there, but what I want to draw your attention to is the last sentence in the second paragraph. It says, "These requirements relate to the construction of buildings, not roads and utilities. These requirements are also reflected in Building Safety Handout number 53. And then the last paragraph says, "Based upon the above and briefly looking through the municipal code, I do not believe we are required to show slope stability for the road, water, and sewer improvements." Do you see that?
I can't remember all the particulars on that, but the fact that this area was going to be built on with homes that would have to be approved, I think that's probably why the subdivision and the construction of roads and everything did have to meet the requirement also.
Okay, well, Mr. Spinelli testified earlier, and you probably weren't here, but he's already built a home in this area, in this new improvement district. Notwithstanding the fact of everything that's been done, he still has to go and get blessed by the GAC for his foundation and everything. And so, I mean, it's not like what was done has eliminated the need to do it for a building or a foundation.
Yeah, but if what we put in there was substandard, then the whole area couldn't be approved.
Well, I understand that. You wouldn't want to put something substandard in there, sir. But again, Mr. Nuss took a look at it, and what it says is if you're going to build a building, you've got to do that. And indeed, it needed to be done for Pump Station 10, correct?
It had to be done for Pump Station 10, but the GAC review was for the whole area.
So as a part of the Pump Station 10 project, VEI hired Shannon and Wilson to do a soils investigation to investigate the stability of the soils for purposes of constructing Pump Station 10, correct?
Correct.
And I'd like to draw your attention to Exhibit 62.
Okay.
And this is, in fact, the Shannon and Wilson Pump Station 10 geotechnical study. And in fact, this is a revised one for Pump Station 10, correct?
That's correct.
Okay. So an earlier one had actually come out, correct?
Correct.
Okay. And I don't know if I've ever received a copy of that, but I do have the revised one, and drawing your attention to exhibit page 12 of 28, or native page 9.
Okay.
And drawing your attention to the bottom of the page. It states that the focus of explorations, talking about the general topic here is subsurface explorations, and it says, the focus of the explorations was to classify subsurface soils and determine characteristics of the soils present at the proposed depth of the new utility lines, pump station building, and wet well, correct?
Correct. I'm still looking for where that's written exactly.
So again, the focus was to explore and classify the soils and their characteristics at the proposed depth of the utility lines, pump station building, and wet well.
Okay, I found it here, yes.
Now, you agree with me that the stability of soils can vary depending upon the depth. I mean, they might be stable at one level and not at another, correct?
Correct.
So if you're concerned about going down 10 feet, you might have one concern. If you're concerned about going down 40 feet, you might have different concerns.
Correct.
And what Shannon and Wilson was told in this report is that the wet well was going to be 40 feet deep.
That's correct. That's what we requested them to consider in their borings.
So when they were asked to review the stability of these soils for the purposes of the pump station and its wet well, what they were told was that you were contemplating a 40-foot deep wet well at that time.
That's correct. One of the requirements the municipality was looking at was 2 hours retention time in the actual wet well, which would And the one configuration where we went with, I think we were looking at 12-foot diameter, would have to be 40-foot deep in order to have that kind of storage. So that was probably the deepest alternative we were looking at. Later we reconfigured and went with a shallower wet well.
Water flows downhill?
Correct.
So if you can de-water an area up above, you can help dry it out, correct?
Correct.
And in terms of constructing something deep, the deeper you go, the more expensive it gets.
Correct, yes.
And a big part of the reason why it gets more expensive when you go deeper is because of water.
If you're in a wet area, yeah, that's a concern.
Okay, so there's other reasons. I mean, it takes more time to dig deeper, and so you've got more time with the equipment and the laborers and everything else. You might have more material you have to deal with, but one of the big concerns is when you go deep, if you go down below the water table, you've got to deal with sloughing of the soils and all kinds of things, right?
Correct.
So if you're digging a wet well and it's going down below that water table and you haven't sufficiently de-watered the area, you might have to use what they call sheet pile and all kinds of things that dramatically increases cost, correct?
That's correct.
Ultimately, you know, after taking a look at all these issues, its location and everything else, the wet well was not made 40 feet deep. It was 25 feet deep or thereabouts, correct?
Yes, it was.
Still deep, though, much deeper than the home of a basement or anything like that, correct?
Correct.
The basement of a home.
It's similar to a lot of the other wet wells around. It wasn't extraordinarily deep anyway.
And so still a concern, in particular in this location, a concern about water, correct?
Correct.
Shannon and Wilson was never told about the fact that you were no longer planning a 40-foot deep well. It was only going to be a 25-foot deep well.
Not before they put out their study, no.
And they were never told, well, we've shortened it up and we want you to restudy it.
Yeah, I don't know that there were a lot of recommendations that dealt specifically with the wet well here as far as dewatering or anything.
Well, again, one of the concerns was the wet well, correct? I mean, that was a concern, correct?
Correct.
And the depth of the wet well in particular, both for terms of constructing it and for other reasons in terms of the water impacting that wet well, correct?
Yeah, we needed to find out what kind of soils were down there to make sure that, we didn't have a major problem.
The recommendations in this report are to install a deep subdrain in the utility lines 5 feet below the gravity utility lines, correct? The gravity sewer lines?
They were supposed to be below all the gravity sewer lines, correct, to make sure there's no water accumulating in the utility trenches.
Okay, and 5 feet below, correct?
Yeah, I see here 5 feet below, correct.
And this was a requirement for Pump Station 10, even if the improvement districts never got built.
Correct.
One of the things you're attempting to do here is to dewater the area to make it more stable and buildable for this pump station.
My understanding of the subdrains and the desire to get it deep to get the water out of the utility trenches was to eliminate the water that would be available for liquefaction, which was a major problem in the earthquake in '64 in this area. So that was one of the primary things they were going after with the deep subdrains. It did, of course.
Which is necessary for Pump Station 10, right, to build it?
Yes, correct. But
And again,
it was the same requirement for the rest of the improvement district.
again, though, the stability of the soils can vary by depth, and so they took a look at building a pump station with a 40-foot deep wet well and said, in order to make sure that it's stable for this pump station you want to build there, we need to put in these deep subdrains and dewater the area, correct?
Yeah, I think it was wasn't the primary benefit they were going after, but a secondary benefit probably.
And again, these requirements existed even if the improvement district was never going to be built.
That's correct.
I'd like you to take a look at Exhibit Charlie 13.
Charlie 13.
There's not sub-tabs, so it's a little bit difficult to find those exhibits sometimes.
Okay, found it.
And this is a letter dated October 6, 2005 to Mr. Nuss, correct? From VEI.
Correct.
And it talks about this soils report regarding Pump Station 10, and it says the Pump Station 10 soils report recommends subdrains be installed in the same trench with the gravity sewer lines. I'm going to skip down to the area in question, and it says the Pump Station 10 upgrade project is responsible for redirecting 2 trunk lines to the new PS10 site, the east trunk and the west trunk. You see that?
Correct.
And then there's some discussion in this letter about installing them in one location or both. And on page 2 at the bottom, there's your recommendation. And VEI writes, we concur with the recommendation of the soils report to install subdrains in all areas for the following reasons. 1. Installation of subdrains over a wider area will eliminate more groundwater and provide more site stability during seismic events. And that's what you talked about before, is that one of the things it does is it decreases the risk of liquefaction, correct?
Correct.
2, the subdrains will provide a tool for the contractor during construction of the pump station. It is possible that the presence of the subdrain will eliminate the need for a formal trench dewatering system. Correct?
Well, it said during sewer construction, not pump station construction.
Okay. Well, this document, sir, is regarding Pump Station 10. Correct? Look at page 1.
Correct.
Okay. 3. With subdrains in place, the deep excavation for Pump Station 10 wet wells would be protected from groundwater flow, correct?
Correct.
And that's what we talked about before. The deeper you go, the more expensive it is. It's more expensive because of water. So if you can dewater the area, you can save a lot of money during construction, correct? During the excavation for the deep wet well, correct?
Correct. Yeah, it's a benefit if you can dry out the area.
And construction of the shallow utilities for Pump Station 10 would not have to deal with groundwater, correct?
Correct.
Page 3, number 5, the discharge at the Hood Creek storm drain is provided by this option would be a more trouble-free discharge point, correct?
Correct.
And then the last one says, that there was a discussion about do we just do one or do we do them both? And you say, well, doing the second one doesn't save us that much because it's the shorter of the two, so we might as well do it all, correct?
Correct.
And construction of the shallow utilities for Pump Station 10 would not have to deal with groundwater, correct?
Correct.
And then the last one says, there was a discussion about do we just do one or do we do them both? And you say, well, doing the second one doesn't save us that much because it's the shorter of the two, so we might as well do it all, correct?
Correct?
Okay. So out of the 6 different things, the last one just dealing with 1 or 2, the 5 sort of benefits, 1 had to do with liquefaction, and 2 through 5 all had to do with basic building concerns.
Great. Yes?
So I want to look again at A7, and you might be able to see this on the overhead, or you can feel free to look at it in your book if that's easier as well. But again, this is the drawing for the design of the new pump station, correct?
Correct.
And there's a little spot down here that says work schedules, and it's got Schedule A, B, and C. Schedule A is Pump Station 10 upgrade, LID sanitary sewer improvements. Schedule B, Pump Station 10 upgrade, storm drain and subdrain improvements. Schedule C, Pump Station 10 water improvements, correct?
Yes, I see that there. That was probably before, I think that concept evolved before the plans were finally put out, but when we, at that point in time, those were the schedules we had.
Well, all of that was necessary for Pump Station 10, even if the improvement district was never built, correct?
Correct.
Including the deep subdrain, including the pump station for the deep subdrain, all of that was necessary for this pump station, even if the improvement district was never built.
Yes?
And this is a basic infrastructure upgrade for the municipality's wastewater utility, correct?
Correct.
And the way that this is paid for, if not paid for by grants, is by passing it on to the homeowners citywide, service-wide, correct?
Correct.
And you're not aware of any instance, are you, sir, where the costs for basic infrastructure upgrade have been attempted to be passed to property owners, particular property owners, by special assessment?
No, that's, all handled within the tariffs of AWWU.
But again, you're not aware of any instance where they've taken basic infrastructure upgrades and said, we're going to take a portion of the cost for this base. Again, all of this was necessary for the pump station, even if the improvement district wasn't built, correct?
Correct.
And
there's a couple of things I should say, though. A lot of times there's facility be upsized for the benefit of the whole system as opposed to the local users. And they will pay the cost of upsizing.
And I understand that. So let's talk about that for a minute, but that's slightly different. So if a contractor is building a subdivision and he's going to put in roads, waters, and sewers, and AWWU says, well, even though what you're putting in is sufficient for the subdivision, we'd like you to put in more, AWWU will pay to upsize, correct?
That's correct. Yes.
And because they're paying to upsize because they want to benefit more than those particular homeowners, they'd like these facilities to benefit more, right?
Correct.
But you're not aware of any instance where AWWU is building infrastructure that's going to serve the whole community. I mean, this pump station, it's going to serve the whole Turnagain area all the way to Turnagain Elementary School, isn't it?
I'm trying to.
Here, sir.
You have trunk improvement districts that will be paid by the residences and therefore the overall use of the system.
I understand, sir, that there is a trunk charge that people can be charged. Is that what you're talking about?
That comes out of it. Yeah, there's a lot, and that's all contained in the tariffs. There's a
Sure,
lot.
sure. And these people involved in this litigation, they're being charged a trunk charge in addition to the assessments. So, the trunk charge is in there. Trust me, they're paying a trunk charge. But this pump station, it serves, I'm gonna put on the board something from AWWU's website. And you can see that if you go from Turnagain Elementary School, the sewage flows all the way to this pump station.
Correct?
So this pump station serves this whole big wide area, doesn't it, sir?
Yes, it does.
Mr. Staley, do we have a copy of that in our exhibits? What you just put up?
I have some copies that we can mark after this.
That would be fine. Is that okay, Mr. Owens?
Yeah, I haven't seen them. I don't know.
It's just something that got printed off from the website.
That's fine. Please provide a copy to the clerk, and then she will enter it numerically after the end of the appellant's exhibits. I'm not sure which number that is off the top.
I don't think he needs to see it again. I'm not going to use it again, so.
Okay, can you give Barbara a copy? Is it 106?
It's not.
Okay. Okay.
And should we agree on what it should be marked?
You can mark it 112.
Okay, so that'll be marked Exhibit 112.
So again, with regard to this pump station project, all aspects of it, the new east trunk line, the water line, the deep subdrain, the pump station for the deep subdrain, in addition to the pump station for the sewer, all of that was necessary and a necessary part of the pump station for the pump station to be built and function for the community, even if the improvement district wasn't built.
That's correct. However, the design was set up to serve the improvement district also, and there were different elements that were, adjusted accordingly.
I understand that the improvement district benefits from this pump station, correct?
That's correct, yeah. A lot of these facilities are kind of a joint use facility.
Well, and the whole Turnagain community benefits from this pump station, don't they?
That's correct.
And, they all benefit from the pump station itself. I mean, you could put these lines in and the poo is going to pile up here without a pump station, correct?
Correct.
But you're not suggesting that these particular homeowners should pay for that pump station because they benefit to get their poo from that place to another place.
No.
So these schedules A through C really would have been identical. What was bid, even if the pump station wouldn't have been, or even if the improvement district hadn't have been built.
Yes.
And none of these costs associated with schedules A through C were added to the pump station because of the improvement district, correct?
If the pump station went ahead by itself without the improvement district, they'd pick up those costs, correct?
And not only that, but none of these costs were added because of the improvement district, correct?
In general terms, yes, there's a few specific things that, the depth of the east trunk, a few things like that were probably a factor of the improvement district.
Do you know whether or not the east trunk would have been any shallower or any deeper if the improvement district hadn't have been built? I mean, it still had to get from point A to point B, right?
Okay, the leg coming down from Marston down to the pump station had to be fairly deep in order to serve the pumps or the improvement district to the east.
None of the facilities themselves, though, were added to this project because of the improvement district. I mean, you didn't add additional water lines, or you didn't add additional trunk lines, or
No,
anything
that
else.
was set up just, what was going to be required for the pump station.
I want to talk a little bit about roads and drains. So you've got storm drains, and that's one thing, correct, sir?
Correct?
And that's not a deep subdrain, is it?
No.
And indeed, in this particular road, there are storm drains that flow, and they don't even flow into this subdrain pump station or anything. They just gravity flow into the storm drain system, correct?
We were able to keep those fairly shallow and drain into an existing storm drain, yes.
Now, 80% of the roads that are built have no kind of deep subdrain at all, correct?
Not sure on that statistic, but, that's
Roughly.
maybe.
That's the number you used in your deposition I'll represent to you, sir.
Oh, okay.
And 20%, the other 20% have what's called curtain drains, correct? And again, I'll represent to you, sir, that's what you used in your deposition. If you want to look at it, we can.
Okay. A lot of the subdrains are a simpler system than the deep system that we're using here. Yes.
Okay, and indeed, other than this one, 0% of the roads that you're aware of use a deep subdrain like this. You're not aware of any other road that uses a deep subdrain like this, correct?
I'd say this is specific with, with the slide area that we're in to, again, for the liquefaction.
So again, the deep subdrain was certainly required for Pump Station 10. It was required by Shannon and Wilson. It helped dewater the area. It helped cheapen the construction for the pump station. It helped lower the cost for them to build it. And it was a requirement for that. And you're not aware of any other road that required something like this.
I can think of a couple other deep subdrains we've done, but not to the extent of this project, no.
And it was not required for the Turnagain Northeast development.
I'm not aware of that design.
Well, Mr. Oswald testified, and he testified that it was not required, and you wouldn't dispute that, would you?
Well, no.
Indeed, the RID, the road, as it was originally designed, it had a storm drain and it had a curtain drain, didn't it?
As it was originally designed.
Yeah. Before the redesign, it was designed with a curtain drain.
Are you referring to what the city did to?
Correct.
For the original estimate?
Correct.
I believe so. He did have subdrains in there, and so I assume they were probably
But the
like
cheaper, less complicated ones, correct?
Correct.
And this deep subdrain that was ultimately put in was the most significant cost factor for more than doubling the cost of this project, correct?
You'd have to look into it a little bit more than that. I mean, that was a major construction cost, increase over what was done originally. But you also have probably the inflation and construction costs that was going on through that period I think that would probably be a larger factor.
Okay, so, but you had two things. You had one was increased cost for construction, but in terms of design changes, this deep subdrain was probably the biggest factor, correct?
Correct.
And not only did that add a lot of the cost to the construction, but it added a tremendous additional cost in terms of design, correct?
Yeah, it was, involved longer subdrains and pump station, and it was another major component of the design and construction.
In fact, if we take a look at Exhibit 100, page 93, I'm sorry, page 93 of 234.
You guys went through a lot of work here.
This is the letter to yourself as president of VEI, basically awarding you the contract to perform the engineering for the improvement district. And the current contract budget is $387,000, 900 something, roughly 388, correct?
Correct.
And looking at, and you might just be able to see this on the board, but looking at Exhibit 101 is a letter from VEI to Russ Oswald. 101, page 34, but again, you might be able to see it up here. I'm not going to go into a lot of detail on it.
Okay. Got it.
This is a letter to Russ Oswald dated January 14th, 2007, referencing the improvement district and basically saying that, gosh, costs have gone up a whole heck of a lot.
Correct.
And it identifies a number of reasons, a large one being the deep subdrain and subdrain lift station designs that were required, correct?
Correct.
So those costs for that design of that deep subdrain and deep subdrain lift station were passed to the improvement district, correct?
Correct.
And I'm just going to show a couple of documents here real quick, and you can probably testify from this from knowledge, but in October of 08, there was an amendment saying that you were going to get paid you being VEI, get paid $867,749 for the improvement district design work. And then ultimately, the final contract signed in 10 or 11 bumps it up to $879,000.
Okay, yes.
So more than doubled the cost of just your contract over time, correct?
Correct.
VEI didn't make the decision about how to allocate these costs. That was AWWU, correct?
Correct. AWW and PM&E.
And I'm looking at some notes here. The first one is Exhibit 97, page 40. And again, I'm going to be very brief. You can probably see it up here to the extent that you can read it at all. Exhibit 97, page 40. And these are notes. I don't know, is this your handwriting, sir? Do you recognize the handwriting?
It's not mine. It might be Mark's, who was working with us on the project.
Okay, and the date on the top of the page is March 29, 05.
Correct.
And midway down here it says Linda, and I don't know what the last name is, Watts or no, Linda Wantz. Who is Linda?
Probably Barbara Wiltsey.
Who?
Linda Barber Wiltsey.
And who's that?
AWU.
AWU. Linda wants to look at lid project contributing to pump station 10 budget. Oversize is negligible, but maybe the depth of the wet well could be a consideration. Do you see that?
Correct.
And I'm going to look at that same Exhibit 97, page 102. These are notes from November of 05.
Okay, what was this, the next one then?
102.
Okay, so that's Exhibit 102 or?
No, page 102, Exhibit 97, same exhibit.
Okay.
And the date on that
Okay.
The date on that is November of 05. And you can see that there was a meeting, and you can see PS10.
Correct.
PS10. Up above, you've got Marston. Then you've got PS10, and there's the discussion here, and it's got subdrain pump station. You can see that there's been a box drawn around it, and it's an arrow saying, let's push that up to Marston.
Okay.
So basically you were told that that cost should go to Marston, not to the pump station, correct?
Yeah, that was the decision that was made on that.
Okay, and that was AWU's decision, correct?
And I imagine PM&E was in there also.
You don't know, though. You were primarily dealing with AWU on this, weren't you?
The pump station 10 was AWU, but the improvement district was PM&E.
Okay.
And this would have been added to the PM&E project, so I'm sure they had to be in agreement.
I'm just about done. So I just want to look at a couple of other exhibits. So I want to just take a quick look at some of these. The first one will be, I don't know which one is N1 and which one is N2, frankly, but either N1 or N2, but it's the Turnagain Heights Water Improvement District, the WID. Do you have that one?
Yes, I've got it.
And this is basically a construction cost estimate for the WID, correct?
Correct.
And on this document, you've got on the top an estimated construction cost with a contingency of $733,000. And then below that, there's a box that says, note, the following items of work are funded by the WID, but will be constructed with the Pump Station 10 upgrade project. Do you see that?
Yes.
And so we've got the total WID construction cost of $842,000. Do you see that?
Correct.
And then we've got the total project cost of $1.229 million. Do you see that?
Yes.
And this box about the stuff that's going to be allocated to the WID from Pump Station 10, that's part of the schedules A through C, correct? Pump Station 10 schedules, correct?
Correct. Okay. Yes.
And this $1.2 million, that was the number that was given to the property owners in the assembly to approve for an estimate, correct?
Correct.
And this $842,000 figure for the total construction cost, both of those combined, that was the maximum funding available for the construction portion of it, correct?
Correct.
Okay. And we've got and so again, that 842, that was the maximum available for constructing the WID, taking into account what AWU had made a decision to do, which was pass a portion of the costs off to the WID from Pump Station 10, correct?
Yes, this was, I think it's a portion of that. I'm not sure it was 100%.
No, they didn't pass all of the costs of the pump station to the WID, obviously. They passed a portion of the pump station costs, a portion of the A through C schedule costs to the WID, correct?
Well, in this case, it was about 300 foot of water line going down Pete's Place, and that was shared between, because there was a couple lots there that needed to be served with the water and then also the pump station. So it was shared cost.
Okay, and I understand that, AWU took the position that these are shared costs, but again, what we're talking about is it's coming from schedules A through C, correct? The pump station schedules.
A through C.
Which you've previously testified, everything on A through C was required for that pump station, regardless of whether the improvement district got built, correct?
That's correct.
And so basically, and then AWU came to you and they said, we would like to try and have the improvement district pay for some of these pump station costs, and they began telling you what it was that you should allocate to the improvement district, correct?
I'm not sure exactly how the whole logic evolved, but yeah, it seemed like where there was shared use and both parties were benefiting, that it would be shared. And I think I think it came from AWU, the actual structure for how these things were divided. A lot of it was from the AWU tariff agreement.
Well, sir, I haven't seen anything that says that AWU either could or should pass infrastructure costs, basic infrastructure costs, off to particular homeowners via special assessment. Are you aware of anything?
Well, this is probably a better question to ask the AWU people, but I think they're set up and so that the AWU doesn't absorb costs for the benefit of individual residents.
Obviously. But again, everything on A through C was necessary for Pump Station 10, even if the improvement district wasn't going to be built, correct?
Correct.
Okay. And so I want to take a look at Charlie 4. And this is a C4, Charlie 4.
Okay.
And this is essentially the same thing that we looked at for the WID, only this one's for the RID, correct?
Correct.
And so, again, on the front page, we've got subtotal of total construction costs of $2.3 million, which includes this contingency factor, correct?
Correct.
On the second page, we've got, again, that same note that a decision has been made to have the RID pay for certain things that are going to be built with Pump Station 10 pursuant to Schedules A through C, correct?
Correct.
And that's with a contingency factor of $363,000 for a total maximum construction cost or estimated construction cost of $2.7, correct?
Correct.
Total project cost of $4.418 million, correct?
Correct.
And that 4418, that was the number that was used to give to the property owners in the assembly when they were balloting, correct?
Correct.
And that 2.7 figure was the maximum available funding for construction, correct?
Correct.
And that maximum available for funding anticipated not just the items from Schedule D, the RID, but Schedule D plus what was being proposed to be passed to the RID from Schedule B, correct?
Correct.
So if the bid for Schedule D plus the items from Schedule B that were going to be passed to the RID came in over this, it exceeded the maximum available funding, correct?
Madam Chair.
Yes.
Can I ask a question? Mr. Staley, to the extent you're asking this witness from VEI to verify the maximum available funding, I'd like the little foundation as to what his knowledge would be of the municipality's maximum available funding. He may know that, but I don't know that he knows.
Well, Assemblyman Evans, I think you'll recall there was testimony that there was testimony from Mr. Bernardini that the source of the maximum available funding on Schedule E4 came from the engineers.
We also heard testimony that those numbers there were not the maximum available funding as known to the municipality at that time. So, I mean, if you can tell me, if he can tell me what the maximum available funding was and how he knows that, I'm fine. I just want to make sure I know how he knows it.
Well, again, sir, nobody knows how much a project's going to cost till it's done, right?
Just a moment. Mr. Rolfs, can you answer for Assemblymember Evans if you know AWWU or the maximum available funding, how you would know that information, or if you knew that actual information?
What I'd say is these are estimates we put together with the project cost. And for instance, the part that was going to be the shared use, the joint use, I'm not sure how that was was divided when it went actually to the balloting, and also the overhead costs down below. I don't know if that was put in the balloting. I wasn't involved in that at all.
Sure.
So our part was just for the construction and construction costs.
Let me see if I can differentiate this a little bit for you. Do you recognize that there has been testimony that there is a difference between estimated costs and the actual maximum available funding that AWWU has, and those two numbers may not be the same? Are you aware of that in AWWU's, or the monies available potentially for these projects? Do you recognize the difference?
It wasn't an area that we were greatly involved in, so I'm not it's really AWU that is the authority on that part of it.
Okay, one moment, please. At this point, the chairman does not recognize that this particular witness has knowledge of AWW's financial position or funding of this. So there needs to be a foundation of that knowledge base. Otherwise, I'll ask you to move on to another line of questioning.
Mr. Rolfs, I'd ask you to take a look at E4. And by way of background, you've participated as an engineering consulting firm with regard to competitive bids in the past, correct? I mean, that's what you were doing in this instance, right? You were acting as a consulting engineer for AWU with something that was going to go out to a competitive bid, correct?
Correct.
And you understand, sir, do you not, that that in some instances, sometimes a project there is no maximum available funds. Sometimes it's just a matter of you get the bids and you look at it and you say, do we want to build it or not, correct? I mean, like Pump Station 10, it didn't have any maximum available funds, correct?
They had the amount they had budgeted for it. It was something that was needed. I suspect if they had to, or they would have come up with some additional funds.
Okay, are you aware, though, aren't you, sir, that when this went out to bid, that there was a main bid and a deductive alternate, correct?
Correct.
And the main bid was Pump Station 10, correct?
Correct.
And the deductive alternate was the improvement districts, correct?
Correct.
And you understood that if the bid for construction, not the whole project, but the bid for the construction portion came in above what's defined as the maximum available funds, but it's really the estimate of what construction should cost, that those projects wouldn't go forward, correct?
That's correct. There's different details in that also, but generally that is correct.
Okay, and so, and when the bids were opened, VEI was present, correct? I'm looking at Exhibit 45, page 1 of 1, July 15, 2008, 2 p.m.
Yeah, we generally attend the bid openings.
Okay. And so you were present at the bid opening.
Mark was there, yes.
And then I'm looking at E4, and this is that same date. And this is the bid abstract from the bid opening.
Okay.
And at that bid opening, in addition to opening the bids, they also open up the final engineer's estimate, correct?
Correct.
And then they fill in these blanks. And with regard to schedules D, E, and F, they also filled in a maximum funding figure, correct?
I see it there, yes. That's not done all the time, but yeah.
No, because some things don't have maximum funding, but a deductive alternate like this did, correct?
Correct, yeah.
A special improvement district has maximum funding, correct?
Okay, yeah, that's
So anytime you're dealing with a special improvement district, it's unique in that you have maximum funding, correct?
Yeah, you're right.
And those numbers come from these estimates that VEI prepared, correct?
Well, it comes from what was approved in the ballot, and the balloting was based on our construction costs plus whatever else went into the amount balloted. I didn't know what the amount balloted was. I
understand you don't know the amount balloted, sir, but you agree with me that this comes from the approved ballot, and there's there's more than one aspect to a project. There's the construction costs, and then there's everything else, right?
Correct.
Okay, and again, we look at Charlie 4, and that's the construction estimate for the WID that VEI prepared, correct?
Charlie 4.
C4.
Okay. Correct? This was our 35% estimate.
Right, and it included the 2008 escalation factor. And I'll represent you, sir. I can pull out the exhibit if need be, but that 4.4 million figure is the approved ballot amount.
Okay.
And you'll see that the construction cost is $2,701,545, correct?
Correct.
And that included not only Schedule D items, but the items that were going to be shifted over to the RID from Schedule B, correct?
Should be in there, yes.
And that number is identical to the number that was filled in at the max, for the max bid for the RID on bid opening, correct?
Correct.
And that's the same thing with the WID and the LID, correct?
It looks right here. I haven't checked them verbatim, but yeah.
Okay, we've looked at the numbers a lot, and we can look at them if you want, but I'll represent to you, sir, that those numbers come from the total construction costs from your estimates. That's all the further questions I have.
Thank you. We're getting to a point now where I'm getting concerned we're going to time out. It's 5 o'clock now. We still will have public testimony, and Mr. Boss is being recalled. So at this point, I'm going to give the witness a 5-minute break because he's been on the stand since 3:40, and then we will come back. Mr. Owens, you will have the opportunity to cross-examine, and then the follow-up questions, I ask that we do them expeditiously so we can make sure you have plenty of time for public testimony and your closing statements. Okay, so 5-minute break. All right, all parties are back in assembly chambers. Mr. Rolfs, you are still under oath. Mr. Owens, you, sir, may proceed with your questioning.
Well, Mr. Rolfe, let's get back to this notion of maximum available funds.
Okay.
As I understand it, VEI's offices are out on DeBar Road near Costco, east side of town. Is that right?
That's where our office is, yes.
And do you spend any considerable amount of your time in the accounting department at AWW?
No, not really.
Do you have any role whatsoever in monitoring the money that is spent by AWW on projects?
No.
You're not an accountant?
No, we're not.
They don't consult with you or report to you on the total amount of money that they spend on any given project?
Just engineering, our engineers' estimates.
And so when the term that was being used earlier of maximum available funds that AWW had in the bank available to spend on a project, do you understand that could be different than the amount of money estimated by an engineer for the cost of construction?
Yes, I anticipated it would be different, yes.
And when you were testifying before as to what you perceived to be the maximum available funds, were you talking about the costs, the estimated cost for construction?
Okay, what I was talking about, I knew there was a maximum amount that was going to be available, or else, we'd deduct the alternates if there wasn't enough funding for that portion. We weren't involved in developing.
You knew that there was a budget lid for the work.
Yes.
Did you know how much money had been spent at the time of the bid opening?
No, we didn't.
So you wouldn't have any knowledge about how much money was left over for the project when the bids were opened?
Yeah, at that point, we weren't advised what the ballot amount was even on for the project. We submitted our estimates, and that it was based on our estimates, plus there's different overhead factors and different things we're just not aware of. Yeah.
And you don't perform accounting for AWW?
No, we don't.
So let's also go back to this, the work that you were engaged to do. You had a contract for Pump Station 10.
Correct?
You had a contract for the Road Improvement District.
Correct?
Did you have separate contracts for the lateral and water improvement districts, or were they consolidated in a single contract?
The administration of the LID and WID was turned over to PM&E to administer along with the Road Improvement District. Since those are related, they're all in the right-of-way, a lot of the same excavation for all the different projects, and they're all the, the utilities and the road.
But I'm talking about the work you were engaged to do and how you internally reported your activities for purposes of reporting to the utility or the Public Works Department.
Okay.
Did you organize your affairs and the activities that your people did pursuant to the contracts that you had with Public Works and the utility?
Yes, we did. The WID and LID and RID were all combined into one contract that we had with PM&E, Public Works. And we had, within that contract, we had probably 20 different job numbers for different elements of the work. And so that our work was, charged to each of those different elements.
Okay, so there's 20 different job numbers for activities under those contracts.
Yeah, I don't remember the exact amount, but there were a lot.
There's a considerable number.
Mm-hmm.
Pump Station 10 was a separate contract with separate job numbers?
Correct. It was separate billing, yeah.
And was it your intention to have people at VEI who were performing work on these projects to record their time to the job number for the time they spent devoted to activities relating to that job?
That's correct. We spent the time to do that accounting, yes.
And was it the individual who was performing that work, was it that person's obligation to record that time essentially contemporaneously in order to ensure accuracy?
Yes, we have our weekly meetings, and different times we'd go over to make sure everybody was clear on the job numbers and where their time should be getting charged.
Right, and people generally tried to record their time every day.
Yeah, staff's generally pretty knowledgeable on this and the requirements. We were working on the project for several years, so.
And it was the staff person who performed the work that had the obligation to decide where it should be billed, to identify the work that they were doing.
Correct, and I would check timesheets at the.
Sure, you would check it, and I imagine it went through several layers of checking overall.
Correct.
All of which was designed to try to ensure accuracy in the way that the time was allocated and those expenses were allocated.
Correct.
And in fact, we've heard earlier that there was some confusion during the course of the work over how to allocate some of the design expenses as between these four projects. Wasn't that right?
That's correct. There were, it was involved enough. There were a couple places I think we did get a little bit screwed up, but we got that corrected. There was times, we weren't real sure. For instance, the pump station, the storm drain pump station was located in the Pump Station 10 area and in the compound there. And so how to break out those design costs, I think that was something that was discussed.
So there'd be occasions, if I understand what you're saying, occasions where the activity might have been related to a couple of different activity codes, and it'd have to exercise discretion on how to allocate and
we
prorate.
used our best judgment on it, yes.
And were you consulted when confusion came up and there was a need to kind of try to get it squared away during the course of the work?
Yes, yeah.
Or did AWW simply come in and tell you where to put your time?
We Like for instance, the storm drain pump station, that was something that was discussed with AWW and PM&E. And I forget exactly what all communication, but that was something that we all discussed and decided on.
Okay, so you played a role in it, and you were concerned about making sure things were accurately allocated as well.
Correct.
And you wouldn't go along with a scheme to bury time that was for the pump station into the bill for the lid or the RID, would you?
No, we can't do that.
And you certify to the accuracy of your reports, don't you?
Correct, yes.
So let's turn for a second to the question of subdrains. I put on the projector what's in your binder as Exhibit A8.
A8?
Correct. Are you familiar with this diagram?
Yes, I am.
Did you prepare this diagram?
Yes, this is something that came out of our office.
Does this depict the total area of the Marston Foraker Road Improvement District?
Yes, it does.
And over on the left, just for orientation purposes, my left, this side of the map, that is Foraker Avenue.
Correct.
And north is generally to the bottom of the page.
Correct.
And so the water is generally to the bottom of the page.
Correct. Knick Arm.
I'm sorry?
Yeah, Knick Arm's down at the bottom.
I'd like you also to turn to Exhibit C13. This was your letter of October 6, 2005. I'd direct your attention to the second paragraph. In subsequent meetings with Kyle Brennan. Who's Kyle Brennan?
He was the project engineer with Shannon Wilson.
And he actually testified here earlier yesterday.
Okay.
And he spoke to his design and the geotechnical report for the road and drainage improvement district.
Correct.
And you stayed here, you spoke with him, and he told you that the most important area for subdrains is along the Marston Drive right-of-way.
Correct.
And subdrains in other areas are less important and could possibly be eliminated.
Correct.
Is that your understanding of the kind of global picture of the project?
Yes, I remember this, yeah.
And so the Marston Drive, as it goes down to Foraker Avenue, that entire expanse, it sort of traverses the slope of the hill in that vicinity. Isn't that true?
Correct. And there was stream up there about the two-thirds way across the Marston that was providing a lot of water needed. That was an area that needed to be addressed.
Okay, and Mr. Brennan told us that the area of greatest concern was maintaining the stability of this slope. Would you agree with that?
Correct.
And one way, and one of the best ways of maintaining the stability of this slope was to remove as much water as possible from the area in order to improve the overall stability of the entire area.
Yeah, that was primary concern with this project, yes.
And that was more important than dewatering the pump station, wouldn't you agree?
Yes.
And the recommended way of doing that was to install effectively a curtain drain, which would go across that entire hillside and attempt to capture water and discharge it to a lower area.
Correct.
And the way that curtain drain was constructed was recommended to be these deep subdrains.
Yes, there was another element in there that there was concern about water standing in the deep utility trenches. You have porous backfill and now water being a source of liquefaction. So that was another element why we needed to get the subdrains down below the level of the sewer and the water trenches.
And if you turn to the second page of this letter C13, I mean, in discussion, there's, again, the first sentence, the subdrains in question, the less important ones are located in the vicinity of the proposed PS10 site. Is that consistent with your understanding of the priorities for the subject area?
Yes, I'm trying to remember we were trying to figure out just how far to carry the subdrains to the west, I think was one of the things we were looking at here that brought about this whole discussion and the feedback that we got from, we went to Shannon Wilson to get their opinion on it.
And overall, the priority was to stabilize the area where there would be homes as opposed to the area where the pump station would be.
Correct. That's, what, from his recommendation or from what he said here, that's what he, and that's consistent with what I know. We didn't have to worry too much there at the pump station. We were doing a heavy concrete structure that was designed to handle it, essentially.
Good. So down below under recommendation, item number 1, you say installation of subdrains over a wider area will eliminate more groundwater and provide more site stability during seismic events. What wider area are you referring to there?
Well, what I remember on this, I was personally pushing a little bit to extend it a little bit to the west.
To extend what a little bit to the west? Be a little more specific, if you would.
Well, were we going to extend the subdrains all the way over and up Sandstrom Drive, which is the road to the west where the old pump station was? We were building a sewer there. Did we want to do that or not? That was the question. And Kyle came back, said no. The main part is up there at Marston. We did extend it, the subdrain over as far as Pete's Place, and that's where we terminated them at that point.
Are you referring to the west trunk down near the pump station itself as the area that you're talking about extending the subdrain to the...
based on the original recommendation, you conceivably could have, extended out that far with them. And only it wasn't clear that's what the geotechnical engineer had in mind. And it turns out that he didn't intend for that to happen. We did we did extend it across to Sandstrom, and we perceived that would have some advantages for construction costs there at the pump station, as well as providing some protection and stability over at the lots on Pete's Place.
And so you're talking about the subdrain for the west trunk.
Yeah, just there's just a short section that goes over on the west
Right.
trunk, and that was, I think that's what this letter was centering on.
But you would agree that the real priority for this entire area was the stability of the slope and the subdrain that ran along Marston Drive.
Oh, very much so. That was the area that slid dramatically during the quake. You had the blocks of soil that had come down, and
understanding there could be advantages for purposes of construction, if the subdrains were eliminated from the west trunk, it would have been of relatively small significance concerning public safety issues.
yeah, the slopes are pretty mild in that area, and the geotech just didn't think there was that much of a need for the subdrains over there.
Okay. And if you were draining then the subdrain, using the subdrains along Marston Drive to capture water and stabilize this global area, the entire project site area, you're capturing water, where's it going to go?
Well, if you can do it shallow enough, you could drain it to surface drainage like the storm drain. In this case, we needed to go deep, and we had to pump it, and we've done that. Where we have difficult problems, but I'm thinking of condominium in South Anchorage, where we ended up having to pump the subdrains also. But
so in this instance, the water was being collected all along Marston Drive, and it was being directed to the east, the route that paralleled the east trunk, and
Correct.
took it down to the pump station area, the sewer pump station area, and that's where the subdrain lift station was located.
correct, we chose that as being a preferred location for the pump station access and serviceability, and all the utilities would be
So you needed that for the subdrains throughout Marston Drive,
correct.
and it wasn't just for the pump station,
That is
for the sewer pump station.
Yeah, plus where we wanted to pump the water to the subdrain discharge, this was a good spot for it.
Okay, so referring again to this Exhibit C13, this was written in October of 2005, correct?
October 2005, yes.
And at that time, the Assembly had already authorized construction of the Lateral Improvement District.
Correct.
And so it was sort of an operating assumption at that time that eventually the service would have to be extended to the Marston Foraker subdivision area.
Correct.
And so the Assembly had directed it and the owners had requested it. And so it was pretty much understood that at some point in time, there's going to have to be service extended out to Marston, and that would have to be fed into whatever pump station was in the vicinity for moving that material out and into the bigger infrastructure system.
That's correct. And also, when you design a facility like this, a pump station, it's engineer's responsibility to go around through the whole service area and make sure you're able to serve that service area. So in that case, even if this improvement district wasn't in the works, we'd probably still have had to design so they could be served.
Well, if area, the slide area, the Marston-Foraker district area, was in fact going to be used as a dedicated park and never developed, there wouldn't be any need to extend lateral sewers and out into that area or build a road into it.
If it was never going to be developed, and the trick is to figure out what's going to be developed and not going to be developed in the future.
So for present purposes, just for right now, let's assume that that happened. There was no assembly approval for development of this special improvement district. No road was ever going to be contemplated. It was dedicated parkland, or was never contemplated that it would be developed. The owners were unable to get a majority, whatever the case may be. This was green space with no intention of developing it.
Okay.
If that was the case, and AWW needed to upgrade Pump Station 10, that was a given.
Correct, yeah.
In fact, it was sort of expected when you prepared the DSR that the new Pump Station 10 would be built first and perhaps the improvement districts would come later.
That was the original intent.
Right. So at that time, if you assume that there's no possibility of developing the Marston-Foraker Improvement District, then there would have been several other possible alignments for how to get material to and from the new pump station site, wherever it might have been.
Are we talking about alternative pump station sites?
Well, for now, let's assume we're even using the same current where it actually was placed.
Yeah.
So you're just extending the pipe over from Sandstrom across Pete's Place and putting it there.
Yeah, that site would probably be the favored site, even if the LID and, the improvement districts weren't built.
Right. So if there is no intention to ever build the improvement districts, but the pump station was placed across Pete's Place where it actually ended up, wouldn't it be possible or make sense you have the west trunk that extends over to the new pump station location?
Okay.
And that's the flow coming into the pump station.
Right.
You could upgrade that. You could leave the existing east trunk that ran between the two houses, right? There's a desire to improve that as well. One alternative could have been to upgrade that.
Yeah,
and leave it in
might
play.
have gone a different route with that. Yeah.
And if you went a different route, couldn't you go down Pete's Place?
Possibly, yes.
And just build the new trunk down Pete's Place to the new pump station?
Yeah, you could probably do that.
And so, if that's the case, and that would have served existing customers all the way to Turnagain Elementary, right?
Correct.
Everybody in the entire western area that fed through this main, down through between the houses to the old pump station, if it was rerouted down Pete's Place to the new pump station, that could handle all of the flow for all of the existing customer base, could it not?
Yes.
And that wouldn't involve any of the configuration shown on this drawing, right? All of the new east trunk and the intercept running north-south would have been unnecessary.
Yes. You could, something simpler, probably.
Right. You would have had something simpler, and there would have been the expense of the pipe down here, but it wouldn't have jogged over to the east.
Yeah, and you wouldn't have had the easement constraints there.
And so this design was ultimately developed with the expectation that the improvement districts were going to go in and to accommodate those.
Yeah, the decision was made during the design that, it looked like a likelihood that was going to happen, and so that's where we put our energy and designed the.
So isn't it just as accurate to say that it was the Marston-Foraker improvement districts that were responsible for redirecting the east trunk of this sewer line in this fashion?
Yeah, I think you'd say that.
And in fact, this east trunk as configured is necessary to provide service to the Marston-Foraker Service District.
Correct. It's designed as both as a trunk and a collector there for the residences.
And what size would it typically be if it was a collector, the pipe?
Generally 8-inch.
And what size would it typically be as a trunk?
This is 12-inch, yeah.
Would it be reasonable then to charge the improvement district for the 8-inch pipe and the infrastructure or the utility for the oversizing to 12, and in that way spread the cost?
That's the custom, the way it's handled. As I understand, that's a requirement of the tariff.
And just to clarify again, the new east trunk was essential to provide service to the Marston-Foraker Improvement District.
Yes, that's in the standard location for a collector sewer.
And the route, the pipe that runs from the intercept on Marston north to the pump station was essential to provide service to the Marston-Foraker Improvement District.
Correct. That's a low point in Marston Drive where all the sewers collect up there on Marston.
And the subdrain pump station that was installed in the vicinity of the sewer pump station was essential in order to operate the subdrain system along Marston Drive.
That's correct. It's just kind of a parallel system in that way.
And where you have mutual or joint sort of shared facilities, as between the infrastructure trunk system and the collector or service systems, and both are being used for both purposes, a project manager will oftentimes exercise discretion in how to fairly allocate those costs. Wouldn't you agree?
Correct.
And one person might believe it should be done one way, and somebody else might think it'd be a little more fair to do it a different way, and reasonable minds could differ on that. Right?
Yeah, I think so. There's this, and there's probably 5 or 10 other things, that you could apply.
And reasonable minds could differ without exercising bad faith, right? You can have good faith and disagree.
Correct.
All right, no further questions.
Mr. Staley, I will give you 5 minutes if you want to follow up. And I'm going to set the timer. You'll see at the 1 minute mark, the yellow light will come on.
Charlie, 13.
Okay.
This letter regarding the soils report and the deep subdrain, this is referencing Pump Station 10. It doesn't reference the improvement district. Is that correct?
Correct.
And the date of it is October 6, 2005. It predates the reballoting and all the extra expense associated with the redesign of the improvement district, correct? I'll represent to you, sir, that your estimate didn't come out until the fall of 2006, and it was reballoted after that for the improvement district.
Correct. This is before the reballoting and this we were working on the design study at this point.
And it's the area in question, it says the pump station upgrade project is responsible for redirecting 2 trunk sewer lines to the new site, the east trunk and the west trunk. And again, looking at what Mr. Owens has left up here, graphic 7, I guess it is, A7. You've got the east trunk is this one, correct?
Correct.
And the west trunk is this one, correct?
Correct.
And the east trunk is the one that's in the Marston right-of-way?
Correct.
And that's the one that is more important, correct?
they're concerned along Marston for the subdrains, yes.
Okay. And ultimately, a subdrain was put in both a portion of the west trunk and in the east trunk?
Correct.
But it's not dealing, this letter, Charlie 13, is not dealing with ultimately what was put in terms of a deep subdrain for the rest of the Marston right-of-way for the road. That came at a later time, correct?
This was on the pump station with AWW, so this was just for the pump station.
Just the pump station portion. Okay. One other very quick topic. Mr. Owens asked you some questions about accounting and how you build and this and that and the other thing, and nobody's accusing you of fraudulently doing anything. Or trust me, no one's going down that road. But the point is this. Whether or not you build your design time to the pump station or to the RID was driven by what AWWU told you, correct? We saw that memo, that handwritten memo from VEI in, I think, November of 2005 saying, move the pump station, move the deep subdrain pump station from the pump station to the Marston Improvement District, right?
Correct.
You weren't making that decision, were you?
Well, a lot of these things, no, we wouldn't be, but I think that would probably be PM&E and AWW on that.
Okay, again, I'm not differentiating between them. The municipality was driving how you build, you weren't driving it.
Right.
So
As far as the accounting and where different elements are charged, yeah.
So you spent your time designing this deep subdrain, and if they said, don't build a pump station, build a lid, that's what you did, right?
Correct.
No further questions.
Mr. Owens, anything further?
Nothing more, thank you.
Thank you, Mr. Rolls, for your testimony. That's it for today.
Thank you.
So at this point right now, I want to have a discussion with council. Our time frame is 5:40. We will be adjourning at 7 p.m. I don't know how long you anticipate Mr. Boss's testimony. Do you have any idea?
About 5 minutes.
About 5 minutes?
5-10 minutes.
Okay. With that said, there's the panel would like for both parties to establish findings of fact and conclusion of law after this proceeding. And those items that I outlined in the beginning, the things that the court sent to us to say, we want all these things answered, do you need me to restate those? We would like you to address those points.
Yes, if would it be possible just to, at some point, maybe you could send us a list of the topics that you'd like us to address?
I think we're going to have to readjust the schedule, though. I'm scheduled to leave the state through the holidays tomorrow. And so you were planning on getting your conclusions out in 30 days, and you're going to wait for us to do something that we didn't.
Well, if
Madam Chair,
yes.
Could you please ask Mr. Staley to speak into the microphone? I'm sure the recording couldn't pick that up.
Okay, let me clarify. If in fact both the appellant and the appellee agree to draft conclusions, findings of fact and conclusions of law, then it would be this body's intention upon receipt within 30 days we would issue our findings. Would that be agreeable to both parties?
It'd be my preference, frankly, to not do it and just let this body do its work on its own, but only because of my schedule. I mean, I'm going to be out of state, then I've got a trial, then I've got, and so you're asking me to try and fit something into a schedule that's been set for a long time. I know you don't want to wait you don't want to wait 6 months for our proposed findings and conclusions, do you?
I'm looking for a yes or no answer from both the appellant and the appellee. Like I said, we're publicly noticed for this meeting, so we are up against a time constraint, and we've been very flexible with the schedule. So we need to know how to proceed.
Personally, I would be pleased to submit proposed findings of fact and conclusions of law.
Mr. Staley?
I just don't think it fits in with my schedule, but if the municipality is going to do it, I'm not going to waive our right.
So then your answer is yes?
My answer is no. I would prefer that neither party submit them and that the body make its own findings and conclusions as originally scheduled.
Okay, with that, then our second part to that would be whether you would want to waive your closing statements and just incorporate that into your findings of fact and conclusion of law.
No.
So that would be no. So with special counsel and conference of the panel, this panel is requiring that both parties do issue findings of fact and conclusions of law. By the end of this evening, you may confer with each other and tell us what your time frame will be for those to be submitted to this body. Once those are submitted to this body will issue our findings in fact and conclusions of law within 30 days. We've had 3 days worth of testimony. This is an incredibly complicated topic. This body really wants to know what both sides have to say about the points on remand. It's very important that we get it right, and it's very important that your positions are accurately reflected. Therefore, that is the order of this body. If you choose not to comply and issue it, I guess that would be your choice. But that's what we're requesting of you. Do you concur? Is there any objection to once we receive those, this body will take 30 days to issue our findings?
No objection to the body taking 30 days.
No objection.
Thank you. With that said, I also want to be very respectful of the public and the public's ability to testify on this topic. Mr. Boss is going to be allowed to come back and testify. But before I do that, I'm going to open up the floor to any members of the public or private property owners, anyone who wants to testify to this panel on this issue. You may come forward now. Yeah, I will. Sir, thank you for coming forward. My name is Assemblymember Domboski. I'm the chair. You will be sworn in by the municipal clerk, so please state your name, first and last name. Spell your last name for the record.
My name is Bob Quist, Q-U-I-S-T.
Mr. Quist, thank you for coming tonight. If you'll face Ms. Jones, our municipal clerk, raise your right hand and you'll be sworn under oath.
That the answers you will give to the questions asked of you in these proceedings will be true?
I do.
Thank you.
Mr. Quist, thank you for your testimony. Do you recognize you're under oath?
Yes.
Okay, please proceed.
Yeah, I'm a property owner. I own, lots 9 and 10 of Turnagain Heights subdivision. And I'd requested through the assembly some years ago to be eliminated out of this improvement district, and it was denied. And so, and I've got I also live there, and these 2 lots that I'm in question about, they're my backyard. They've been my backyard for 20 years now. I've lived over there for 28, 30 years, something like that. And all I wanted to do was just to keep it as my backyard. I never wanted to develop it. But I have, right now, it's over a $300,000 assessment on these 2 lots, which is going to force me into doing something that I really don't want to do. And we tried to replat to get these lots divided and you take the lot line out of, remove the lot line. So I'd have two lots. I used to own 3301 Iliamna Avenue and 3315 Iliamna. And I live in 3315, but I've sold 3301 now. But when I first started this, I tried to it was a long plat, to remove the lot lines, so I just had one lot that was going to be affected by this. And we didn't get the replat done in time. We had a couple extensions, but I worked on the slope all the time, and my son was doing it, and he works out of town and a lot of times out of country. And so when we had one signature we needed left to sign on this plat. And then when we checked on where it was at, we found out that the individual had been killed in an airplane crash, and we weren't notified of this. And by this time, our 18 months was running out, and so we never got it done in time. I came to the assembly again, and actually before I did that, I went to the mayor. We had a meeting with the mayor to try to get something settled. And there was some discussion about reducing this rate. And I think they would have taken it down to like $250,000. And I'd still have to go through the plat to get everything done, which, so I would have ended up with what was going to be called Lot 14A of a park subdivision. And that would have had, it's already serviced by water and sewer and road. And we would have had an assessment for Lot 9 and Lot 10 for water and sewer. And in the process of this, we found out that we still had about $2,000 on the original assessment. It was either on water or sewer. I'm not exactly sure which one it was. From the earthquake days. So that one lot would have ended up with 5 assessments for either water or sewer. I don't know which one it was, but anyway, so that got turned down at the assembly. We never got that through, and but I just think it's kind of wrong that we're being assessed this enormous amount, because nothing in this gave us any advantage to anything. I mean, we had road service. There was a gate at the top of 4 Acre. We had a key to the gate that the city had given us, and we would open it up for city employees or the police department if they needed to get down there. And we had it just to get into our backyard. We'd go down there and haul trash out in the trees and stuff in the spring. And other than that, there's nothing in this improvement district that has improved anything for us. Just caused us a nightmare. But anyway, I'm not part of this suit or anything. Not that I'm against it. I think they've got a good case, but I think our situation was kind of a little different because we voted no on everything there was, because we never wanted to be involved in this. We just wanted our backyard to utilize.
Okay. Does that conclude your testimony? Because I think there'll be questions.
Say again?
Does that conclude your testimony? I think there's a couple questions.
Okay, go ahead.
Okay. Do either of you have questions for Mr. Quick? Okay, I do. Mr. Quick, can you give us a legal description of Lot 9 and 10? I'm trying to figure out where exactly it is on the map.
Yeah, it's Lot 9, Turnigan Heights sub.
Turnigan Heights.
And Lot 10, Turnigan Heights sub. And the 3301 is Park Subdivision K14A.
And what about 3315?
It's Park Subdivision K 15A, I believe.
That's correct.
K15A?
Yeah.
Okay. And is Park Subdivision 15A, was that the only parcel that was serviced by water or sewer prior to these improvements?
Yeah, well, 15A, it's 15A and 14A are they front Iliamna, and you know, I've lived there since the 80s. First lived in 3301, then I moved to 3315 right next door.
And they both had water and sewer?
Yes.
Okay,
Yeah.
and Turnagain Heights lots 9 and 10 did not have water and sewer prior to these improvements?
Well, they did prior to the earthquake, but when the earthquake came in, then they, you know, the houses there all sunk and everything, and there's an alley between us, and that was what made the getting the long plat a little more difficult, because it had to be signed off by everybody in town, and we had just about all the signatures but one. And
Sure. Okay, thank you. Is there any other questions for Mr. Quick? Mr. Quick, we appreciate your testimony. Do you have anything else that you need to add?
no, I think that'll do it here.
Thank you, sir, and thank you for sitting with us these 3 days.
Yeah,
And we appreciate it.
I thank you.
Hello, sir. Welcome. Could you please state your first name and your last name? And
Yes,
spell your last
I'm David Dexter. I am the owner of 2219 West Marston
Mr.
Drive,
Dexter.
former Hitchens house.
Okay, could you spell your last name for us?
Dexter.
Mr. Dexter, thank you, Barbara. Mr. Dexter, do you recognize you're about to give testimony and you'll be sworn under oath?
Yes.
Okay, if you'll please raise your right hand and face Municipal Clerk Jones, she'll go ahead and administer the oath.
Do you solemnly and sincerely swear or affirm that the testimony you will give in these proceedings will be true?
I do.
Sir, you have 10 minutes to go ahead and present your position.
Okay.
Thank you.
I just want to make 2 comments. First of all, I concur with the Hitchens assessment that the road devalued the property. I moved in April of 2008, and that was before construction started, and it was a wonderful property to be in then. And you know, we've lived through the road construction, and now we have a big road in front of the house. Had no problem getting in and out of the property before construction, and it had the water and sewer, which wasn't a part of the thing. The reason I'm here is that they have their money in escrow, so it's their money that's on the line, but the house itself is still in limbo because of this unresolved issue. I'm the owner of the house, so my home is still kind of up in the air, in limbo. It's still subject to, I think, the same issues that the Hitchens went through, this uncertainty when they were trying to sell the house. If I were to try to sell my house now, I think I'd still run into the same issues, not having this resolved. My request of you is please resolve this. Thank you.
Mr. Dexter, I just want to see if there's any questions for you. Any questions from any of the members of the body? I have one. There's been some discussion about the easement that was negotiated and the pavement that was done. When the pavement was done in your driveway, can you describe to me, I'm assuming there was a negotiation and that amount was paid or reduced amount for the easements. Can you just describe to me what happened?
Yeah, there were 2 issues. You have the pavement that went around the front of the house. We didn't like. We knew that was going to be the front of our house in front of our road. We're also losing a lot of grass area in the front because there was going to be a road there. So we talked to the construction people, and it was Jeff Coleman, as he was in constant contact with us. We went through the whole construction process. We asked him if he could remove that. He said, yes, it will cost you the $780, and we just work that out that way, the way that was described. So that was our request. The other new pavement, they had to install a storm drain. There was a low area right at the bottom of our driveway because they raised the road level up in order to decrease the slope of the road coming down. So that created a low area in our driveway. And in order to put in that storm drain, they had to cut out some of the pavement, and then they just replaced it. And they didn't extend the area at all. They just replaced the old stuff.
I appreciate that. Thank you for the explanation.
Okay.
All right. Did you have anything else you wanted to add?
Once again, but this has been going on for several years. You guys, I keep seeing delay, and I just want my books closed, and I just want some closure.
Thank you so much for coming out and testifying tonight. Okay. Is there anybody else who would like to testify in front of this panel on this matter at all? Anyone at all? All right, seeing, hearing no one, we will move on to the portion of...
Madam Chair, so in light of the fact that you have ordered us to do the findings of fact and conclusions, I'd be willing to just waive the closings and go with findings of fact and conclusions. Bob?
If you'd like, if that's it, you're considering that, I'd be happy to take a 5-minute at ease so you two can confer.
Want to confer, Bob?
That's okay. I also do not mind. I also don't mind doing an abbreviated, 15 minutes each. That would accommodate to let Mr. Boss come back up. But I'm going to go ahead and give you 5 minutes.
Why don't we take care of Mr. Boz and then see where we stand?
Okay, I need 5 minutes, and then we'll be right back. All right, we're back on the record. We're on the record, right, Barbara? Okay, thank you. Mr. Staley, Mr. Owens, have you had an opportunity to confer?
Want to just do real brief? We're going to waive closings.
You're going to waive closings altogether?
Well, unless you want to do brief.
Well, if we have time, then you want to reassess after Mr. Boss? All right, so Mr. Boss has retained his seat at the witness chair. Mr. Boss, do you realize you're still under oath?
Yes, I do.
Okay, Mr. Staley, please proceed.
Can you get Exhibit G10, please?
Madam Chair, Mr. Staley, you need to probably can you just
Move that a little bit?
Thank you very much.
Yeah, okay. I'll not quite as tall as Mr. Dexter.
You said G10?
G10. Which I believe is the closeout activity report for the lid.
Okay.
Just help me, if you will, Mr. Boss, with what I'm looking at in terms of like AFUDC. Do you know what that stands for?
The acronym, Steve would probably have to help me out. What that basically is the cost of capital. We're basically financing the project with AWW capital money. So essentially, you have to recover like an interest on that money as you have it and are using it. And so that's what that is, as I understand it. But I'm probably not the best person to explain.
Maybe I called the wrong person back. Would Steve be better? I thought you were more the allocation guy or the...
I'm the balloting process guy and the tariff rules and regulations guy.
Okay. Who would be the guy for this?
You're just going to go over this table.
I'm just
and
trying
see
to
what's in
understand this. I think I know the cap pot. That's the basically the contracts like with or with PRUs, et cetera, correct?
I believe so, yeah. But again, you probably want to talk to Michelle or Steve.
Steve? Can I?
Oh, you can absolutely substitute
Okay.
witnesses here. Thank you. All righty, welcome back, Mr. Nuss. Do you recognize you still are under oath?
Yes, Madam Chair.
All right, thank you. Mr. Staley, please proceed.
Okay, Mr. Nuss, so was that correct? AFUDC, do you know what that stands for?
Yes, for right now, I'm forgetting it. But it is capitalized interest. Essentially, we borrow money and we get charged the interest on it. So this is the interest for use of funds during the development of capital construction.
And
Accounting for use during construction. I think that is AFU, accounting for use during construction. I believe
so to the extent the testimony was that you financed this up front, really you're acting no more than a bank who would give a construction loan charging interest of the contractor as the project goes on, right?
we are borrowing money to be able to build it. And so because we are borrowing money, we get charged interest, and we pass that interest on to the individual projects.
Sure. The second one, CAPOT.
Stands for capital outlay. That can include the actual construction contract. It can also include the acquisition of land, property, easements. It can also include things like purchasing of equipment and stuff like that.
The next one, labor.
Labor is in-house labor.
So that's AWWU labor?
Correct.
And so this isn't, I mean, this is just, well, are you salaried or are you hourly? How are you paid?
Hourly equivalent for me. Other staff are direct hourly.
Okay, so you're salary but hourly equivalent or whatever, and other
Yes,
people are hourly?
40 hours.
But this isn't over and above wages. This is just their wages that were paid to them for time that they spent on the project.
Well, it's fully burdened rates in here.
Say that again.
This is the fully burdened rate. So this includes things like cost apportioned to leave, medical, all that stuff. So this is a fully burdened rate that you see in here for labor.
Okay, and so again, just so I'm clear, so somebody's working for AWWU a 40-hour week. They normally, even if they're not working on this project, they would normally make $1,000 for that week, let's say. And so if they spend that week working on this project, then you've charged $1,000 plus something for their vacation accrual, benefit accrual, and all of that.
Correct.
Okay. The other category, what might that be?
Other permits, there's a whole PeopleSoft chart fields with different things. A lot of these times, these are permit fees, things where we have to go to ADEC for plan review. ADEC reviews all water and sewer plans, and so we have to submit payment to them for their review of them, those kind of things. Overhead, so when AWW works on projects, there's a lot of my time gets billed to overhead, and those get spread across a multitude of all active projects at that particular time. Because I'm not just working on one individual project, I'm working on the overall management of the program, and so those costs get spread. So that's overhead. Plus, there's other overhead costs associated with other AWW work and how it contributes to.
What other things go into overhead? Building costs? I mean, facilities costs?
No, there's a whole cost calculation. Folks that work in finance processing, the invoices and things like that, there's a certain percentage of those times and everything like that that get included in the overhead to manage the program and execution of a project.
Okay, overhead again, though, I understand it that it's not a matter of people billing time. It's calculated as a percentage of construction?
No, not in this case. There's a formula, and our finance people deal with that, and I don't know all the exact formula details. They apply this on a routine basis as projects get charges accrued against them. They apply the overhead costs against those projects, and so you'll see our overhead rates are 7% or so.
Okay, but again, so the overhead rate is as a percentage of what? Of the contract?
percentage of the cost incurred against that project. So it's just not just the contract. It can include the labor, other costs, professional services expenses. So it's a combination of cap outlay, labor, other PRSVC, and those combined costs. It's not just on any one. It's the
Okay, I probably misspoke or confused you. I didn't mean that it's a percentage of the construction contract. It's a percentage of the total costs.
Well, it ends up, but it's not an exact percentage. There can be times when overhead, because say there's only 10 sewer projects built, or 10 sewer projects open at one particular point in time, and 5 of those projects had costs hit against them during that month. Those 5 projects that only had those costs hit against them get billed the overhead in that particular month, because those were the active projects. So it's not a straight percentage necessarily. It averages out generally to about 7%.
Okay, and I'm going to repeat it back. I think I understand, but I'm going to repeat it back. So overhead is calculated as a percentage, but it's not necessarily a straight percentage because it depends on how many different projects you have going on in a given month. And so you look at all of your overhead, and if you've got 10 projects, you divide that total overhead between 10. If you've got 5 projects, you divide it between 5. Well,
that and the proportional against the amount of money spent on those projects.
And so then if you have a project, like let's say that this one for some reason had failed to go forward. Let's say that you had spent a certain amount of money leading up to the second ballot, and the second ballot failed and it didn't go forward.
Right.
What happens with that? Does that get built into overhead?
What that does is then that's not applied to this overhead. This is capital overhead. That gets absorbed and expensed to the operating budget, and all of the ratepayers across the municipality or AWW service area ends up paying for that as part of the cost of doing business for the utility. So it gets absorbed into operating.
And is any of that recovered through future projects?
Not through future projects, no.
Okay. That's all the questions I have.
Thank you. Mr. Owens, do you have any follow-up? Thank you, Mr. Nuss. Okay, so very quickly, I'm just going to go back through and essentially articulate for you what we would like your findings of fact and conclusions of law to cover. These were the issues on appeal identified. First, the special assessments exceeded the value of the benefit conferred upon the property owner taxpayers. Second, Bob, did you want to write these down?
I think I've got them written down, but I want to double check.
Okay, I'll pause for just a minute. Just give me a wink when you're ready. Mr. Staley, did you get the first one?
I did. Thank you.
You're welcome.
Assessments exceeded the benefit, right?
Yep.
If assessed costs, including the lift station costs, were not approved by the property,
Okay. So, yep. Number one was the special assessments exceeded the value of benefit conferred upon the property owner taxpayers. Number 2, that $1 million of cost of constructing Pump Station 10 lift station was improperly shifted to the improvement districts. Number 3, the costs for 3 improvement projects must be reassessed under AMC 1920, 340, and 3.60.
Say that one again.
The costs for the 3 improvement projects must be reassessed under AMC 19.20.340 and 3.60.
I think that's just the one that refers it back to you guys.
I think it is too. I'm just reading them all because I'm being overly cautious. Number 4, whether the lift station project costs were improperly imposed on lot owners. Number 5, whether assessed costs included the addition of an independent lift project that was not approved by ballot of lot owners. Number 6, adjudication is required rather than merely legislative because there are no disputes of facts. We kind of handled that. Number 7, whether bidding procedures were properly implemented. Number 8, determine how costs are offset, i.e. benefits conferred to the property owners. Additionally, the panel would like both parties to address a couple specific issues. We would like your opinion, or we would like comment on muni ordinance and regulations that govern at what point parcels can and must be added to improvement districts. Also, under code, when can an improvement district be dissolved? And if by chance you recognize a mechanism, that would be helpful for you to hear what your opinion on that. Is there anything else that the panel believes should be included that maybe hasn't been articulated? Okay, good. All right, the time, let me just look here. The time is 6:17. Would both parties like to have 20 minutes for closing each? Okay, and I believe our stipulation said that the municipality went first. Is that correct? Yes. Trying to find it here. All right. The appellee MOA through its designee, we've stipulated obviously by agreement tonight, it will be allotted 20 minutes to present closing arguments. Mr. Owens?
Thank you.
I'll go ahead and set the timer for 20 minutes. At the 2-minute mark, there's the middle light will light up for you. Please proceed.
Okay, thank you very much. I genuinely appreciate your time on this. I know it's been very confusing. I believe it's undisputed. There's been no testimony presented that challenges the fact that the charges for work and materials that were actually assigned to items in Schedule A were accurate. It's clear that there's no dispute that the actual costs for the items listed under Schedule A are accurate, nor is there any challenge presented this evening to the actual charges for work and materials under Schedule B or C or any of the other schedules. The costs that we have presented, the information and allocation of specific costs have not been challenged. The key disputes go to whether the costs of the components in Schedules A, B, and C should be charged to Pump Station 10 exclusively or shared by Pump Stations 10 and the improvement districts. Whether the subdrains were required to improve the safety of people living in the area, or whether the subdrains on the hillside were needed to connect to Pump Station 10. We've presented evidence, being the municipality, that project managers reasonably shared costs for shared components. Schedule A consists of the sanitary sewer improvements. The east trunk, which we've spent a lot of time talking about. This east trunk along the top here is a shared use facility. It had a basic, the service for this area would have had to extend the service line through the right-of-way all the way up, and that would have been an 8-inch line, as we've heard. The actual costs associated with this were allocated. The 8-inch cost to the 8-inch pipe was for the lateral improvement district, and the cost of upsizing it to 12 was charged to the utility. In addition, the trenching for burying that line was shared equally between the utility and the improvement district. And the backfill and manholes associated with this east trunk were similarly shared equally. Pump Station 10 paid for the upgrade on the 12-inch line, and Pump Station 10 paid for 100% of the cost of this line running north up to the pump station. So this, the the main, the pipe, the trenching, the excavating, the backfill, all of those expenses for this line were charged to the pump station, not to the improvement district. With respect to Schedule B, the evidence we presented was that the storm drain and related subdrain improvements were allocated as well in Schedule B. Pump Station 10 paid for the storm drain and these subdrains that were installed where they were installed on the west trunk, running from the old pump station to the new pump station. The other subdrain associated with the Marston Road right-of-way and its ultimate delivery to the subdrain pump station and for full ultimate discharge were all appropriate costs for the improvement district because they were necessary to stabilize the greater hillside and to dispose of that water. So Schedule C involved water improvements. In that schedule, the portion that was assigned to the improvement district related to the two lots, lots 1 and 2 in Pete's subdivision, extending existing service across those two lots. And that was for the improvement of those two parcels, and it was charged to the improvement district. From that portion down to the pump station was paid by the pump station. That broke out to about a 75-25, 77-23 percentage roughly of that length of pipe. So the trenching, excavation, backfill, and associated costs of burying that pipe was split 77-23. In addition, the Water Improvement District paid for one hydrant that was installed up in the Improvement District service area and 2 valves. The pump station paid for 75% of the run of that pipe, and it paid for 75% of the trench excavation, backfill, and disposal. Now, the subdrains engineer, we heard Kyle Brennan, who talked about the need for the subdrains, and it was necessary to protect people and not the pump station. The subdrains in the vicinity down below were done for the convenience of construction and to preserve some of the area, but it did not drive the need to install subdrains elsewhere. The owner's evidence, in contrast, consisted of what Mr. Rolfs testified at the end about how he was understanding the way this went together. And they presented some evidence consisting of documents that used shorthand references to Pump Station 10 as being everything within A and Schedules A through C. And it was a secondhand interpretation of the Shannon and Wilson report. But it was there is no evidence that they've presented that contradicted the fact that this allocation of the shared costs was appropriate and reasonable as indicated by the project managers. So in conclusion, with respect to the question of whether the components were appropriately allocated, the work and materials included in the basic bid, Schedules A through C, included components that were used by all 4 of the projects. Special effort was made to develop schedules that enabled them to be broken apart and constructed and monitored throughout. And the managers exercised good faith in attempting to allocate those costs appropriately. The subdrains clearly were required to protect health and safety on the hillside, and that was the driver for those expenses. It was appropriate to charge the improvement districts for those costs. Now, as to the accuracy of the rolls themselves, the evidence presented goes back to this notion of schedules. Everything about these jobs was broken down into individual line items that involved work or materials. Those were developed early on in the estimating process. They carried through the work and development of design to the point of developing the bid documents, evaluation of the bids, construction of the work, monitoring progress of that, inspecting the work, and assembling the charges for those. It was all based on the schedules that were developed and that specifically identified the work and materials to be included. These, the evidence demonstrated that the work was monitored throughout every step of the way. There were field inspectors on site watching the work, comparing what was being done to the schedules and verifying they were going in. There were laws with criminal penalties against the contractor for submitting false certifications of work that was being done. And the project managers had multiple layers to verify the accuracy of these pay requests. So through the time of, once the contract was let, every step of every labor and material that went into all 4 of these projects was carefully monitored and documented. Back in the offices, the AWU and Public Works people double-checked for accuracy of the pay requests, and accounts payable staff monitored the progress of the work. In the end, the state of Alaska audited the costs of the pump station. They found everything, all the costs were approved. There was no evidence presented that any of the charges included in the assessment rolls relate to the pump station itself. The plaintiffs don't question the books of account that have been presented, the costs that are, we've provided absolute detail of every charge for every one of the 4 projects. None of those or those allocations have been challenged. There's complete accounting, and it's organized, summarized, indexed. They've had lots of time to look at it. If you accept the allocation of the shared costs and the component parts, then the assessment rolls necessarily follow and deserve to be approved. On the question of benefit, benefit is not measured solely by market value, nor is it measured immediately after the project is wrapped up. There's a couple of cases cited in the briefs, including Kasani versus the City of Anchorage and the City of Wasilla versus Wizinoff. In Kasani, the Supreme Court held that so long as the property receives some benefit, gain, or advantage, the assessment will not be considered arbitrary or unjust. In the City of Wasilla, they said that the benefit need not be direct or immediate. So the burden is to prove that the assessment is grossly beyond benefit and that it's disproportionate and or otherwise illegal. Further elaboration of these standards is in my briefs submitted for this hearing. The evidence showed that nearly every property owner that sold a lot since the improvements were completed was able to recover 100% of the assessed values assigned to those lots. That's an indication that they received benefit at least to the extent of the assessed value. There's no dispute that every property in the improvement district increased in value, and the evidence showed that many saw immediate and substantial. 2 minutes? Oh, okay. Every property saw increased value, and many of them doubled, tripled, or quadrupled in value immediately after, not to mention how the values will increase as the area builds out and these homes that are certain to be showpiece homes go into this neighborhood. The bottom line is that the immediate increase in market value equal to the amount of the assessment is not required. We don't have to prove that. Many of the lots in the district did see an immediate, quick, full increase in value. Other lots received substantial immediate increases, and that'll continue to grow as the area builds out. So while it might be true that not all subdivisions appreciate in value immediately, and you can't have guarantees to that effect, this area is probably an exception. It's clear that this is a very desirable neighborhood. It's going to attract top-end homes, and as this builds out, this is going to be a very desirable place to live. Therefore, as it builds out, every lot is going to benefit through the long-term use of this land. Also, the other thing to remember is that some of the cases that are relied on for limiting or controlling the way that assessments should be assessed or improvements should be assessed involve assessments that are involuntary, where the city or the state comes in, builds a road, and assesses people, none of whom had a say in the process. And that's where there's a genuine concern about fairness. In this instance, it's a voluntary assessment. They came to the city and asked that this be put in. They saw the estimated cost in advance. They understood their commitment when they signed those ballots. And they decided for themselves whether that value that they approved was proportionate to the return that they expected to obtain upon development. So the owners decided that question of whether it was proportionate themselves. Now, the accuracy of the bidding process. We've got additional cases and things in the pre-hearing brief, but generally the standard for mistake in Alaska is established by a case called Alaska International Construction versus Earth Movers of Fairbanks. A mistake has to be significant enough to render enforcement unconscionable. The mistake has to be material. It has to have occurred despite ordinary care being exercised, and it needs to be possible in the end to place the other party in status quo. The evidence here was that Mr. Bernardini walked through the steps perfectly. He observed what could have been a mistake, pointed it out to the bidder and said, please, we're not saying one way or the other, but double check. Make sure that you can perform it on the values that you've submitted. When they came back and said, oops, he didn't just take their word for it. He asked them to provide proof. Demonstrate to us that you exercised ordinary care, that you tried to avoid this. And in fact, they submitted that proof, and it was only after those steps occurred that he finally agreed to allow them to withdraw their bid. Now, on this issue of whether the bid was too high for maximum available funds, the invitation required sufficient available funds before award of Schedules D, E, and F. The dispute is over this term of maximum available funds. Plaintiffs say that the amount shown on the bid tab sheet, the handwritten amount, $2.7 million, has to include both work and materials from the specific line item that the figure is given. For example, Schedule D had $2.7 million. Plaintiffs contend, or the appellants contend, that that 2.7 has to include not only the clearly indicated Schedule D, but also some amount up above in Schedules A, B, or C. Our contention is that the maximum amount for the line on which it is written refers to the schedule of the same line. So Schedule D was 2.7, Schedule E was whatever, and Schedule F. It did not incorporate whatever was in A through C, and there's no indication that it would if you look at the sheet on its face and its simple meaning. According to the property owners, the procurement rules were violated when the improvement district contract was awarded because the combined cost of the improvement districts with A through C were combined with D through F, and somehow that exceeded the maximum amount written on that form. But we've presented the testimony of project managers who were monitoring the accounts and knew how much money was available at the time, and who testified that the tabs were selected because they were believed to be adequate for the amount listed on that row. For Schedule D, it was 2.7, etc. The owners refer to a document that was prepared at least 2 years earlier, the estimate. It was prepared 2 years earlier for a different purpose. It shows the same number as the number, for example, that was on the bid tab. And in the estimate, that total is comprised of two other numbers. So they would have you believe that if you see the sum of those two numbers, when that sum appears again, it must mean those other two numbers. It's like saying 50 plus 50 is 100. So 2 years later, on another document, totally unrelated, you see the $100. They want you to believe it means 50-50. But it could equally have meant 60 plus 40, or it might simply have meant 100. The fact that there was a number on a document 2 years earlier does not mean that the component parts of that number are the maximum available funds as listed on a different document prepared for different purposes 2 years later. The bid tabs form was not conclusive proof that the terms of the invitation to bid, in short, were violated or intentionally violated. It's certainly not proof the handwritten bid tabs form is not proof that AWW planned to cheat the homeowners by shifting pump station expenses to the improvement districts. If it's proof of nothing, in fact, it's proof of nothing that justifies releasing the property owners from their promise to pay for the improvements. Now, I have two other points, and I've got 2 minutes. Okay, there's much ado about AWW's purported failure to pay for the short section of road. I think we've covered that fairly extensively. The road from Pete's Place was paid. The other goes to a question of assessable costs and interpretation of the municipal code. AMC 1930-040 addresses assessed improvement costs in general. It's just generally the one that's intended to cover, and it was the original provision for assessing improvement costs. AMC 1940-090 is the assessment share calculation in the chapter governing street improvement districts specifically. Now, I believe plaintiffs are likely, or appellants are likely to say that 1930-040 is the so-called cap on costs provision. It limits project costs to construction costs plus 20%. I'm very, very close. This is the provision of 1930-040. And you'll see that in Part 1 is the reference to construction contract costs plus 20%. Basically, there's a list of 3 things, and the assessed amount must be the least of the 3. Number 1 is construction contract costs plus 20% for non-contract costs, including but not limited to engineering, supervision, net interest, pay for property acquisition, and the like. That follows the underlined portion above. And it states, Part A, generally, except as provided in Part B below, which is dealing with projects financed by bonds, except as provided in Section B or elsewhere in this title. The project costs are limited. So it refers to and allows for exceptions that might be contained in other provisions of Title 19. Title 1940, governing street improvements, contains a provision that defines total project costs. That is in 1940-010. And it states that total project costs means all costs, direct and indirect, incurred during development of the project. Then it goes on to describe in 1940-100, Part A, the provision that defines the 70-30 program that is in play in this case. That provision states that an upgrade upgrades one or more local roads that have not been constructed to the specifications and standards of the municipality. Assessable costs for upgrade rids shall be 70% of the total project costs. So under 1940-100, street improvement costs are to be allocated 70-30, and those costs include the total project costs, not the cost of construction plus 20%. The cap for street improvement costs comes in 1940-130, where it says final assessment shall not exceed the property owner approved assessments by more than 10%. That's the cap. Thank you very much.
So, Mr. Staley, I will extend to you the same courtesy as Mr. Owens. You will have 23 minutes instead of 20 minutes, and I will put your yellow light will come on at the 2-minute mark. Alrighty, sir, you can go ahead and proceed.
I too want to thank you for your patience in listening to the evidence. I know that it got a little bit overwhelming at times and a little bit burdensome, but I appreciate your attention. You obviously all did pay attention, and we really do appreciate that. We can't really ask anything more other than that you consider the evidence fairly. I want to start with the Hitchens. Frankly, I don't think I need to spend much time there. It's pretty much a no-brainer. We shouldn't even be here. And if that one guy's boss wouldn't have died, if the one guy's boss wouldn't have died, we probably wouldn't have been here. So they really fell through the cracks. But you can't really treat them differently than the McLeods. They were in the same situation. They've been fully taxed as fully assessed the whole time. The assessor said their property value didn't change. You made an accommodation for the McLeods. You can't treat the Hitchens differently without being arbitrary and capricious. You don't want to go there because then you open yourself up for what else did you do that was arbitrary and capricious. So I agree with Mr. Dexter. Let's get that one done, and let's get it done as quickly as we can. So I want to move on to the other issue. And there is a broader issue that's very similar to the Hitchens, and that is this issue of that the assessments must be proportionate to the benefit conferred. And it doesn't just apply to the fact that the Hitchens value actually went down. Some of the other lots also didn't receive a benefit that was proportionate to the amount that's being assessed to them. Mr. Quist came up here as an example. And this is another issue. He said, well, this is voluntary. This isn't involved. Well, that's not true. 43% of the people didn't want it to happen. The Hitchens didn't want it to happen. The Quist didn't want it to happen. Numerous people didn't want it to happen. This has been involuntarily imposed upon them. It certainly was involuntarily imposed on Mr. Quist. He had a backyard that he was enjoying. He doesn't want to develop it, and suddenly he's got $300,000 worth of assessments he has to pay, and he's forced to sell a home that he's lived in forever and wanted to live in for the rest of his life, and that's frankly just not fair. And so there does have to be a relationship to the assessments and the benefit conferred, and that is the law. And so you don't get to say, well, maybe 30 years from now your property values will rise to the point where it'd be worthwhile to having done that. That's not the standard. It has to be, might not have to be immediate, but it has to be more immediate than that. And so what are we going to do about that? Well, frankly, one of the things that we're going to do about that is we're going to look at, well, how else are these assessments allocated? How else are they capped? And maybe some of that can be taken care of that way, okay? So I don't want to dwell on what we're going to do in an individual case because I want to look at the assessments as a whole. And so let me move on to that. And so when we look at the assessments as a whole, the first thing that we have to look at is what can be assessed to these property owners. And the only thing that can be assessed to these property owners are the things that are specific to their improvement district, okay? You can't add in other things. You can't add in other. Indeed, the law states that this was supposed to be kept separate. It wasn't supposed to be commingled. And it got commingled, and it got commingled without the property owner's consent, and it got commingled without the property's knowledge, and they weren't even told about it until the very end. And so what do we have here? Can you get me or Bob, can I borrow yours if you still have it handy, that sheet? So what do we have here? Well, we've got this pump station, and Mr. Owens wants to say, well, gosh, this benefits the improvement district, and we don't deny. You know, the water benefited the improvement district. We don't deny. Indeed, the pump station benefits the improvement district. We don't deny that. The whole darn thing benefits the improvement district. But the reason why you don't get to allocate it to the improvement district is it doesn't just benefit the improvement district. It benefits everybody. And that's the distinction here. This is a capital improvement project. This is basic infrastructure that benefits a number of people. Certainly, every aspect of this benefits the people in the improvement district, but it benefits everybody. And this is the cost that was associated with building this is properly allocated system-wide. And so the first thing that you need to do is you need to say A through C was represented as the cost of the pump station. That would have been the cost of the pump station, even if they hadn't have built the improvement district, and so that has to remain the cost of the pump station. That, again, is not difficult. It doesn't cost the municipality anything. It's passed on to the ratepayers. If we've got 150,000 households, that's 50 cents a month per household for a year. That's it. And that's done. It's paid for. That portion of it that was misallocated, commingled to the people here. If it's 75,000 households that we have in the system, it's 50 cents a household per month for 2 years, or $1 per month. I mean, we're not talking something that's really burdensome here. It doesn't cost the municipality. It's right. It's fair. It's something. And you know what? Let's take a look at a whole other issue, which is this max funding issue, okay? This concept of maximum available funds has been misunderstood. It's like, how much money is left in the bank? Well, that's not it at all. That's not it. It's you take a forward look. It's the whole idea of the estimate. Way back when you went to the property owners and you approved a budget, okay? And so it's the concept that we're dealing with here is an approved budget that they approved, you guys passed, and that was it. And a portion of that was allocated to construction, and that's the maximum approved funding available for construction, and a portion of it is available to the rest. That's the reason why those numbers match up exactly to the estimates. It's a budget that was approved, and there was a budget that was approved for construction, and there was a budget that was approved for the rest of it. And for them to say that there was the money there and that we looked at it, well, then why didn't they bring the evidence in? Why didn't they bring the accounting in? They didn't bring any accounting in. They didn't bring any evidence in. What they said was, oh, we think it was there. Well, take a look at what the evidence did show. The evidence showed that the bid that Pruz did for the RID was $500,000 over that max funding number. And the only thing that was left was for Pruz to perform. He performed well. He came in under budget. And yet the whole thing came in $500,000 over the proved total project costs. Coincidence? I don't think so. So what are we going to do about that? This is the toothpaste out of the tube, okay? What should have been done was they shouldn't have accepted it, and they should have rebid it. That's what the homeowners wanted, that's what the bid process said, but that's what they should have done. And so they didn't do that, so what does that mean? Now, is the whole thing void? Well, why don't you take a creative approach? If you say A, B, and C properly belong to the pump station and didn't belong to the RID, the WID, and the LID, suddenly Pruz's bid for Schedule D alone, if you don't add in Schedule B, comes in below that maximum available funding. That problem more or less goes away. And so, again, you're dealing with these legal infirmities by just taking a look at really what should go on here. And the cost for the pump station should be borne by the pump station. It doesn't cost the municipality anything. It doesn't burden the ratepayers very much at all. It's proper because if Girdwood needs one or Eagle River needs one, everybody pays. That's the way that it works. And suddenly that whole maximum available funding issue isn't an issue at all because you, as the panel that decides it, have said that the proper way to look at this is that just Schedule D, E, and F belong to the improvement district, and so then we don't have to worry about bringing those other things in. So then the maximum funding issue suddenly goes away. And so you solve two birds with one stone by looking at that. So if we do that, has that solved this whole equity problem? Well, there's still another issue, and that issue is in addition to transferring the construction costs for the pump station, certain aspects of the pump station improperly, it transferred over design costs, engineering costs, et cetera. And how are we going to sort all that out? You know, are we going to have to go through every line item? And again, the law provides the simple answer for that. And that's the difference between allocation and capping costs, okay? And I'm going to put up to you the headline for Title 19. And I want you to take a look at this, okay? So we've got the various different sections here. We've got, how they're authorized, special districts authorized. We've got creation and dissolution of special assessment districts. So clearly they can be dissolved. We've got calculation of improvement costs, okay? Calculation, that's that title. Then we've got allocation of street improvements, allocation of off-street parking, allocation of water improvements, allocation, so all these other things, allocation of sewer. So there's a difference between allocating and capping, all right? One thing is you say, all right, we've got total project costs, and we know what that is. That is everything, but can you assess total project costs? Well, no, you can't always assess total project costs. There are limitations on it. And so that's where 1930-040 comes in. And it says that the project cost assessed against the benefited parcels shall be the least of the following. Construction contract costs plus 20% for non-contract costs, including, but not limited to, engineering and design, surveys, soil investigations, right-of-way negotiations, inspection, and contract supervision, and net interest, remember that net interest thing, plus actual property acquisition costs. Okay, and then it's got some other ones, but it's the least of them. So if this is the least of them, then that's the one that controls. And what does that do? That does a couple of things. One, it doesn't allow the municipality to come in here and load these projects up. Again, McQuillan says you're supposed to look at this, when you're going to do this, you're supposed to look at this for the benefit of the taxpayer that's being assessed. And so it doesn't allow them to load it up with all kinds of miscellaneous costs, et cetera, et cetera. It says, you know what this should be, and it's the rule of thumb that Mr. Ralph said. He said 12% and 8%, which adds up to 20%. You had Mr. Spinelli said basically 10% is what his experience has been in private development. This gives 20% for all of those add-ons, which is the rule of thumbs for what Mr. Ralph said. And so that's really what you're looking at here is you're saying construction costs plus 20%. And so what does that do? That solves this problem with the fact that in addition to passing off construction costs from Pump Station 10 to the improvement districts, they passed off design costs, et cetera, et cetera. We don't need to go through line item through line item. We've got a simple answer for it. The code provides it. Construction costs plus 20%. So 20% takes care of all of that. You do those two things and you've solved all of these legal infirmities. That's it. You follow the code. You say, by law, these things weren't supposed to be commingled. The costs of the pump station are the costs of the pump station. The costs of the improvement districts are the costs of the improvement districts. And then you take a look at the improvement district and you say, we're going to give you contract costs plus 20% for the overhead, and that's it. And if you do that, that solves a lot of issues, and it's going to bring that proportionality thing much closer to where it should be. So those lots where the value, according to the assessor, went up $44,000 from $36,000 to $80,000, and they're being assessed $150,000, when you do this, it's not going to be quite a 310% difference between the cost and the benefit conferred. It's going to be something that's much more proportional and will pass muster with the courts. And that's what we're asking you to do. And it's just following the code, it's following the law. And I want you to think of one more thing before I sit down. And that's that, what do you think would have happened if these two projects had been built separately? We all know. The pump station would have cost more, they would have paid more, because they clearly passed certain costs off to the improvement districts, and they didn't pick up any costs from the improvement district. They didn't pick up any cost of that road access. They didn't pick up any of the costs for the deep subdrain on the other side of this right-of-way. So they didn't pick up any costs. They passed costs off. So if these projects had been built separately, the pump station would have cost more. It would have cost it schedules A, B, and C, and the improvement districts would have cost less. And that's the way that you should look at it, because that's what the law says should have been done. They shouldn't have been commingled to begin with. They should have been kept separately. And so if you do that, if you deal with the Hitchens fairly and equally as the McLeods were dealt with, don't treat them differently, If you treat these two projects as two separate projects, and then you identify the difference between allocation of costs, which can be on an equal lot basis or a proportional size basis, or it can be split between the municipality and the homeowners. That's allocation. That's different than how much of it can you pass on at all before you allocate it. If you look at those things, you solve the legal infirmities, and you've done the right thing. I thank you for your time.
Okay, that concludes both the appellee and appellant's closing arguments. I have seen a couple members of the public walk in. Is there anybody who would like to testify before the hearing remand panel on this issue? Anyone at all? Seeing no one come forward, when will you have your briefs into this body?
I need to talk with Bob about that. I mean, this is an issue that I need to try and spend a little bit of time thinking about it. Can we get back to the body with an agreed upon time?
Okay, so in conference with the panel and special counsel, we would like the briefs no later than January 30th, 2015. However, we will go ahead and wait. Both the appellee and appellee are directed to contact special counsel Levesque no later than Friday at 5 p.m. of this week to indicate when those briefs will be in. And again, the council or the panel is recommending. We're recommending that those briefs be in by January 30th, 2015.
I have no objection to that date.
I'd like to confer with Bob, but we will get to the panel, and I understand you'd like them in by that date. So I will endeavor to reach an agreement with Bob to try and pick a date within that time frame, but it might be, close there too.
That would be fine. We just want to make sure it's been a wonderful experience listening to both sides. We appreciate both the effort. The witness testimony, the public testimony, it's been an education, no doubt, and we just appreciate a very good discussion. If we could have them by January 30th, I mean, that would be ideal because we can see the property owners and the municipality. I think everybody wants a resolution to this issue sooner rather than later. So with that,
One other observation. I assume council is going to be discussing with you. I believe we have a date scheduled for when this is supposed to be reheard, and it's been noticed. I know that we have sent notices out. We may need to, I assume you'll advise us on that.
We will. So what Mr. Owens is referring to is we have a specific schedule. Once this hearing remand panel has issued its findings of fact and conclusion of law, there will be an assembly work session in which the entire assembly is briefed on this topic. The item will come back before the assembly. The assessment rolls will all come before the assembly. They will be open for public testimony. And then after that public testimony is closed, the assembly will take action on essentially the findings of this panel and then the assessment. Is that accurate way to put it? We've announced publicly, and we've noticed when all these things are going to happen, and because we're shifting a little bit how things are being done, we'll probably have to adjust those dates. We will do so, and we'll make sure that the proper public notices are all sent out, and in those tax assessment rolls, they will all be noticed. And again, public testimony will be taken on those rolls. So if anybody here thinks about things and they want to come back and testify in front of the whole assembly on those tax assessment rolls, you're more than welcome to do so. Any questions or final comments from either party?
No, thank you.
Thank you again for your patience.
All right, we are adjourned.